Memos kudi. Adjournments. List 1. B group matters.
Number 17.
17 to 21.
Number 17. I'm incoming student.
It's a 2013 matter, Sudhindra. You're not getting prepared in the matters.
Instruction.
See, it's a 2013 matter, and I think interim order is operating against you.
No.
No, whatever it is. What is KSB doing from 2013?
That's not. Petition is up after 9.5 years. Yes, file the-
So you take 50 years to file a written objection statement, is it? Now, is it a ground for adjournment?
Tomorrow.
What type of submission is this? On date kodre, at the request of respondent number 2 and 3, finally call on. We are struggling to dispose of old matters and I am not getting cooperation from you people.
19.
Please.
No adjournment on that day.
Yes.
22 to 29.
My lord,
Please.
serial number 22, I appear for petitioner, my lord. As we are filing an application under section 38D, the party signature is needed as he is not well.
What application you are,
38D of the BDA Act, Varavana.
so why you require adjournment? You make a representation to the BDO over there, you withdraw the writ petition.
Kindly 3 days time, my lord.
Why 3 days? Why 3 days? Tell me, if you are making the application, if you are not pressing the writ petition, then why I should adjourn it? I'll dismiss it, reserving the liberty to approach.
Kindly grant 2 days
No,
time.
no,
my
I'll
lord.
do one thing.
Fine.
I'll call it in the afternoon, get instructions from your senior and make submission. We'll dispose it off today.
Kindly,
I'll
Varavana.
give you the liberty. If that is only the ground, I'll give you the liberty. 2:30 will call it. Pass over. 2:30 it will come, madam. Get instructions. ಅರ್ಥ ಆಯ್ತಾ ವಿನಾಕಾರಣ ಕೇಸ್ ಇಟ್ಕೊಳ್ಳೋದು ಬೇಡ ಬೋರ್ಡ್ ಮೇಲೆ.
On 2 days, my lord.
ಯಾತಕ್ಕಮ್ಮ 2 days ಬೇಕು? ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ನ ರೆಡಿ ಆಗಕ್ಕೆ ಅದು we can understand. Your submission is you are making an application to BDA to grant you a particular site. I'm going to give you that liberty. Even the BDA council will not be objecting to it. 2:30 you make your submission. Pass over.
Number 30 to 35. List 1.
Seal number 30, my lord.
Hmm.
Appearing for 2 to 4.
Hmm.
We filed a statement of objections, my lord. So personal inconvenience is there. Adike one week time may be granted, my lord.
Okay. At the request of respondent number 3 to 5,
2 to 4. 2 and 4, my lord.
2
3 side where either.
Okay.
Kindly have it on 30th, my
Have
lord.
you informed the other side?
I'll inform it, my lord.
It's a date given matter, madam. They will object to it.
No, my lord, I'll inform now itself.
If they object, if they come and say that our matter has to be taken, I will take it up.
Okay, my lord.
You do one thing, you mention it when it reaches.
Oh, great.
Because last time you took time, no?
No, my lord, we filed an objections that time.
Whatever, mention it when it reaches.
Oh.
No adjournment now. Let's
36 to 41.
Serial number 40, my lord. 40.
Hmm.
I'm for respondent number 2 and 3.
Hmm.
On last occasion, your lordship has directed to list this matter on 21st. By mistake, it was listed today. I informed the petitioner. It may be taken up on 21st.
The request of petitioner call on 21st.
I'm for respondent number 2 and 3.
At the request of respondent number 2 and 3. Call on 21st.
42, 43.
My lords, appearing for serial number 43, my lords, appearing for the petitioner in this matter. My lords, I pray for a week's time because I'll be filing an IA for amendment of cause title.
You for?
Petitioner, my lords.
Okay. At the request of petitioner call on date to
Please, my lords.
take a date of your choice. When do you want?
My lords, August 30th.
Huh?
30th, my lords.
Why so late?
Then it may be fixed on 23rd or 20th.
23rd.
23rd.
Deeply obliged.
44 to 48. 49 to 52. List 1, serial number 1. Karunakara P.
This is pertains to the complex matter, my lord, matters, my lords. That complex matters, my lords has disposed of 4 matters in a row. And earlier,
Who are these respondent number 3 and all?
they are the tenants, my lords, before the tenants in the complex. My lords, BDA is now constructing, my lord, PPP model in the premises, my lords. My lords has passed an order
What do you?
based upon this judgment, my lords.
Who is the petitioner?
Karnataka.
What are you there?
Healthcare,
Huh?
healthcare, healthcare innovation private limited petitioner.
ಏನ್ ನೀವು ಅಲ್ಲಿ BDA ಕಾಂಪ್ಲೆಕ್ಸ್ ಅಲ್ಲಿ? Who are you?
May not pass, sir.
Sorry, my lord. For the petitioner, my lord, who's a, who has been allotted shop number in the HSR BDA complex, my lord. Now notice has been issued to vacate the premises in the, on the guise of that, it will be developed by the, in a joint development with the M4 developers. But now notice has been issued to vacate the premises within 30 days from the notice. My lord, as per annexure C, my lord, there is a resolution by the BDA saying that
Why have you made others party to the proceedings over here?
please, my lord,
You are a tenant, no?
I'm a tenant.
Who are respondents, 2, 3, 4, who are there?
Only two respondents, my lord.
ಎಷ್ಟನೇದ್ರಿ serial number?
Sir, one, sir. Serial number 1. My lord, an order was passed in connected matters, my lord.
We'll dispose it of accordingly. Yes, bani. Petitioner is a tenant in one of the licensee, is a licensee in one of the ಎಲ್ಲಿ building up ಇದು?
HSR BDA layout, BDA complex.
Petitioner is a licensee in one of the
BDA complex.
of BDA complex situated at HSR layout. Full stop. On the ground that the term of licensee is over. Completed. Term of license is completed. And that BDA also intends to put up a new complex by demolishing the existing structure. Correct, Andre?
Yes, my lord.
BDA has issued a notice to the petitioner to vacate the property. Agreed by the full stop, agreed by the same. The present petition is filed. Next paragraph. During the course of the proceedings, both the counsel for BDA as well as the petitioner submit that this court in WP number 51630 of 2018 and other connected matters has considered the case of similarly situated persons and has disposed of the writ petitions by reserving the liberty to the petitioner to show cause to the notice and authorizing the BDA to initiate such proceedings required in accordance with law. And it is prayed that the present writ petition also be disposed of on similar lines. On similar terms. Full stop. Next para. Admittedly, the petitioners in the instant case are similarly located to that of the petitioner in WP number 51630 of 2018. And there is no reason why the order passed in the said writ petition. And there is no reason why similar order should not be passed in the instant writ petition. In the instant writ petition. Hence the following order. The writ petition is disposed of in terms of in terms of the order passed in WP number 51630 of 2018. ಈ ರೆಸ್ಪಿರೇಷನ್ ನಂಬರ್ ಒಂದು ಬರ್ಕೊಳ್ಳಿ ಈ ರೆಸ್ಪಿರೇಷನ್ ನಂಬರ್ ಒಂದು ಬರ್ಕೊಂಡ್ರೆ ಸಿಮಿಲರ್ ಮ್ಯಾಟರ್ಸ್ ಬರುತ್ತೆ. ತುಂಬಾ ಮ್ಯಾಟರ್ಸ್ ಇದೆ, ಎಲ್ಲಾನು ಇದೇ ತರ ಡಿಸ್ಪೋಸ್ ಮಾಡಿದ್ರೆ ಇದಲ್ರಿ ಇದು ಇವಾಗ ನಾನು ಡಿಕ್ಟೇಷನ್ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ ಇದೇ ತರ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರೆ ಆಯ್ತು ಅಷ್ಟ. ಅದೇ ತರ ಬರ್ಕೊಂತಾರೆ.
My lord,
ಈ
sir,
ನಂಬರ್ ಬರ್ಕೊಳ್ಳಿ.
20090 on the earlier date when my learned friend has appeared in that matter.
ಆಯ್ತು, ಇಟ್ಸ್ ಆಲ್ ರೈಟ್. ಇದು 20284 of 2024 ಇಷ್ಟು ಹೇಳಿದ್ರೆ ಸಾಕು. ಅದ್ರಲ್ಲೆಲ್ಲ ಡೀಟೇಲ್ ಆಗಿ ಏನೇನೋ ಹೇಳಿದೀವಿ, ಅದೆಲ್ಲ ಬೇಕಾಗಿಲ್ಲ. ಅದೇ ಅದೆಲ್ಲ ಏನ್ ಬೇಕಾಗಿಲ್ಲ.
Yes,
ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದಿಸ್ ರಿಟ್ ಪಿಟಿಷನ್ ಇದನ್ನು ಡಿಸ್ಪೋಸ್ ಮಾಡಿ ಅಂತ ಹೇಳೋದು ಅಷ್ಟ.
yes.
ಇದು ಅಷ್ಟ.
My name may be shown in the.
ನಿಮ್ದು ಸಚಿನ್ BS ಸಚಿನ್.
BS
ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗ್ಬೇಕಾ?
Notice has not been ordered.
BS Sachin for respondents. Order sheet.
Much of.
Mention it when it reaches, no?
But in mine, my lords, I have not asked for not to demolish or the prayers that they have made, my lord. I have said that as per the one, their agreement to. As per
Solid, mention it when it reaches.
Much of.
Lord, I appeal for petitioner in this case. My lord, the petitioner have made an application for a site on incentive basis as a land loser. My lord,
Yes,
Muda have
Muda.
given an endorsement.
ಮೂಡ
My lord, TP Vivekananda, GM Anand.
He is there. No?
GB Sharad
TP
Gaur.
ಶರತ್ ಗೌಡ.
You have to get instructions immediately.
Your lordship.
You have to get instructions immediately.
Okay.
On that condition. So and so accepts notice for respondents.
Same, my lord. Next serial number 3 is also same.
ಏನಿದು?
ನೆಕ್ಸ್ಟ್ ಇದೆ.
My lord, both the lands, my lord, both cases lands have been
But two-
acquired for nationally layout.
Hmm.
And they have given an endorsement, they have deposited the amount before the court and therefore they cannot give incentive sites. So that is the endorsement, my lord. That fact is covered by a judgment of this honorable court, which is at annex
Notice,
C.
so and so accepts notice for respondents. Call on. Date today.
ಎಷ್ಟು 19th.
19th, objections if any by then.
3
Same, my lord.
It
That
was
is
same,
also
my-
same.
Yes, ಇದು same ಮಾಡಿ.
1980. TP
But may I make one more submission, my lord? Serial number 38 to same ಏನೆ. ಬಟ್ ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ನೋಟಿಸ್ ಆಗೋಗಿತ್ತು, ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ನೋಟಿಸ್ ತಗೊಂಡ್ರು, ಮೂಡಾದವ್ರು ಯಾರು ವಕಾಲತ್ ಹಾಕಿಲ್ಲ ಟಿಲ್ ಡೇಟ್.
ಬಂದಾಗ ಮೆನ್ಷನ್ ಮಾಡಿ.
ಮಚ್
4
Lord,
J ಸಂತೋಷ್
till number
ಪ್ರಸಾದ್.
4 is concerned, my lord, have it on 21, my lord. The survey is conducted, my lord, report
So
should be.
VGA call on 21st. 21st.
21st.
Yes.
Oblige you all.
5
21.
number 5 ಅಂಗಡಿ ಸೋಮಶೇಖರ್ ಚನ್ನಬಸಪ್ಪ.
For the petitioner in this matter pertains to challenge to BDA acquisition for the petitioner's land. Matter pertains to challenge to the BDA acquisition petitioner's land in Vishweshwarya layout block 3. In this case, my lord,
Ready?
layout is formed, even allotment is done, excluding the portion in which the petitioner is in possession. To know the exact extent of possession of the petitioner, a joint inspection was ordered by this honorable court on 1/2/2021. They filed the joint inspection report along with a memo on 9/2/2021. There, my lord,
There is a report, kindly see the report, my lord, I filed it on 9/2/2021. My lord, the entire land, the land is acquired, my lord, the petitioner claiming 16 guntas of land, my lord. The petitioner father participated in the matter and acquisition is completed, my lord. Now the sites are formed and sites are allotted to third party, my lord. Kindly see the spot inspection measure because this honorable court directed to conduct the spot inspection. My lord, in that, kindly see the page, my lord, the map, I produced the one sketch, my lord, the layout plan. My lord. My lord, the site formed is the, my lord, survey number, entire survey number 131/3 of the. My lord, the bottom, my lord, there is a colored portion in the bottom, my lord.
Yes, yes.
That is the 16 guntas land claimed by the petitioner. My lord, the sites are formed. The detail of allotment, my lord, is produced the previous letter, my lord, page 1, page 2nd, in the report, the second page of the report, my lord. The sites are, we have allotted the sites, some corner sites are not allotted. Now, my lord, in the map, my lord, kindly see the map. He claims that he has constructed one house in the road portion, my lord. It is in the middle of the road. And after my lord, the filing this writ petition, he also filed the suit for injunction. Suit was dismissed and thereafter filed the RA. RA is pending their status quo order in the RA, my lord. That is pending. Thereafter filing the suit, my lord, there are, my lord, the two green portion, my lord, small green dots in. They have constructed a shed, my lord, in the cattle shed. After the sites are formed, he filing the writ petition, he constructed a shed. Now he is seeking for all these sites to give all this site handover to the petitioner. Wherever we allotted site, give the alternative site. My lord, it is acquired and acquisition was has attained finality.
When was the preliminary notification?
Preliminary notification was dated, my lord, 14/12/2001.
14/12/2001.
Final notification is at 31/10/2002. Award was passed on 30/10/2002, my lord.
Award?
Passed on 10/12/2002.
Idu possession taken?
2003, my lord, sorry. Award 10/10/2003.
Possession taken?
Possession was taken on 11/3/2020, 2003. 11/3/2003.
ಅವ್ರಿಗೇನ್ ಬೇರೆ ಇದು ಡೆವಲಪ್ಡ್ ಸೈಟ್ ಆ ಕಾನ್ಸೆಪ್ಟ್ ಇರ್ಲಿಲ್ವಾ?
ಇಲ್ಲ, ಅವ್ರದ್ದು 16 guntas, my lord. 16 guntas, they can make application for, my lord, incentive site if the BDA may consider for the.
ಜಮೀನಲ್ಲಿ ಏನಾದ್ರು ಕೊಡ್ರಿ ಅವ್ರಿಗೆ.
My lord, the sites are formed, my lord,
ಆಯ್ತು, ಅಲಾಟ್ಮೆಂಟ್ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಕೊಡಿ ಒಂಚೂರು, ಏನ್ ಕಳ್ಕಂತೀರಿ?
even prior to the preliminary notice.
ಅಲ್ಲಪ್ಪ, ನಿಮಗ್ ಪಾಲಿಸಿ ಇತ್ತೋ ಇಲ್ವೋ ಅವಾಗ ಡೆವಲಪ್ಮೆಂಟ್ ಕೊಡ್ಬೇಕಂತ ಅಂದ್ಬಿಟ್ಟು?
ಅಲ್ಲಿ ಇನ್ಸೆಂಟಿವ್ ಸೈಟ್ ಸ್ಕೀಮ್ ಇದೆ.
ಎಲ್ಲೇ?
BDA ಅಲ್ಲಿ ಇನ್ಸೆಂಟಿವ್ ಸೈಟ್ ಫಾರ್ ದ ಎಕ್ವಿಷನ್ ದೇ ಕ್ಯಾನ್ ಫಾರ್ ಎಕರೆಗೆ 40-60, ಬಿಲೋ 20 ಆದ್ರೆ 20-30 sites there is under the scheme.
ಅದೇ ಲೇಔಟ್ ಅಲ್ಲಿ ಕೊಡ್ತೀರಾ?
ಅದು ಅವೈಲಬಿಲಿಟಿ ಮೇಲೆ ಇವಾಗ ಬಿಕಾಸ್ ಮೇಲೆ
ಲೇಔಟ್ ಅಲ್ಲಿ
ಅಲ್ಲ, ಇದ್ರೆ ಅಲ್ಲೇ ಲೇಔಟ್ ಅಲ್ಲಿ ಕೊಡ್ತಾರೆ ಸ್ವಾಮಿ. ಇದು 2001 2003 ಅಲ್ಲಿ ಲೇಔಟ್
Compensation is not given.
ಈ ಫೈಲ್ 2020
ಕಾಂಪನ್ಸೇಷನ್ ಕೊಟ್ಟಿಲ್ವಂತ?
ಕಾಂಪನ್ಸೇಷನ್
ನೀವು ತಗೊಂಡಿಲ್ಲ ಅಷ್ಟೇ, ಕಾಂಪನ್ಸೇಷನ್ ಡಿಪಾಸಿಟ್ ಮಾಡಿದಾರೆ.
Kindly
See, council, listen. 2003, the acquisition is completed. You filed the writ petition in 2020. What to do?
and he
No, actually there is a
participated in
delay,
the
but they have
acquisition.
not taken that ground in the statement of objection.
ಆಯ್ತಪ್ಪ, ನಾವು ಸಂಪೂರ್ಣವಾಗಿ ಅನಲೈಸ್ ಮಾಡ್ಬೇಕಲ್ವಾ? ಇಟ್ ಇಸ್ ಸೋ ಈಸಿ ಟು ಥ್ರೋ ಔಟ್ ಯುವರ್ ರಿಟ್ ಪಿಟಿಷನ್.
He participated.
It is so easy for me to throw out your writ petition. Correct? ಏನೋ ನಿಮ್ಗೆ ಏನಾದ್ರು ಒಂದು ರಿಲೀಫ್ ಕೊಡ್ಸಕ್ಕಾಗತ್ತ? ವಿ ಆರ್ ಜಸ್ಟ್ ಎಕ್ಸ್ಪ್ಲೋರಿಂಗ್.
There is a settled.
At the end of the day, you are landlord. ಅಷ್ಟ.
My lord,
Question
petitioner
of
is-
setting aside does not arise, sir. It's an agricultural land that has been acquired.
Let them allot some sites to the petition.
His father filed the application Maharaj, seeking cash compensation of this land, annexure
Sites
urban,
may be allotted, my lord.
So your father asked for cash compensation.
cash
Yeah.
compensation.
You have filed it as late as,
Now, 18 years after the,
Mata?
but there is a settled possession in favor of the petitioner. my lord.
ಏನ್ settled for?
Kindly see para 4 of the
Application
station.
ಆದ್ಮೇಲೆ ಎಂತ settled possession?
Even prior to the date of preliminary notification, petitioner was in possession of the land.
ನೀವೇ ಪೊಸಿಷನ್ ಇರೋದು ನಿಮ್ ಲ್ಯಾಂಡ್ ಅದು ಬೇರೆಯವ್ರ ಪೊಸಿಷನ್ ಇರೋಕ್ ಹೆಂಗ್ ಸಾಧ್ಯ?
Like,
Land has been acquired from you.
excluding these 4 sites, which they have reported in the spot inspection, all the sites are allotted. These 5 sites are not allotted. That those sites may be allotted in favor of the petitioner, my lord. I'll make necessary application.
You make necessary application. ಒಂದು
Allah,
result ಮಾಡಿ.
they can make the application under incentive site scheme, Maharaj, not for this unallotted.
Do one thing, you take compensation that is deposited, you are bound to do it because your father had
That
sought.
sites may be allotted, my lord. Alternative sites may be allotted. If it is not possible there, somewhere else it may be given.
There should be some process of law, no?
No, even the possession notice is defective.
Then you argue on merits, then first of all, answer,
No, if they are,
answer the ground of delay and laches.
no, if they are acceptable to allotting alternative sites, I have no issue.
It's only incentive scheme what is available. In Krishna, our pocket in the ಕೊಡಕ್ಕಾಗಲ್ಲ, policy ಏನಿದೆ ಅದನ್ನ ಹೇಳ್ಬೇಕಷ್ಟ.
Possession notice ಅಲ್ಲಿ haphazard vague possession notice ಅದು.
ಆಯ್ತಪ್ಪ, first you have to answer on delay and laches, no?
Owner has not signed the possession notice. Even in the,
Answer on delay and laches, no, sir. How do you answer delay and laches?
there was a suit pending before the civil court. There was a status
Between
quo
whom?
against BDA.
So what? The suit is not a ground for setting aside acquisition. Show it. Show in law how this court can help you, it will help you, that's it.
Ground of equity, my lord.
That's no ground, sir. Anything else?
There is a settled possession in favor of the petitioner.
The lands of the petitioner have been acquired by way of a preliminary notification 4/12/2001. Dates.
14/12/2001.
14/12/2001. And final notification dated 31/10/2002. Correct, Anappa?
Yes, correct.
Full stop. Further, possession of the land have been taken on 11/3/2003.
Yes.
And award has been passed on 10/12/2003.
There is
Correct,
Yes, ma'am. 10/2/2003.
10/2,
10/2/2003. 10th February 2003.
Okay, 10/2/2003. Possession 11/3, na?
Position 11/3/2003.
my lord.
10/2/2003 ನಮ್ಮ. ಯಾವುದು award. Possession 11/3/2003.
2003.
Your lordship's own judgment is there
Yeah, no.
in this matter. It has to be done within a reasonable time. Acquisition is not done within a reasonable time.
It is a reasonable time, sir. 2001 preliminary notification.
There is one more judgment covering this kind of situation, my lord. A divisional bench judgment. Where an option was given to the petitioner to apply under section 38D of the BDA Act.
See, if you are eligible, you are eligible, sir. All those things will be reserved for you.
Liberty may be reserved.
ಆಯ್ತು. 2000 possession was taken on 2003. Full stop. When the lands were acquired, the father of the petitioner was alive and he was the owner of the property. He has not challenged the acquisition. He has accepted, he has made a representation to the BDA that he may be given
Cash compensation.
No, I have requested the BDA to withdraw the acquisition.
not you, sir, your father.
Father.
ಏನ್ ಬಂತು? Full stop. He has not challenged the acquisition. He has not challenged the acquisition. Full stop. Instead, he has requested for award of compensation. Compensation. It is submitted by the counsel for BDA that the compensation has been deposited before the,
No, it is in the revenue deposit, man.
why?
Because my lord, there is a stay in the, he filed the suit, injunction suit. Thereafter, my lord, it was in the RA, my lord, there is a status quo address.
RA was filed in the year 2012, my lord.
ಏನ್ ಬಂತಿದೆ? Has been deposited, has been deposited. Huh? Full stop. After the demise of the father of the petitioner, well, it is not yet withdrawn, it is not yet withdrawn. It is not yet withdrawn. Full stop. After the demise of the father of the petitioner, comma, the petitioner has challenged the acquisition in the year 2000, belatedly in the year 2020. Huh? Belatedly in the year 2020. Full stop. Next para. The inordinate delay of 18 years, of nearly 18 years in challenging the writ petition is not explained. Full stop. Huh? The writ petition is liable to be dismissed on the ground of delay and laches. Full stop. Further, comma, admittedly, the lands were agricultural in nature and they have been acquired by the BDA in accordance with law for formation of a layout. Huh? Full stop. The petitioner has failed to point out any infirmity in the acquisition proceedings. Full stop. Next para. For the aforementioned reasons, the writ petition is hereby dismissed. Full stop. However, dismissal of the writ petition will not come in the way of the petitioner withdrawing the compensation amount deposited or making a claim for higher compensation in the manner known to law, or even requesting the BDA to allot any incentive sites or ask for such other benefits as is permissible under in law. And if such a request is made, BDA is bound to consider the same in accordance with law. Yes. Six. Ravindran.
In this matter, my lords, I have to file a report, please, my lords. I will do it in due course. But in the meanwhile, if my lords may permit me, that's page number 69 and 70. please.
Arguments purti mugsodadre matadi idellare date ತಗೊಂಡು ಹೋಗಿ.
No, it was twice, it was parted, my lords. It was released when the change of. My lordship, may kindly see, it's already, see, they
If you want, I will post it day after tomorrow, you file your
Lords,
report.
in the meanwhile, may I only submit one aspect? Page number 16 and.
No, if you want adjournment, why do you want to make extra submission? I am granting you adjournment.
Please,
When do you want? Tell me. On that day, no further adjournment.
please, another 2 weeks, my lords, I will.
No 2 weeks, sir. Sorry.
I'll have to get the report, my lords. I've informed them. I'll get
How much? Corporation in the report ತರ್ಸಕ್ಕೆ ಅರ್ಧ ಗಂಟೆಲಿ ತರಿಸಬಹುದು.
1 week. May I request, my lords, 1 week.
26, my lordship, may kindly have it. It won't be in station. 26.
See, he has been so gracious enough.
My lords,
I was thinking of having it on 9 days. Now he is
I am not.
asking, at the request of respondent number 2 to 4, colon
26.
26 holiday.
26 holiday. Okay, 27th.
27.
Apply.
7, Vasant Kumar HT, Gautam
He
Dev.
got what he wanted. You only gave him on a platter.
No, this is a site value fixation matter. The BDA was directed to file an affidavit. Our
You are-
information is that the site was formed, identified in the year 2009, which is prior to 2010.
Yes,
My lord, we need a passover to file the affidavit.
pass over.
Would my lord consider having it tomorrow? There are some personal inconvenience.
Personal inconvenience. ನಾಳೆ ಆಗ್ಬೋದಾ?
Yes.
ಆಯ್ತು.
I'm obliged.
At the request of parties called ನಾಳೆ ಕೊಡಿ date.
Serial number 34 and 42, the same issues involved in those matters also. Those matters also taken up tomorrow, my lord.
ನಾಡದ್ದು ಹಾಕ್ಬಿಡ್ತೀನಿ ಶಂಕರ್.
ಹಾ.
ನಾಡದ್ದು ಹಾಕ್ತೀನಿ. Day after tomorrow.
14.
ಹಾ? ಆಯ್ತು ಇದು ಸಬನನು ನಾಡದ್ದು ಹಾಕಿ ಮತ್ತೆ ಯಾವ್ದು?
Serial number 34 and 42, my lord.
35 to
32 and 42. Both are.
2 and 42.
Yes, ma'am. 32, 44. Yeah. Same
ಅಲ್ಲಪ್ಪ
meaning.
32, 42.
34 and 42.
34 and 42 ನಾ 42 ನಾಡದ್ದು ಹಾಕಿ.
Yeah, same issues involved, ma'am.
34 ನಾಡದ್ದು ಹಾಕಿ.
Much of it.
34 and 42.
Yes. Number 8. Sundaresh HC, Devendrappa.
Correspondent 1 and 2, my lord.
ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ಲಾ? ಪಾಸ್ವರ್ಡ್ ಅಲ್ಲ R3 ಗೆ ಸರ್ವಿಸ್ ನೋಟಿಸ್ ಹಾಕ್ಬೇಕು.
Awaiting.
Yes, post the matter after service of notice to respond number 3. Yes.
9, Nagesh.
Petitioners, 1 week time objection.
1 week to do the next.
Copy served. KDB.
ಆಯ್ತು.
Take receipts.
2 matters.
ಇದನ್ನು ಅಷ್ಟೇನಾ? 1 week.
House.
ಏನು ಅಬ್ಸರ್ವೇಷನ್ ನಿನ್ನ?
ತುಂಬಾ ಇದೆ ಸರ್. 9 objection ಇದೆ, 7.
ತುಂಬಾ ಇದೆ ಅಂತ.
Awesome.
ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ ಪರಮೇಶ್.
House.
9 and 10. 1 week to do the needful.
11, R. Kempegowda. PV Chandrasekhar, K. Krishna.
The award passed by the KADB under the 1894 Act. Prayer made is that we are entitled for compensation under the 2013 Act. And the division bench of this honorable court has confirmed the order of the single.
ರೆಡಿ ಚಂದ್ರಶೇಖರ್?
ಅದೇ ತಾವು ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ದೀರಿ ಸಬ್ಜೆಕ್ಟ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ 812/2019 WP ನಲ್ಲಿ ಸಿಮಿಲರ್ ಟರ್ಮ್ಸ್ ಅಲ್ಲಿ ಮಾಡಬಹುದು ಅಂತ ನಾನು ಹೇಳ್ತೇನೆ ಸಾಹೇಬ್ ಹೇಳ್ತೇನೆ.
ನೋಡಿದಿರಾ ಜಜ್ಮೆಂಟ್? ನೋಡಿದಿರಾ ಸರ್ ಅದು?
ನಾನು ನೋಡಿದ್ದೀನಿ ನಾನು. My lords may pass the order. Only thing is, my lords, whatever amount they have deposited here, that I may be permitted to withdraw.
That should not be a problem. ಅದೆಲ್ಲಿದೆ ಜಜ್ಮೆಂಟ್ ಇದೆಯಾ?
ಅಲ್ಲ ಇದ್ರ ಮೇಲೆ ತಾವು ಮಾಡಿದ್ರೆ
ಅಲ್ಲ ನನ್ ಜಜ್ಮೆಂಟ್ ಇದೆಯಾ?
ಅದು ಕಾಪಿ ನಂಬರ್ ಇದೆ 812/2019 ಅಂತ.
812.
Of 2019, 4/7/2024.
4/7/24.
ರಿಲೀಸ್ ಆಗೇ ಇರೋದು.
ಆಗಿದೆ.
ಒಂಚೂರು ತೆಗೀರಿ.
ಇಲ್ಲೇ ಒಂದು ತೆಗೀರಿ.
812 of 2019.
ಒಂದು 4-5 ಮ್ಯಾಟರ್ ಮಾಡಿರೋ ರಾಧಾನಂದ
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ
And they are not to pass a fresh award under the 2013 Act and pay the amount without deducting the TDS. Because TDS they have.
Agriculture land ಬರಲ್ಲ ಅಂತ.
That TDS ಬರುದಿಲ್ಲ for under 2013 Act itself there is a provision.
ಬರಲ್ಲ.
ಅಬ್ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ
ಅಗ್ರಿಕಲ್ಚರ್ ಲ್ಯಾಂಡ್ ಬರಲ್ಲ.
ಬರಲ್ಲ.
ಅವರು ಎಲ್ಲಾ ಡೈರೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಕಡೆಗೆ ಏನು ಅಂತಂದ್ರೆ ವೇರ್ ವಿ ಆರ್ ಎಂಟೈಟಲ್ಡ್ ಫಾರ್ 200 ರೂಪಾಯಿ, ಒಂದು 20 ರೂಪಾಯಿ ಕೊಟ್ಬಿಟ್ಟು ಇಷ್ಟ ಇದ್ರೆ ತಗೊಳ್ಳಿ, ಕಷ್ಟ ಇದ್ರೆ ಬಿಡಿ ಅಂತ ಹೇಳಿದ್ರು.
ಅಷ್ಟೊಂದು ಡೈರೆಕ್ಟ್ ಮಾಡಲ್ಲ ಸರ್.
ಅಲ್ಲ, ಫಸ್ಟ್ ಆಫ್ ಆಲ್ 1894 ಆಕ್ಟ್ ಅಲ್ಲಿ ಮಾಡೋದು. ಅದರಲ್ಲೇ 2000 gets reduced, 200 gets reduced to 80 rupees. ಅದರಲ್ಲೇ TDS. ಅದರಲ್ಲಿ ಇನ್ನೊಂದು ಯಾರನ್ನು ಗೋಕರ್ಣ ಅನ್ನೋರ್ನ ಕಂಡು ಹಿಡಿದು ಅವ್ರಿಗೊಂದಷ್ಟು ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ ಅವರು.
812 of 2019 WP.
ಡೆವಲಪರ್ ಅಲ್ಲ ಸರ್ ಅದಕ್ಕೆ.
Except asking the advocate also to be confiscated, ಎಲ್ಲ confiscated. ಏನೋ ಪಾಪ ಅಡ್ವೊಕೇಟ್ಸ್ ಆಕ್ಟ್ ಅಂತ ಬಿಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಸಿಮಿಲರ್ ಟರ್ಮ್ಸ್ ಅಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಮಾಡಬಹುದು.
Award date in, sir?
Awards dated 20, not this BW 43.
Yeah.
Awards are
Huh?
dated 11/9/2018.
11/9/2018,
18.
Preliminary notification,
Preliminary notification is dated
8th October 2015.
sorry,
8/10.
22nd September 2015.
22nd?
September, 21st/22nd September 2015. Declaration is dated 22nd February 2018.
ಇದು ಯಾವಾಗ ಬಂತು ಫೋರ್ಸ್ಗೆ?
This act came into force on 1/1/2013.
14.
11?
14.
14.
14.
And the preliminary notification itself says that compensation will be paid under the 2013 Act.
Whatever it is, sir, my personal view is that once this act comes into force, it's applicable across the spectrum, irrespective of whether
In fact, they have fairly stated in the preliminary notification
no,
itself.
no, no. See, the philosophy is whether state acquires it or an agency or instrumentality of the state acquires it. Whichever enactment it is acquired. See, the procedure may be different. The authority may be different, but at the end of the day, it is acquiring the land.
Compensation has to be paid.
Compensation has to be just, fair and reasonable.
New
What
act.
is just, fair and reasonable is determined by this act.
Yes.
You cannot say just because government acquires the land, the new act will prevail because some agency or an instrumentality of the state acquires the land, old act will prevail. See, I don't subscribe to that view. That is my personal philosophy. Well, it is subject to the decision of the Supreme Court. Bane.
ತಮ್ಮದೇ ಆರ್ಡರ್ ಇದು. Subject.
ಇದೇ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಬೇಡ ಸರ್. ನೋಡಿದಿರಲ್ಲ ಇದು?
ನೋಡಿದ್ವಿ.
ಇದೇ ಆರ್ಡರ್ ಪಾಸ್ ಡಿಟ್ಟೋ. ಇದು BMRC ಅಲ್ಲಲ್ಲ?
ಹೌದೌದು.
ಸರ್ವೆ ನಂಬರ್ಸ್ ಎಲ್ಲ ಅದೇನೆ.
ಸೇಮ್.
ಸೇಮ್.
ಸೇಮ್ ಆರ್ಡರ್.
Disposal of all pending AD.
All.
12, Rambat K.
Lords may add one sentence, my lords, because they have deposited certain amounts here. That I may be permitted to withdraw. That is not that.
ಅದರಲ್ಲಿ ಹೇಳಿಲ್ವಾ?
ಹ?
ಅದರಲ್ಲಿ ಹೇಳಿಲ್ವಾ?
ಇಲ್ಲ, ಇಲ್ಲಿ ಡಿಪಾಸಿಟ್ ಮಾಡಿದ್ದೀರ. Wherever it is, either before. ಮಾಡಿದಾರ? Okay. In the reference court, wherever it is, I am permitted to.
ಇದೇ ತರ ಆರ್ಡರ್. Yes.
12, Rambat K. K Krishna.
2, 3 and.
Number 12, list 1, 12. K Rambat.
Pass out ಮಾಡಲ್ಲ, adjourn ಮಾಡಲ್ಲ.
Matter, Supreme Court ಅಲ್ಲಿ ಇದೆ similar matter, it may be adjourned.
Okay, then appears to the petitioner. Call after 4 weeks.
13, 14.
Date given, Allah Krishna, why was date given?
At the request of petitioners. Finally, Kala, 12/8.
So last time, petitioner, my lord, they are claiming as they are the allottees under the Ashraya scheme ಅಂತ ಹೇಳಿ. But ಒಂದು even allotment letter ಹಾಕಿಲ್ಲ.
No, sir.
13, 14 person, Ajay.
I'm awaiting instructions.
Your Honor, this is a 20-year-old matter. Each time they take a date like this and they don't file.
This is
any
the first time it's
objections.
coming up after notice, my lord.
Your Honor, this matter has arisen because they have not followed your orders.
You want one date.
The fresh matter on the last occasion. Notice.
When do you want? That day, no adjournment. Don't make him run from pillar to
Your Honor,
post.
if next week
because-
it is possible, because after that I'm
I
traveling.
shall file my objection 2 weeks. 2 weeks. Up 2 weeks, I shall file my objection.
So when do you want, tell me?
In any day, my lord.
ಯಾವಾಗ ಬೇಕು ಕೇಳ್ರಿ, ಅವ್ರಿಗೂ ಮ್ಯೂಚುವಲಿ ಕನ್ವೀನಿಯಂಟ್ ಡೇಟ್ ತಗೊಳ್ಳಿ. Person.
19.
Is it okay on 19th? Okay, at the request of respondent. Finally call on 19th, that day no adjournment. Yes.
14, SV Giri Kumar.
Yeah, for petitioner, my lord, I have received the objections recently. I'll file my rejoinder 2 weeks time.
This is a land acquired for aligning the national highway, my lords. The sketches have been placed. Earlier, there is a black spot, regularly accidents used to take place. So based on that, there is a report which was submitted with the police. Based on that, according to national highway standard, already work has been started from both ends. In between his property is there. There is no ground to reason. He is entitled for a compensation. There is no other way where court can say that land should not be taken for the construction. Kindly look at the drawing, sketch for a minute, my lords. If that survives, kindly.
My lord,
Look
my
at-
submission is
No.
this, my lord. I will file my rejoinder, my lord.
Just for the sake of.
The other thing, my lord, I was not heard in the proceedings at all.
ಅಲ್ಲ ಎಲ್ಲ ರಸ್ತೆ ಆಗೋಗಿದೆ ಅದು
I was
area
not-
ಮಾತ್ರ ಇಲ್ಲ.
I was
Kindly
heard-
turn the page, my lords. The drawing is there. It is there. It is there in that drawing.
Page number 36, my
Page number 36, my lords.
36. Annexer 4, R34.
In this manner, there are two.
The black spot, my lord, based on accidental, my lord.
36, respondent.
Those are the sketches. Yes, my lords. Your lordship. If it is turned, there are 4 sketches, my lords.
This is
First-
130, page number.
130 is mine, man. They filed their.
Sorry, it is
in
a
their
statement of.
objection.
Annexure,
It is statement of objections.
Statement of objections.
Yes, statement.
annexure.
Another I will pass on, my lords. Kindly I will pass it on. Sir, I can pass it on for immediate reference.
Respondent 3 filed
Put up
objection.
ಆಗ್ಬೇಕು. ಇನ್ನ they filed it on.
Respondent 3 filed is there.
I Giri words. We'll call it next week.
No, just for the sake of looking at it, otherwise I am not going to say that today itself matter has to be taken up. That is, kindly see, my lords, there are 2 marks,
Yeah, I got
right, if it is legend is seen.
Black and
The
red.
red one, what is shown, is already your work has been commenced. In between that, this property is there, my lords.
My lord, sir.
And now the work has been awarded. They are carrying on the work.
All pending here is.
My lords may see the
Oh,
linear method.
you know what is his contention?
Yes.
See, you are telling this is the accident.
Correct.
Okay. What he says, instead of taking the road like this, why couldn't you take the road like this?
My lords, the asset,
At the end of the day,
Huh.
see, at the end of the day, see, the road goes like this only.
no, that is what we are correcting directly.
What he says, see, the road comes like this.
No, not that road, my lords.
That not.
That is not the one where we have shown the red mark numbers. From there is
That one-
a kilometer 412 plus 480. Commencer from there and kilometer 413. This is the alignment, my lords. Not this road, which is going on right side.
You come to page number 136 of his writ petition.
136. 136.
132, please.
ಇಲ್ಲ ಸರ್ ಅದು ಕಾಣ್ಕೊಂಡು
132.
34.
133 and 34.
ಆಯ್ತು ಫಸ್ಟ್ 136 ಬನ್ನಿ.
136 is not there in my page. No. Sorry.
ಅವ್ರನ್ನ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರು.
It was that.
ಫಸ್ಟ್ 130ಗೆ ಬನ್ನಿ. 130ಗೆ ಬನ್ನಿ.
Yes, ma'am.
130ಗೆ ಬಂದ್ರೆ ನೀವು ಇದು ಎಲ್ಲಿ ಸರ್ಕಲ್ ಹಾಕಿದಿರಲ್ಲ.
Yes, ma'am.
ವಿಚ್ ಇಸ್ ಕಾಸಿಂಗ್
ಅಲ್ಲಿಂದ ಮುಂದಕ್ಕೆ ಹೋಗ್ಬೇಕಾಗಿತ್ತು. Straight road.
ಆಕ್ಸಿಡೆಂಟ್. ಅಲ್ಲಿಂದ ಮುಂದಕ್ಕೆ ಸ್ಟ್ರೈಟ್
Straight, very straight.
That is it.
That round is the block spot.
Correct.
ಕರೆಕ್ಟ್. ರೌಂಡ್ ಇಸ್ ದ ಬ್ಲಾಕ್ ಸ್ಪಾಟ್. ಯಾಕೆ ಅದು ಅಲ್ಲಿ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತದೆ ಅಂದ್ರೆ ಬಿಕಾಸ್ ದೇರ್ ಇಸ್
That is the proposed by the petitioner, that round.
ರೈಟ್ ಟರ್ನ್ ಬರುತ್ತೆ.
Earlier it was going like this, my lords. Now gradation has been made according to Indian National Road Congress standards to avoid much difficulty
My
for
lord,
the
the
vehicle
notification
movement.
itself
One.
is for extension. Notification is for extension, my lord.
Secondly, my lord,
Not acquiring
as far as-
plans, my lord.
as far as alignment is concerned, it's based on the technical parameters which requires to be adhered to accordingly. Earlier, it was constructed very 100 or so many years back. So now it is.
ನೋಡಿ ನೀವು ರಿಸೈಂಡರ್ ಹಾಕಿದ್ರೆ
Yes.
Yes, please.
ಬಿಕಾಸ್ ಏನ್ ಗೊತ್ತಾಗಿರಿ ಅಟ್ ದ ಎಂಡ್ ಆಫ್ ದ ಡೇ
I understand, my lord.
ವಿ ಕಾಂಟ್ ಸಬ್ಸ್ಟಿಟ್ಯೂಟ್ ಅವರ್
And I understand, ma'am,
And
but the notification
The
itself
Honorable
is.
Supreme Court said, my lords, the national highway project cannot be stopped because two aspects are there.
ಐ ನೋ ದ ಲಾ.
One, second thing is, my lords, as far as he is concerned,
I myself have said no
Yes.
question of interference.
that's one.
No question of interference.
As far as he is concerned, whatever the compensation according to law, that will be paid. There is no.
There, madam,
this
that
thing.
is my property, they have to pay.
That will
The
be paid.
the grievance is, my lord, they have not followed the methods which is required under PWD guidelines. They have to go, and the notification is for extension of the road, widening of the road.
19th they will call it.
Yes, 19th.
29th, please, ma'am.
No, not such a long term. 19th.
19th, obligation.
The
That day, it
request
will be for
the
final
request-
disposal. ma'am.
Request of petitioner call on 19th.
Great.
Obligation.
15, Srinivas Rao, BN.
Only legal issues, Ashta. Technical
Yes, yes,
issues we won't.
And madam, as
And
far as
noti-
alignment is concerned, Lordship, sir,
See, technical issues, we are not going to.
That's the
going
only
into it. See, it's not for us to say what is right, what is wrong.
and it is not a new stretch, my lords, existing, which
My
is
lord, it
getting
is
aligned with it.
notification issued only for extension.
Legal issues ಇದೆಯಾ ನೋಡಿ ಅಪ್ಪ.
Legally, ma'am, the notification is only for extension,
ಆಯ್ತು, whatever it is.
widening.
ಆಯ್ತು, let's see.
Yes, yes.
Obligation.
15, Srinivas Rao, BN.
ಪಾರ್ಟಿ ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ವಿ. ಪಾರ್ಟಿ ಮಾಡಿದ್ದೀನಿ ಮಾಡ್ಲಾಡ್. Petitioners are my siblings and externals as per the office note party ಮಾಡಿದ್ದೀನಿ. Should be allowed.
ಒಂದು ನಿಮಿಷ ಸರ್.
They are your siblings, huh?
Yes, my lord.
Siblings and?
And respondents are the beneficiaries of the land.
ಏನಪ್ಪ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ? ಕೊಡಿಲ್. ಅಡ್ರೆಸ್ ಎಲ್ಲ ಹಾಕ್ಬೇಕಲ್ರಿ, ಈ ತರ ಮಾಡಿದ್ರೆ ಹೆಂಗಪ್ಪ? ಕಳ್ಸೋದು ನಾನು.
ಅಲ್ಲ ಎಲ್ಲ ಗೌರ್ಮೆಂಟ್ ತಗೋತಾರ. ಫಿನಾನ್ಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎಲ್ಲ ಗೌರ್ಮೆಂಟ್ ತಗೋತಾರೆ, ಪೊಲೀಸ್ ಗೌರ್ಮೆಂಟ್ ತಗೋತಾರೆ. ಎಲ್ಲ ಅವರೆಲ್ಲ ಗೌರ್ಮೆಂಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ಸ್ ಇರೋದು. ಎಕ್ಸೆಪ್ಟ್ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್. ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ಗೆ ನಾನು ಪ್ಯಾನಲ್ ಕೌನ್ಸಿಲ್ ಸರ್.
ಕೋ ಪಿಟಿಷನರ್ಸ್.
ಕೋ ಪಿಟಿಷನರ್ಸ್ ಅವರೆಲ್ಲ ನಮ್ಮ ಜೊತೆಗೆ ಇದ್ದಾರೆ.
ಆಯ್ತು, ಅವ್ರ ಅಡ್ರೆಸ್ ಹಾಕ್ಬೇಕಲ್ವಾ?
ಸೇಮ್ ಒಂದೇ ಮನೆ ಇರೋದು, ಪಕ್ಕದ ಮನೆ ಇರೋದು, ಗುಳ್ಳಮಂದ್ ಬೀದಿಯಲ್ಲಿ.
Put their address. I'll call day after tomorrow. Make a proper application.
I will undertake to file wakalat, your lordship, for them.
ನಮ್ಗೆ
I may be permitted to file wakalat.
Whatever it is,
Yes,
proper
yes.
address ಕೊಡ್ಬೇಕು ನೀವು.
ಓಕೆ
ಗೊತ್ತಾಯ್ತಾ?
ಸರಿ.
Proper address ಕೊಡ್ಬೇಕು. At the request of petitioner, call day after tomorrow date.
16, KR Lingaraju, GB Sharath Gowda.
Instructions ಬರ್ಬೇಕು 19th
On the basis of the petitioner, call next week.
17, Ajjan.
18th, Bharat Kumar V. G. Lakshmesh Rao. S. Raju. R. Krishnamurthy. Naya. 18 ನಮ್ದೆ.
ಸೆಕೆಂಡ್ ಪಿಟಿಷನ್ ಅಲ್ಲ ಗೋಯಿಂಗ್ ಟು ವಿಡ್ರಾ ದಿ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲ ಮೆಮೊ ಸೈನ್ ಆಗಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ 10 days ಟೈಮ್ ಬೇಕು ಸೈನ್ ಕಳಿಸಿದ್ದು
19 ಕರಿತೀನಿ ಹಾಕಿ 19th
ಇಲ್ಲ ಆಫ್ಟರ್ 20th ಅಲ್ಲ
21st the request of petitioner call on 21st
18.1 ನಲ್ಲಿ Yeah, Krishnamurthy, advocate for R4, R5, R7, R8. Being mistake, my lords, I'll just write it in.
Krishnamurthy agida. How must to show the name of
SHNA.
So and so as the advocate appearing for R4, 5, 7 and 8, 18.1 ಅಲ್ಲಿ. ಹೆಸರು ತಪ್ಪಾಗಿದೆ.
SHNA. 19, Anusha L. Vikram Balaji. K. Krishna.
This is a case where last week I took time. Stay of disposition amounts to the stay of further proceeding. I got the list of authorities. There are 3 questions. After I went through it, the original records are required.
Ready na Krishna?
Yes, the original records are required. If original records are there, you will ask me have it at 2:30, I will ask.
Original records ಇದೆಯಾ?
Original records are there.
ಇದಲ್ಲ? 2:30. Possible.
20. Number 20, Subhash Shastri N. HL Pradeep Kumar. Number 20, Subhash Shastri.
Lordship sir directed us to file an affidavit on 4/1/2024. In compliance, Lord, Lordship filed affidavit and also served copy on them. Last time they complained that it is not served on them, it is served also.
Password ಮಾಡ್ಲಾ?
19th.
ಏನಿಲ್ಲ ಇದರಲ್ಲಿ ಒಂದೇ ಕಂಟೆನ್ಷನ್ ಅಂದ್ರೆ Lord, the Lordship's direction was to file an affidavit as to explaining as to why only 350 acres are acquired out of 1,100 acres that were notified in the preliminary notification. My Lord, we have filed the affidavit explaining that though preliminary notification had been issued for 1,100 acres, government approved the scheme only in respect of 400 acres. That is how, my Lord, we had to restrict the, my Lord, extent of land. We could not have implemented this scheme, my Lord, without sanction from the government. So, my Lord, sanction was for 350 acres. That is what we have, my Lord, stated. And the other thing is that, my Lord, there are some 5 survey numbers involved in the writ petition. Out of, my Lord, these 5 survey numbers, only one land is, my Lord, converted for non-agricultural purposes in the year 2008. But it was not, my Lord, utilized for the purpose for which it was granted, my Lord. The validity of the conversion order was only, my Lord, 2 years. And it had lapsed, my Lord, and it makes, my Lord, part of the compact area. It's part of the compact area, hence could not have, my Lord, given up, the board could not have given it up, my Lord. That is
Password ಮಾಡ್ಲಾ? ಅರ್ಜೆಂಟ್ ಮಾಡ್ಲಾ ಸರ್?
ಬರ್ತಾರೆ ಇಲ್ಲಿ ಗೊತ್ತು.
19th. Next week. Matters ಇದ್ರೆ we'll pass it over ನಿಮ್ದು. ನೀವು ಬೇರೆ matters ಇದ್ರೆ ನಿಮ್ದು.
ಆಯ್ತು.
Password.
21, Vijay Krishna Bhatt. Murgesh Vicharan.
We filing the NOC Wakala. We've received the papers today. Maybe taken up next week.
The request of petitioner call on date put it next week.
21. 21/8. 21/8. Number 22.
Password. Serial number 22. See, your colleague came and asked for it, asked for time on the ground that you'll be making an application.
Please, my lords.
If you are making that application, I'll reserve you the liberty and dismiss the writ petition.
No, my lords, in fact, in the present petition also, there were other relief that we had sought, my lords. They want to have an amendment application in the very same.
No, see, I'll tell you what, if that is the submission made, see, if you are not contesting the writ petition, If you only want to make that application, I'll reserve you the liberty.
My lords, I need to secure from party also, my lord.
What do you need to secure?
My lords, he on his
Tell
instruction.
me
my
what
lord-
is preliminary notice? When was preliminary notification? Tell me.
My lords,
You just tell me, madam, when was the preliminary notification? Krishna, yavaga
Preliminary notification 14/12/2001.
14/12?
2001.
Final notification?
31/10/2002.
31/10/2002.
Award is, my lord, the 10/2/2003, my lord.
Possession?
Possession was 4/3/2003. 16/2, my lord, on 20th December 2003.
16/2 yavaga?
20th December 2003.
Red petition no kodi?
Award deposited on 22/3/2004.
2014. Petition on 14.
My lord, they are in the writ petition, my lord, seeking the quashing of the annexure F, my lord. The endorsement of the BDA, they have made the application seeking for alternative site, my lord. That application was rejected since they have not made it is only a GPA and it is unregistered GPA. On the base of the Jinjama judgment, my lord, case, it was considered, and since it is unregistered GPA, his request was rejected. That was questioned in this writ petition.
If the petitioner comes and asks for it, you are willing to consider it.
In 38DL, 38DL, if there should be construction, by site ಗೆ ಬರೋದಿಲ್ಲ 38D, if there is a construction prior to 2008, then it will be considered.
I'd let them file them, what they want. The request of petitioner call on 20th.
Grateful, my lords.
23, HN Basuraj.
Sachin
BS.
My lords, this is the case pertains to my lords. On the other day, I have proposed one 38D, my lords. The petitioners are seeking a reconveyance of land under section 38C of the BDA Act. Now I have proposed them under section 38D. They have taken time to seek instructions, my lords, in this matter.
Lord, the client is not feeling well. We are now contacted, but couldn't.
20ನೇ ತಾರೀಕು 20. No further agenda. The request of petitioner call on 20th.
20th. Number 24, Manivandan G, HL Pradeep Kumar.
Day after
tomorrow.
ಏನಪ್ಪ ಇದು? What is this about?
Lord, we challenge the acquisition proceedings
Notification of acquisition.
on the ground that, my lord, the conversion order has been issued. My lord, the subsequent issuance of preliminary notification conversion order has been issued. My lord, moreover, my lord, there is no bar to the state to, my lord, acquire, my lord, the converted land. Even, my lord, the converted land can be acquired. That is the. Here is the case, my lord.
Day after tomorrow.
Why?
Because of some negotiations going on, because of they are already,
Lord,
government issued
we have-
50-50.
We have advised
but-
them to take 50-50 land sharing land, my lord, developed lands. They want, my lord, they can ask for, my lord, 50-50. Earlier it was 40-60.
If you want land, I will order that.
ಅಲ್ಲ ಮಾತಾಡ್ತೀವಿ
ಮಾತಾಡೋದೇನು ಪ್ರೈವೇಟ್ ಪಾರ್ಟಿ ಕಟ್ಟೋಯ್ತಾ ಅವರು ಏರಿಳಿತ ಮಾಡಕ್ಕೆ
ಪಾಸ್
ಪಾಸ್ ಕ್ಲೋಸ್ ಇಟ್. See, they have a policy. You either go with the policy or not. It's as simple as that. There's no scope for negotiations over here. You are offering them 50% developed land, huh?
ಹೌದು,
Huh?
50%.
notification is done, notification is there. Government also notification.
Then what else you require?
Can pass or.
ಪಾಸ್ ಓವರ್ ಬನ್ನಿ. ಈಗಲೇ ತಗೊಂತೀನಿ 2:30 ಮುಂಚೆನೆ. ಗೊತ್ತಾಯ್ತಾ?
25, Kirti A. Elegar.
This is a matter which has been remanded by the Supreme Court.
Ready, madam?
Acquisition under the slum clearance board minutes.
Record time.
Why?
Instruction.
What instructions? It's 2015 matter, madam. Why should we grant you time?
Please 1 week.
This is regarding the compensation under the slum clearance board. 300 times, my lord, of the tax payable on the property would be the compensation. This court said the compensation can only be under the Land Acquisition Act. The matter went to the Supreme Court. Supreme Court said, without a pleading, without challenging the constitutional validity, the orders have been passed that was struck down, and the matter is remitted back with a direction that we should amend, my lord, the pleading, which we have done. The other side took time to file the counter on the last hearing. That's the position. Your lordship may hear any time, my lords.
ಯಾವಾಗ ಬೇಕು ಮೇಡಮ್ ಅವತ್ತು ಫರ್ದರ್ ಟೈಮ್ ಕೊಡಲ್ಲ.
1 week,
Take a date, but that day no further time will be granted. When do you want?
please 1 week, my.
20ನೇ ತಾರೀಕು 20 ಆಗುತ್ತೆ ಸರ್. The request of respondent finally call on 20th.
26, Sanket M. Menegi.
May it please your lordships, I appear for the petitioner in this matter.
Hmm.
On the previous day, your lordships have heard the matter in part, wherein your lordships were of the opinion that the award has been passed and the possession has been already taken over by way of drawing of a measure in as much as the 16-2 notification. Lord, insofar as these documents are concerned, which I seriously dispute though, there is a coordinate bench judgment of this honorable court which may, pertaining to the same notification, be looked into. May I place that judgment on record, my lord?
Yes.
Similar contentions were raised. That is also pertaining to the notification in respect of Banishankari 5th stage. This honorable court had the reason to refer to the other division bench judgment of this honorable.
Yes. Ready for hearing.
Yeah.
Put it.
May I take your lordships to that judgment? The first one is WP number 32605 of 2018. This is decided on 24th of February 2020. Straight away invite your lordship's attention to paragraph number 1, wherein there is a reference to the notification. In as much as section 27, in as much as section 24(2) of the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act. They have given up their prayer in so far as that new act is concerned, but they have limited their prayer only to the extent of 27 at paragraph number 2. Paragraph number 3 is quite relevant, my lord, for the case on hand. May I read, my lord, the relevant portion? The learned counsel for the petitioner submits that, in fact, the issue stands covered by more than one decision of this court, including the case of so and so, which was disposed of on 2nd February 2016 with respect to the very same notification and with respect to the very same village in which the properties belong to the petitioners are situated, that is Uttaradi village, Uttaradi Hobli, Bengaluru South Taluk. The learned counsel submits that in the case of so and so, this court, having secured original records from the respondents, noticed that initially what was notified in the preliminary notification is an extent of 1851 acres and 39 guntas. On the other hand, in the final notification, the extent of land was restricted to 1458 acres and 21 guntas. A statement showing the details of the layout formed by the BDA and Banishankari 5th stage, this is also same, is also extracted in a tabular column at paragraph number 7 in this said judgment. This court noticed that in Uttarali village, total extent of land which was acquired measures 16 acres and 15 guntas. Total extent of the land acquired in all 7 villages is 116 acres and 27 guntas. This court noticed that there are other tabular statements produced to indicate that the land which was not available for formation of layouts such as areas which are built up exceed 279 acres. Therefore, since the final notification was of the year 1997 and if the state of affairs as of 2014 is as noticed therein, it cannot be said that the scheme has been implemented substantially. This court noticed that the award was passed, as in the instant case. Compensation was determined and it was also the contention of the respondent BDA that the measures were drawn and positions were taken after issuance of the notification under section 16 of the Land Acquisition Act. Nevertheless, having considered the rival contention, this court held that measures were in cyclo-style forms with the blank filling in and many blanks were not filled up at all, as in the instant case. It was further held that the names of the panchas reflected in the measure did not bear the percentage.
What is the proposition that you want to canvas counsel?
First of all, my lord, the Mazar is a secular style copy. It is not having the essential ingredients which are required under law, number one. And section 16(2), do not take away my right is one of the submission which was accepted by the division bench of this honorable court. Passing of an award or depositing of an award in the reference courts also will not amount to the implementation of the scheme. That is how it has been interpreted by the honorable court, which was upheld by the division bench of this honorable court. So in a nutshell, my submission is that, my lord, the issue which has been now covered by the coordinate bench in as well as the division bench of this honorable court, where it is clearly saying that the possession having been taken over is not established beyond reasonable doubt with all the essential documents and the original files having been considered.
Senior, my lord.
Let him complete, na? Why are you interfering like this? Sorry. Yes, go on.
May I continue, my lord? Yes.
Yeah.
And another aspect of the matter which was considered is they refer to one H.V. Nandakumar judgment, my lord, which is also placed on record. That's a very elaborate judgment. Entire files pertaining to this fifth stage of Banshankari layout was considered by the division bench of this honorable court, wherein the court holds that the
What is the date of preliminary notification?
Preliminary notification is of the year 29/12/1988. They're also the same, my lord. FN final notification was 5/5/1994. And it was set aside by this honorable court, and another final notification was issued on 7/10/1999. A stipulated period under section 27 is 7/10/1999 to 6/10/2004.
What is it?
Stipulated period under sections 27, that is 5 years period under 27. The award was passed on 6/2/2008. As per annexure R3, page 24 of the respondent number 3's statement of objections. Mazar, according to them, was drawn on 17/3/2008. That is, there is one essential ingredient in the Mazar, my lord. There they say that someone else is in possession. Society is in possession. There was no bulk allotment to the society. Well, that is also one disputed fact, my lord. An award amount has been deposited in the reference court on 23/7/2008. And section 16(2) notification according to the respondent has been issued on 18/8/2009. So one of the submission which is now being also canvassed is whether within that 27, that's golden period of 5 years within that 27, has any step been taken by the BDA or by the government as per the implementation of the scheme. That is one of the submission. And another contention, my lord, which the BDA tried to advance before this honorable court in as well before the division bench, that scheme may lapse but not the acquisition in view of section 16(2) or in view of the Mazar. That contention was also overturned by this honorable court, holding that Mazar is a conclusive document which has to be demonstrated complete with cogent evidence, which has not been done so by the BDA. So, my lord, it is not just placing a document on before the court; it has to be proved beyond reasonable doubt. May I take your lordships to that judgment which I was referring to?
Now, what is the position of the land?
13 guntas. Total.
What is the position of the land?
I am in possession, my lord. There is no development. Society claims, as per its statement of objections, that they have been allotted in a bulk allotment and they have allotted the sites to the members, and now they have made a statement before this court that there is no bulk allotment. And BDA says that it is not in possession. And now, by virtue of this stand which has been now taken by the society, BDA claims that they are in possession. Can you appreciate the rival contentions between themselves? In one way, in a statement of objections, the society claims that it got the land under the bulk allotment. Kindly appreciate this submission. And they further say that they have made the allotment to the allottees. And allottees are in possession, and they have also named them and arrayed them as the impleading respondents. And their sale deeds were also produced before this honorable court, which were executed by the respondent society. Interestingly, there was no bulk allotment, but the society has executed the sale deed. And those allottees also have not constructed because there is no valid bulk allotment at all. So, my lord, the society's stand is very clear that there is no bulk allotment. And records also very clearly demonstrate before this court that there is no bulk allotment. Because bulk allotment requires certain procedures to be complied with, which I had demonstrated before this honorable court in the earlier occasion. No procedure insofar as bulk allotment like public notice, inviting the public, filing an application, all those procedures have never been complied with. So there is no case of a bulk allotment. So safely the society said, yes, there is no bulk allotment. Well, if there is no bulk allotment, there is no sale deed, and the sale deed do not confer any right, title, or interest to the purchaser. That's one aspect of the matter which has to be looked into. And the second aspect of the matter is, in Mahajar they say, kindly appreciate one important aspect. In Mahajar they say, the society was in the hands of the society. The land was in the hands of the society. How can this society be in physical possession of the land? Under what context? Is another question which was not addressed to therein. Society in one another aspect, my lord, is which is important to refer to, is that went up to the Supreme Court challenging 4.1 and section 17.1 and 19.1 notification. Notifications were upheld, and they claimed therein that they are the agreement holders, and they did not help the society at any point of time insofar as quashing of the acquisition proceedings are concerned. I am for a moment not disputing the validity of section 17.1 and 19.1 notification, my lord, for which reason there is no delay and latches at all. My submission is on an entirely different footing to say that, number one, under 27, there is a golden period under which the scheme has to be implemented, whether has it been implemented by taking any relevant step which would save the acquisition proceedings. Otherwise, 36 becomes inoperative. Section 36 comes into play, it becomes inoperative, acquisition fails. And my lord, this particular question as to whether only the scheme lapses and acquisition continues to be valid, that also been overturned by this honorable courts. And my lord, my respectful submission is that this case on hand, in a particular situation where I am in physical possession of the property and the land is still a vacant land, number one. And number two, I have produced certain photographs to demonstrate that there is a shed constructed by us which we are in still possession of the property. Number two, BDA claims that now for the first time that it is in possession of the property. Earlier it is not saying so. And the society in other way claims that it is in possession and it has allotted, because there is a dispute between themselves as to who is in possession. And it is a vacant land, kindly appreciate. So that being the case, my lord, I am in a better position to demonstrate that I am a landowner. And my rights are safeguarded and has to be safeguarded in a context where possession. Yes, ma'am. May I take your lordships to the Mahajar directly for a moment, which is at page number 33. R5 is at R5, respondent number 3's statement of objections. Your lordships would get it at 33. Here, my lord, the Mahajar
R5,
it is R5, my lord. Respondent number 3's statement of objections. May I take that page number 35, my lord? It is almost the same one which has been already considered by this honorable court, coordinate bench of this honorable court and division bench. All the addresses are vacant. Kindly see, my lord, at page 35. And the division bench in elaboration deals with this aspect of blank and cyclo-styled Mahajars. Malikara sahi illa alli. Odi heli ruju madirutteve, avara address illa. ಕೆಳಗಡೆ ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ. Kindly turn to the next page, my lord. ಅದ್ರ ಹಿಂದಿನ ಪೇಜ್ ನಲ್ಲಿ ಪೇಜ್ 34 ದಲ್ಲಿ ತಾವು ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ. ಅರ್ಜಿದಾರರು ಸೊಸೈಟಿ ಹೆಸರಿದೆ ಅಲ್ಲಿ. How can they serve a notice to the society is another question which has to be answered by the government or by the BDA. Page 34, my lord, on the left hand side. ಅರ್ಜಿದಾರರು ಅಧ್ಯಕ್ಷರು ಅವ್ರ ಹೆಸರು ಕೊಟ್ಟಿದ್ದಾರೆ. ಪೇಜ್ ನಂಬರ್ 31 ದಲ್ಲೂ ಕೂಡ ತಾವು ನೋಡಬಹುದು ಅವಾರ್ಡ್ ನೋಟಿಸ್ ಇದೆ. ಅಲ್ಲಿ ಸಿಗ್ನೇಚರ್ ಮಾಡಿದವರು ಸೊಸೈಟಿ ಅವರು. Do your honor say that, my lord, page 31 annexure R4 for a moment. Do your lordships have 31, my lord, annexure R4? There are 3 more judgments, my lord, which I would like to place reliance upon on the same point of law.
See, what is wrong in the document at page number 33, counsel?
Well, page 31 may kindly be seen at the first side. Page 31 is the award, my lord, R4. Do you lordships have that, my lord? Here kindly see, my lord, award notice at the second page, page 32. ಕೆಳಗಡೆ ಇದೆ ತಾವು ನೋಡಬಹುದು. ಅವಾರ್ಡ್ ನೋಟಿಸ್ ಅನ್ನು 14/3/2008 ಜಾರಿ ಮಾಡಲಾಗಿರುತ್ತದೆ ಅಂತ ಒಬ್ಬರು ಬರೀತಾರೆ. Foot of the page 32.
32 is in English.
ಅದೇ ಅದರಲ್ಲಿ ಕೆಳಗಡೆ ಕನ್ನಡದಲ್ಲಿ ಬರೆದಿದ್ದಾರೆ. ಒಂದು ಶರ
ಅವಾರ್ಡ್ ನೋಟಿಸ್ ಅನ್ನು ದಿನಾಂಕ 14/3/2008
ಜಾರಿ ಮಾಡಿರ್ತಾರೆ ಅಂತ ಒಂದು ಬರೆದು ಒಂದು 14/3 ಅಂತ ಒಂದು ಬರೆದಿದ್ದಾರೆ. ಅಲ್ಲಿ ಕೆಳಗಡೆ ರಿಸೀವ್ಡ್ ಅಂತ ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 5 ಆದ ನಂತರ ಲೆಫ್ಟ್ ಹ್ಯಾಂಡ್ ಸೈಡ್ ಇದೆ ತಾವು ನೋಡಬಹುದು. ರಿಸೀವ್ಡ್ ಅಂತ ಬರೆದಿದ್ದಾರೆ. ಹಯಗ್ರೀವ್ ಆಚಾರ್ GPA holder of Venkatramana. Venkatramana was not alive on that day. My respectful submission is, how can the GPA be valid? Assuming for a moment that there is a GPA, how can he receive it? No notice has been served to me, my lord. It's an internal arrangement between themselves.
Notice need not be served on accounts.
No, my lord, how it is well managed or the stage managed is my respectful submission. And kindly to turn to page 33, annexure R5. ಚೆಕ್ ಅನ್ನು ಈ ಮೂಲಕ ಲಗತ್ತಿಸಿದೆ ಅಂತ ಕೆಳಗಡೆ ಬರೀತಾರೆ. ರೈಟ್ ಹ್ಯಾಂಡ್ ಸೈಡ್ ಅಲ್ಲಿ ಮುಖಪುಟದಲ್ಲಿ ಮುಂದಿಂದೆಲ್ಲ ನೆಕ್ಸ್ಟ್ ಪೇಜಿಗೆ ತಿರುಗಿಸ್ತಾರೆ. ಅರ್ಜಿದಾರರು ಅಂತಿದೆ, ಅಲ್ಲಿ ಸೊಸೈಟಿ ಹೆಸರು ಬರ್ತದೆ.
No, ಅರ್ಜಿದಾರರು is different. ಅರ್ಜಿದಾರರು is claiming for that land.
Claiming for the compensation.
ಅಧಿಸೂಚಿತ ಖಾತೆದಾರರು.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಅರ್ಜಿನಾದ್ರೂ ಹೆಂಗ್ ಎಂಟರ್ಟೈನ್ ಮಾಡಿದ್ರು ಅಂತ ಹೇಳ್ಬೇಕಲ್ಲ. My submission is that when I am the notified khatedar, it is a land being acquired by the BDA. How can the third person make an entry there? How can the third person at least find a place as an applicant or an arjidaru?
Where is to whom the compensation is paid?
It is
Not
deposited
been paid.
before the civil court, my lords. It is deposited before the civil court.
It is deposited before the civil court. In whose name it
Not,
is?
my lords, the document which has been shown by the senior, my lords, that is the deposit challan, my lords, of the BDA before the civil court, my lords. My lords, kindly annexure page number 33, the top bottom side, my lords, in the ಭೂ ಪರಿಹಾರ ಹಣ 1,14,800.
See, now the scope of that petition is very limited.
Yes.
Preliminary and final notification are not challenged. In the sense, there is no error in preliminary and final notification.
Yes, ma'am.
The only dispute pertains to possession not being taken in the manner known to law.
Yes, ma'am.
It boils down to that.
Yes.
Possession not taken in the manner known to law.
Yes, ma'am.
That's the only thing, right?
Yes, that precisely revolves around that issue, my lord.
It's only that particular issue that has to be looked into.
Yes, ma'am.
No other thing needs to be considered.
Yes, ma'am.
Now, how possession has to be taken in law? What is the error committed by the authorities concerned? You limit your arguments to that. That's it.
Yes, ma'am. May I take your lordships to that judgment, my lord, which specifies about the procedure to take possession?
See, I'll tell you what. 16.2 is only a presumption.
Yes, ma'am.
It is not an irrebuttable presumption. You
Yes.
can always rebut it by showing that possession has not been taken in accordance with law.
Yes, ma'am.
Number one. Number two, scheme of lapse, lapsing of scheme does not result in lapsing of acquisition.
Very true, ma'am.
Okay. Pursuant to lapsing of scheme, there will be lapsing of acquisition only if possession is not taken in the manner known to law.
Then 36 becomes inoperative.
Yes.
Yes, ma'am.
Okay. You will have to look into whether possession has been taken in accordance with law or not.
Well, there are two important aspects here which I would like to place emphasis upon. Number one, whether possession has been taken in accordance with law. That's the first question. Number two, whether the possession claimed to have been taken by the BDA, is there any procedural lapse therein? Both are quite different, though appears to be similar. My submission is that in the first phase, I would like to submit there is no procedure followed and there is no possession taken over. Number one. By virtue of the documentary evidence, which the BDA also has failed to demonstrate beyond reasonable doubt that there has been delivery or taking over of the possession by following the prescribed procedure, number one. And number two, even assuming for the sake of argument without prejudice to my other contentions, that they have claimed to have taken possession, but the procedure which is required to be followed has not been followed, which has resulted in vitiating the entire proceedings for taking over of the possession. So in one by one, I would like to submit now, my lord. And insofar as the procedure is concerned, may I take your lordship's...
Now, what do you want to? If you are canvassing, possession itself is not taken, first you have to canvass on that.
There are 2 points, my lord. First, my submission would be the possession itself has not been taken over.
First, you have to argue on that.
Yes. In the second half of my submission would be the other way.
When the alternative, even presuming possession is taken, then it is the procedure adopted vitiates the same.
Your lordships are quite right. Your lordships got me correctly. That it would be an alternative submission.
Yeah.
Yes.
So, if you concede with regard to first submission, confine your arguments to the second submission. What do you want to do?
Both I may have to make submissions.
Okay, then make submissions on both aspects.
Yes, ma'am. So, my lord, in order to make submissions on the possession or taking over of the possession, may I invite your lordship's attention to the settled proposal of law regarding...
With regard to possession not taken. With
Yes.
regard to possession not taken.
Yes, my lord.
Now, possession, how it has to be taken, the Oka Sabri judgment is a I want you to look into AR Online 2023 SC 265. Or AR 2023 Supreme Court 1964.
I would open the judgment, my lord, but in the meantime, may I make my submission on this question, which your lordships have posed me. There is one division bench judgment of this honorable court, which was referred to by the coordinate bench of this court, which is in the writ appeal number 435 of 2017. Do your lordships have that copy, my lord, which I have already given?
See, you just go through this particular judgment.
Yes.
Come to You have the judgment with you, Sanket?
I'm opening it, my lord. Year 23 Supreme Court 1964.
Yeah. You can come to para number 11.
May I know the party's name, my lord, if you lost it?
It's Land and Building Department through Secretary and another versus Atro Devi and others. Land and Building Department through Secretary and another versus Atro Devi, ATTRO Devi and others. If I have AR online, I can give you that citation also.
It's not opening, my lord. This seems to be a server down.
Okay, I'll read it for you. See, the Constitution Bench of this court in Indo Development Authority case has opined that satisfaction of either of the conditions, namely
Yes.
either taking possession of the acquired land or payment of compensation to the landowners would be sufficient to save the acquisition from being lapsed in terms of section 24(2) of 2013 Act. Various questions posed before the Constitution Bench of this court were also answered. Then resultantly, the decision rendered in Pune Municipal Corporation and another is hereby overruled, and all other decisions in which also are also overruled.
My lord, here in that judgment, my lord, may I take your lordships to paragraph 14. That is a case wherein the entire records were placed before the Honorable High Court for consideration. Original records were summoned. And at paragraph number 245, of para 12, my lord, there is a reference to the judgment of this Constitution Bench of the judgment. In Indo Development Authority has been referred to at para 12. Your lordships may kindly have it at para 12.
Yes.
Where in para 244, in that judgment was referred to pertain to section 16. And para 245's question arises whether there is a difference between taking.
Para number 12, what is important? Where large chunk of land is acquired, the state is not supposed to put some person or police force to retain the possession and start cultivating the land till it is utilized. The government is also not supposed to start residing or physically occupying the same once process of acquisition is complete. If after process of acquisition is complete and land vests in the state free from all encumbrances with possession, the person retaining the land or any re-entry made by any person is nothing else but trespass on state land. Okay.
That is pertaining to the Delhi Development Authorities Act, wherein the provisions were interpreted and considered by the Supreme Court.
Then it is submitted that drawing of Panchanama for taking over possession is not enough when the actual physical possession remains with landowner, and section 24(2) requires actual physical possession to be taken, not possession in any other form.
Yes.
When the state has acquired the land and award has been passed, land vests in the state government free from all encumbrances. The act of vesting of the land in state is with possession, any person so and so.
Now, my submission is that if the document like Panchanama is the proof of taking over of possession by the government, and that Panchanama in my respectful submission is incomplete or defective, and it does not contain the required document or material evidences to demonstrate physical.
Show me the case law which says how Panchanama has to be drawn.
So may I take your lordships to the judgment by the division bench in writ appeal number 435, which I have placed on record now.
See, before that, notified Khatadari is Venkatramani, right, in this case?
Yes, my lord.
Notified Khatadari is Venkatramani.
Yes, my lord.
Okay, and revenue records reflected the name of Venkatramani.
Yes, my lord.
Notice has been sent, preliminary and final notification has been sent in the name of Venkatramani.
Notice, preliminary notification notice has not been received, my lord, and there has been no challenge at all to that extent, my lord, even though whether they've accepted it or
That
not.
means that presumption that notice has been sent.
I'm not on that point, my lord, because for a
will be
moment,
there.
yes,
Okay.
I go with presumption.
Here also, the notice, if it is sent in the name of, see, they need not look into whether his GPA is dead or somebody, if an imposter comes, they cannot make an inquiry and all that. Here, notice of possession will have to be sent to Venkatramana B, that's all.
Yes, ma'am. Kindly
Okay.
see the judgment for a moment, my lord.
In the last known address.
Yes.
Now, the Anand Bara Reddy ಅವ್ರದ್ದು judgment ಇದೆ.
Oh.
ಯಾವುದು how possession, how this particular thing, ಯಾವುದು possession has to be taken ಅಂತ ಅಂದ್ಬಿಟ್ಟು.
Procedures.
Procedure. That is staring on the BDA.
Yes.
Because they have accepted the finality of it. It has not been challenged.
Yes.
Okay. So ನಿಮ್ದಿಲ್ಲಿ ಎರಡು ಆಸ್ಪೆಕ್ಟ್ ಬರುತ್ತೆ. ಒಂದು possession, is it properly taken, number one. Number two, delay and latches in you filing the writ petition. So these are the two things that you need to argue and nothing more than that.
Yes, may I limit my submission only to that extent and address? First of all, on the question of delay and latches, that would be
delay
the
and
first
latches.
one.
Yes.
So that at least my writ petition be entertainable. So, my submission is that since I'm in physical possession of the property, no possession having been taken over by me, and the society also claims in one hand that they have taken the physical possession of the property and allotted the land. And I have come to know about the physical possessions interference only when the society's allottees try to interfere, by which I have approached this honorable court, and there is no delay and latches in approaching this honorable court, especially under section 27, so long as I continue with the possession. And my
Where have you
possession.
said that regarding delay and latches? Where have you explained it in your writ petition?
In the writ petition, my lord, we have only said about certain aspects of the matter. Para 2.11. The BDA in pursuance of the notification has not taken over the possession from the petitioners or from its erstwhile owners notified under the notification.
When did you become the owner of the property?
Well, it is granted land to me. It was granted in the year 1976 as per annexure A.
What do you mean by erstwhile owners then?
Erstwhile in the sense my parents. It was originally granted to Venkatramanappa, that is Kariyappa and Galappa, Venkata. There are three grantees in whose favor the land was granted by the Assistant Commissioner under the provisions of the Karnataka Village Officers Abolition Act of 1961. BDA Annexure A dated 17/5/1976. Lord, even though there is a provision in the government circular and notification that the granted land need not have to be acquired and there is a separate procedure contemplated, but that ground would be available for me only when I challenge 17(1) and 19(1), but that is not available to me at this point of time. Let me fairly concede that fact, my lord. But now my submission is that, my lord, I have stated at para 2.11 in specific terms that the possession is still with the landowners. 2.11 and 2.12. So, my lord, I specifically pleaded that fact. And now, my lord, the documentary evidence only placed by the respondent BDA or by the government is that the Mahajar, to demonstrate that they have taken over the position. Other than Mahajar, there is no documentary evidence. Kindly see the judgment, my lord, which refers to everything of this aspect, every procedure of this aspect.
Yes, which is the judgment?
WA number 435, my lord, which your lordships would have it at 435 of 2017, division bench judgment, you know. para 9, Melo.
435 of 2017.
Yes, Melo. Para 9. It's a division bench judgment. Para 9, your lordships would find it at page number 12. The learned single judge, may I read, Melo? The learned single judge also dwelled upon the question as to whether the lapsing of the scheme would result in lapsing of acquisition. To this, the learned single judge deciphered the measure under which the possession of the land in question was taken. The learned single judge found that the measure was just like many measures that were drawn by the respondent number 2 and 3, which were cyclostyle forms, where some of the blanks were either filled or not filled, and the percentage of the persons shown as witnesses and their addresses were not found in the measure. Similar memo. The signature of the owner was also not found in the measure. The learned single judge therefore held that the document under which the possession of the property was taken was nebulous, and held that the respondent number 2 and 3 cannot establish the taking over possession of the land in question. The learned single judge therefore held as under. So it is the extract of the paragraph. On the basis of such nebulous documents, it would not be possible for the Bangalore Development Authority to proceed further in that direction. Therefore, it cannot be said that the possession of the land has been taken. The learned single judge therefore held that lapsing of the scheme would also result in lapsing of the acquisition insofar as the land of the petitioner is concerned. Respondent number 2 and 3 are in appeal before this court. And further, my lord, there is a reference at page number 18. Same similar format which has been followed in this case as well. There is a reference to measure in paragraph line number 4, page number 18. Curiously, may I read, my lord?
1 second.
Para 12, the judgment of the Supreme Court in Bondu Ramaswamy has been referred to. And further, it is stated at last line. Yet we can't lose sight of the fact that this court is an arbiter between a citizen and a mighty state, and courts cannot shut its eyes to a palpable, colorable exercise of power. And para 13 starts at page number 16, at the foot of the page. My lord may take your lordships to directly page number 18, line number 4. Curiously, page 18, man. Curiously, in the measure at annexure R4, drawn evidencing the taking over of possession, it is found that the executive engineer was not present on 6.
1 second, just pause for a minute. Where is the measure over here?
Yes, ma'am.
So this you are required to satisfy, Sachin. Measure.
Measure, my lords. Measure, my lords.
1 second, I will hear him and I will get back to you. No, I will hear him and get back to you.
Yes.
I just told you that, sir.
No,
Yes, page number
you'll also
35.
find it at page
30. One by one we'll go.
Yes, ma'am.
If we found the executive engineer was not present on 6/1/2000 at the spot.
At this spot, here also the same, man.
ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರು ಅಂದ್ರೆ ಯಾರು?
ಅವ್ರು ಬೇರೆ ರೆವೆನ್ಯೂ ಇನ್ಸ್ಪೆಕ್ಟರ್, ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಜಿನಿಯರ್ ಇರ್ಲಿಲ್ಲ ಅಲ್ಲಿ.
That is not required. ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರು ಇದ್ರೆ ಸಾಕು.
ಅಲ್ಲ, ಮತ್ತೆ ಇನ್ನೊಂದು ಹೇಳ್ತಾರೆ, ಅವ್ರು ಪ್ರೆಸೆಂಟ್ ಇದ್ರು ಅಂತ ಇಲ್ಲ. The measure shows that executive engineer took possession of the land on 17/1. This means that executive engineer was not present on 6/1/2000, and there is no corresponding intimation by the revenue officials of the respondent number 2 to the engineering section to be present at the spot. ಇದನ್ನೆಲ್ಲ ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ಅವ್ರ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಜಿನಿಯರ್ ಆ ಜಾಗದಲ್ಲಿ ಯಾವ ರೀತಿ ಬಂದ್ರು ಅನ್ನೋದು ತೋರಿಸ್ಬೇಕಾಗತ್ತೆ. ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಇಸ್ ಮೈ ಸಬ್ಮಿಷನ್. ಮತ್ತೆ ಫರ್ದರ್ ಇಟ್ ಸೇಸ್, it therefore belies the contention of the respondent number 2 and 3 that the possession was taken over on 6/1/2000 and handed over to the engineering section. It is found in the measure that there existed a house on the land. However, it is not known whether the house was taken over or demolished. In addition, the notice under section 12(2) of the BDA Act disclosed that the land acquired was a garden land. The petitioner has claimed that there are mango trees existing on the property which are more than 25-30 years. However, the land acquisition officer has found that the entire land is vacant. Illu mane ide avara kadege vacant anta torsutte. This apart, the owner was not present, and the details of the witnesses is not forthcoming from the measure. Idralli address kottilla. ಓನರ್ ಸಿಗ್ನೇಚರೇ ಇಲ್ಲ. ಅಟ್ಲೀಸ್ಟ್ GPA ಹೋಲ್ಡರ್ ಸಿಗ್ನೇಚರ್ ಆದ್ರೂ ಇರ್ಬೇಕಾಗಿತ್ತು, ಅದು ಇಲ್ಲ. There are blanks in the Majar making it difficult to accept the sanity of this document. The apex court has held that in Katina of Business, the mode and manner of taking over of the possession and the latest in the long line of the judgments is in the case of NAL Layout Residents Association versus BDA so and so. The mother of the petitioner so and so ಅದು ನಮಗೆ ಬೇಡ.
Yes. So Mazur is improper according to you.
And it is not just one piece of paper. They may have to place it before this court and say, look, we have taken possession. That's not sufficient, my lord. They have to produce every communication, entire file they may have to produce before this court to demonstrate that there was an authority conferred on the authority to do so or to take over the possession. Without assuming for a moment that he was present and taken over the possession according to the Mazar, he must have some authority to do so under the act. And there are certain other judgments also to go to an extent of saying that it's only the deputy commissioner who is authorized to take possession, not the executive engineer. The manner in which the possession claims to have been taken is not satisfactory, is in accordance with law. Is the first submission of mine. In paragraph number 18, my lord, the judgment of the Supreme Court in offshore holdings also has been referred to, wherein there is no reversal of the title and possession of the state. That was one of the contention, my lord.
Yes, I'll come back to you. Yes, explain.
My lords, kindly turn to page number, first point, my lords, kindly turn to page number 32 of my statement of objection.
Now, land was acquired for what purposes? For the purpose
For
of
formation of Panshankari fifth stage layout, my lords.
property acquired for
Panshankari fifth stage layout.
BSK
Formation,
fifth stage layout, huh?
my lords.
Huh?
Yes, my lords.
Scheme has lapsed.
Yes, my lords.
Scheme has lapsed. Scheme has lapsed.
Yes, my lords. There are several.
Scheme has lapsed.
My lords.
Okay, your contention is acquisition is not lapsed. Does not lapse.
My lords, scheme has not substantially lapsed, my lords. In the division bench of this honorable court in my lords, page number 42, in Madhurama versus State of Karnataka. And one more judgment is there, my lords, I will produce that. In that also, my lords, the why BDA couldn't implement the scheme ಅನ್ನೋದನ್ನ ಹೇಳಿದ್ದಾರೆ.
No, that is different.
Yes, my lords.
See,
and in this, my lords.
Scheme has lapsed already. Panshankari fifth stage, the scheme has lapsed. Last time you submitted
The
that.
finding of the division bench, that scheme is substantially implemented. That is the decision of the division bench in Madhurama's case. In fact, the coordinate bench judgment he has produced, we don't have the benefit of the copy, he has not furnished.
There are no right of audience as
Maybe
such.
taken tomorrow, so tomorrow I will argue with him. I'll respond to that also.
My lords,
That-
in
that
so
is
far as, my
distinguishable.
lords, my senior argument, my lords, in so far as.
See, I'll tell you why I am asking you this. If scheme has lapsed, then in that event, possession becomes very important.
Yes,
All
my lords.
importance will have to be given to the possession. If scheme has not lapsed, then probably we need to look into this.
My lords, I will
Authority
provide the
judgment.
material.
That's but the learned thing that in the head, that in respect of that scheduled property of the petition, not the scheme has lapsed. But what has happened is the division bench has extracted as to what is the extent of the.
See,
land.
what is the position right now? The position right now is scheme has lapsed with regard to this land is concerned.
Only with regard to the particular land is.
Yes.
Not scheme, not that is what we have been contending and before they.
It has accepted finality, no?
That order has attained finality.
That order has attained finality. Scheme has elapsed then.
Scheme in the, that is what is our argument. Scheme in entirety should be looked into. Not the scheme in particular of a portion of a property. There cannot be a micro lapsing of the scheme.
Correct.
It will have to be seen in a macroscopic, not in entirety, large, not in respect of one property. If I don't use the property or if I don't take a possession of the property, not even otherwise as per section 36. 36 only when it scheme lapses.
I request the use of mic, Mano.
The provisions of the land acquisition become
Mike use
inoperative.
ಮಾಡಿ ಅವ್ರಿಗೆ ಕೇಳ್ಸಲ್ಲ.
The provisions of the Land Acquisition Act become inoperative. That means if the scheme has been implemented, I can very well continue the land acquisition proceedings. Not the contrary has been argued saying that if I don't use a particular property or if I don't take a particular possession of a particular property, the scheme lapses. That is not the way in which section 27 has to be interpreted.
See, as I understand things, scheme lapses means you come up with a declaration for formation of a particular layout.
Yes.
Correct?
Yes.
Now we are not in a position to implement that particular layout.
No, not in a position to is not the word, not, it has to be a failure on the part of the authority.
Exactly.
Yes.
So the scheme lapses, we can say the scheme has lapsed only when there is a lapsing with regard to the entire layout.
There has to be failure. My respectful submission. Yes. Not if your lordships could see the judgment of the division bench, which my learned friend may have.
Now, are you contending that scheme has not lapsed?
No, we are contending that there is no failure on the part of the authority to implement the scheme substantially. There has to be, as per section 27. There has to be a failure. Not if there is any impediment for the authority or the state government to go ahead with the acquisition proceedings. And that should not be considered as a failure of the authority to implement the scheme. Not for my respectful submission, I initiate the acquisition proceedings. But there are several litigations which are initiated, which do not find the end till date. And there are status quo orders or stay orders, or there are several impediments for the state and the BDA to implement the scheme. That should not be considered for determining whether the scheme has been implemented.
What is see, this particular scheme was already under challenge.
Yes, ma'am.
Last time, both of you considered that scheme has lapsed.
Not insofar as there is a finding of the two division benches, contrary orders of the two division benches, wherein in Justice Ravi Mallimat's case, lordships holds that by extracting the entire extent, if your lordships could see that order, where lordships have extracted what is the status of the land. While going through that, land under litigation is 544 acres. If that is so, the authority cannot be expected to to say that we have by our own dereliction of a duty, it has been we have not implemented it.
So you are disputing the fact that
Yes,
the scheme has lapsed.
Yes,
Scheme has not lapsed.
Scheme has not lapsed according to us. Lordship may kindly see that tabular form itself.
Page number 11 of 435 of 2017, my learned friend has passed on, my lords, now it's 435, Retabil 435 of 2017, page number 11.
Lordship may kindly see that page number 11, there's a tabular column. Out of 1,458 acres, 21 guntas, Lord, Lordship may kindly see the built-up area is 279.6. Yes, that deleted subsequent to the orders in the writ petition, 58.3. Denotified land, 205. Layout formed by BDA, 116. Government land, 255. Land under litigation is 544. Watch me kindly see this. Not there here. If we join this, all this, there's a question of failure will not come.
No, but what was the finding of the court?
Finding of the court that, my lord, since the possession mahazar The Mahazar which has been relied upon by the BDA to show that the possession was taken is a nebulous document. And Lord, the landowner's signature is not found. But this has been all answered in the indoor development case, Lord. It is said that landowner's signature is not required because the landowner will not come forward to sign. Then if in the absence of a landowner's signature, it cannot be said that the possession is not taken. Even otherwise, if you want to challenge the possession Mahazar or a 16-2 notification, what is the earliest point of a time that you could have come to the court and ought to have said as to the possession is not taken? The division bench says the 5 years lapses. The limitation for the landowner starts from the 5 years date of.
Anything about acquisition, nobody comes to his land. So you can disturb him.
Please.
He doesn't know anything about the acquisition. Nobody even comes to his land.
Lord, that is what, that ignorance he cannot plead because in the entire vicinity of that area or a scheduled property, the other lands are acquired.
The fact that you don't do anything on his
Not
land.
the fact that we pass an award and take a possession. Even otherwise, I don't go there. He cannot be treated as a person.
Then
He is treated as a trespasser.
If you have taken possession in the manner known to law, then he is definitely treated as a trespasser.
Yes.
There's no question of him being entertained at all.
But according to us, we say it's the Mahazar is. We'll have to justify the Mahazar.
You have to justify the
But
Mahazar.
not at this instance. Lord, for a simple reason, I'll tell. I have taken possession 25 years back, Lord. There's a signature of a Ramaya. Now I cannot call upon Ramaya to come and give evidence because I do not know who is that Ramaya, where he is at this
No,
point of a time.
The point is when you take Mahazar, when there is signature of Ramaya, should it not be accompanied by his address? Should it not be accompanied by his address?
Lord,
Forget owner's signature. Owner will never come forward to sign the document.
yes.
Okay, forget owner's signature.
Yes.
Okay, and when you take possession, you simply take the surveyor along with you. Okay, he measures and says that illinda illige ishtu area bartade.
How?
Okay, so you jot it down. So come to Mahazar in this particular case. Page number 33.
Page number 35, my lord.
35.
36 is important, my lord. It says that someone else is in possession again. It is another wrong. Page 36. Swadhina ಪಡೆದುಕೊಂಡ ಭೂಮಿಯ ವಿವರ.
That's okay. That may be erroneous. We are not bothered on that.
Yes.
You come to page number 35.
Yes.
If you come to page number 35,
Yes.
see, you incorporate the first portion of it. ಓದಿ ಕೇಳಿ ಒಪ್ಪಿ ರುಜು ಮಾಡಿರ್ತೇವೆ. Till that you come.
Yes.
When you look at it, see, because everything is properly filled up. See, circular style means it's not that you cannot photocopy the Mahazar and then fill up the blanks. Nowhere it is prohibited. The only question is it believable or not on the face of it? On the face of it, that's all we look into.
Yes.
Now, you come to this so and so, Rajaswa Nirikshakaru, Dinaka, 15/3/8 ರಂದು ಸ್ಥಳಕ್ಕೆ ಬಂದು
15/3 on the right hand side.
ಕೆಳಗಡೆ ನೋಡ್ಬೇಡ್ರಿ, ಮೇಲೆ ನೋಡಿ.
No, ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರ ಪಕ್ಕದಲ್ಲಿ ಸೈನ್ ಹಾಕಿದಾರಲ್ಲ ಅದು 17/3.
That's okay. That itself becomes a doubtful thing. I'll tell you how. See, ಬೆಂಗಳೂರು ದಕ್ಷಿಣ ತಾಲೂಕು ಉತ್ತರಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 51 ಜಮೀನು ಬಳಿ ಸೇರಿದ್ದ ಈ ಕೆಳಗೆ ರುಜು ಮಾಡಿರುವ ಬರೆಸಿ ಪಂಚನಾಮ ಬನಶಂಕರಿ 5ನೇ ಹಂತ ಬಡಾವಣೆ ಸ್ವಾಧೀನವಾಗಿರುವ ಜಮೀನುಗಳ ಪೈಕಿ ಉತ್ತರಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 51 ವಿಸ್ತೀರ್ಣ 13 ಗುಂಟೆ ಜಮೀನು ಭೂ ಸ್ವಾಧೀನವಾಗಿದ್ದು ಆ ಬಗ್ಗೆ ಆದ ಅವಾರ್ಡ್ನ ಪ್ರಕಾರವಾಗಿ ಜಮೀನನ್ನು ಸ್ವಾಧೀನಕ್ಕೆ ಪಡೆಯಲು ವಿಶೇಷ ಭೂ ಸ್ವಾಧೀನಾಧಿಕಾರಿಗಳ ಪರವಾಗಿ ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರು ದಿನಾಂಕ 15/3/8 ರಂದು ಸ್ಥಳಕ್ಕೆ ಬಂದು ಹಾಜರಿರುತ್ತಾರೆ. ಗೊತ್ತಾಯ್ತಾ? So that means to say this possession was taken in the presence of Rajaswa the village accountant,
revenue inspector.
Revenue inspector. Okay.
Of the state government.
Revenue inspector.
Yes.
On 53/08.
Yes.
In the presence of following punch.
Yes.
Now you find 5 names over here. Kempaya, Nagaraj, so and so, Shankara, Ramaya. Okay? Huh? The third one is not, we cannot decipher. Now, should it not contain their address at least, number one? When you draw the muzzle. Number two, come to Nanna Samakshama.
Please.
Right hand side.
Please.
ರಾಜಸ್ವ ನಿರೀಕ್ಷಕರು ವಿಶೇಷ ಭೂಸ್ವಾಧೀನಾಧಿಕಾರಿಗಳ ಕಚೇರಿ 17-3-8.
Yes.
See, he cannot sign it on 17th. So this gives the impression it has been signed in his office.
Lordship, may kindly refer to the 2
ಇನ್ನು
pages.
ಕೆಳಗಡೆ
back.
ಮತ್ತು 17-3 ಅಂತಿದೆ, ಮತ್ತೊಂದು ಕಡೆ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲ, ಒಂದು ನಿಮಿಷ. ನೀವು page number 32 note. This is the 12-2 notice.
ಆಮೇಲೆ ಮೇಲ್ಕಂಡ ಒಂದ್ ಸೆಕೆಂಡ್ ಬಿಫೋರ್ ಗೋಯಿಂಗ್ ಇನ್ ಟು ಇಟ್, ಮೇಲ್ಕಂಡ ಕೆಳಗಡೆ ಬನ್ನಿ ಒಂಚೂರು. ಮೇಲ್ಕಂಡ
ವಿವರಗಳುಳ್ಳ ಜಮೀನನ್ನು
ಮೇಲ್ಕಂಡ ಮಾಲ್ಕಿ ಕಟ್ಟಡ ವಗೈರೆಗಳೊಂದಿಗೆ ಭೂ ಸ್ವಾಧೀನಾಧಿಕಾರಿಗಳ ವತಿಯಿಂದ ಬೆಂಗಳೂರು ಅಭಿವೃದ್ಧಿ ಪ್ರಾಧಿಕಾರದ ಪರವಾಗಿ ಸ್ವಾಧೀನಕ್ಕೆ ದಿನಾಂಕ 13-3-8 ಪಡೆದಿರುತ್ತೇನೆ. ಹೌ you can have 15 at the top and 17 at the bottom. You need to explain it.
Yes.
You need to explain it.
Please.
Yes. Now, because the top of the muzzle, when we read, it indicates possession of the property was taken on 15/3/2008 by the revenue inspector.
Yes.
By the revenue inspector.
Yes.
Nobody else.
Yes.
In the presence of the following witnesses.
Yes.
Okay, but down it is stated, he says he has taken possession of the property on 17/3/08.
Please.
That discrepancy you need to explain.
Yes.
With regard to Mazar, number one.
Yes.
And then, see, we are not asking you to get this Kempaya, Nagaraj, Shankar, Ramaya and the other one.
Yes.
Today.
Yes.
We are not asking you to get their statements. But Mazar means what, sir? What is Mazar?
Mazar is not.
What is Mazar, sir?
Yes. Mazar.
Why Panchas are required? If you want to get into criminal law, why Panchas are required? Mazar is one and the same. How you draw a Mazar? Why Panchas are required? Panchas are required because they are the witnesses. The witnesses should be identifiable. Where is the question of identifying the witness in this particular document? That's what makes it nebulous.
Not image.
Now, for a moment, if you say this is not nebulous,
Yes.
this Panchnama is not nebulous, then I request you to, or rather I direct you to provide me the Mazar copy in this particular judgment.
I'll do. Not it would
No,
be
in
the
this particular judgment.
it would be the same.
See, in this particular judgment, where it has been held that this particular property also was acquired for the purpose of
5th stage.
BSK 5th stage, number one. Number two, the acquisition has been set aside only on the ground that the Mazar is nebulous.
Please.
No other ground. No other ground. Number two, Mazar is nebulous. You produce the Mazar.
Yes.
If the Mazar is similar to this, and this has attained finality because you have accepted it. You have not filed an appeal. You have not filed an appeal.
It has attained finality before the Supreme Court.
Huh?
I'm told that, my lord, this judgment of the division bench also attained finality before the Supreme Court.
Okay, now if it has attained finality, then in that event, a similar Mazar drawn over here should also be considered nebulous.
Yes.
Because there are two disturbances over here. One,
The date and the witness.
the date,
And the witness.
because the person who takes possession is revenue inspector.
Yes.
Okay, when he says here possession is taken on 15/3, that 15/3 should have found a place in the other two dates.
Yes.
And see, the Panchas have to be identified, identifiable. You need not get them today.
Yes.
It may not be able to, you may not be in a position to trace them today.
Yes.
But Pancha should be identifier.
Yes.
Their name, their signature, and their address, where they come from. The Panchas have to be identified.
Yes.
Here, the Panchas are not identifiable. You please produce a copy of the Mazar
In this.
of this particular judgment.
Yes, and I'll produce the copy of other Mahazas where the Honorable Court has upheld the acquisition proceedings by relying on those this one. Lord, it goes the other way, Lord. Why I submit
Yes,
this?
correct.
This is the document which has been followed from past 40 years by the BDA. And Lord, Lordship may kindly refer to the 12-2 notice.
Yes, you do one thing.
Yes,
You produce both.
Yes.
Okay. And you also produce details about whether the scheme has lapsed or not lapsed.
Lord, according to us, the extract of the order of the division.
I'll call it
bench-
day after tomorrow.
Yes, that is correct.
I'll call it day after tomorrow.
Yes.
19th, my lords.
Let them
19th of
produce the
Division.
entire.
The problem ಏನಾಗುತ್ತೆ ಗೊತ್ತಾ ನನಗೆ ಮರ್ತೋಗುತ್ತಾ
Day after tomorrow, my lords. I will try to get it, my lords.
But in other matters also, there are mazars similar. We don't have any.
Produce
other-
both.
Yes.
We'll settle the issue.
Yes.
Either of you go on an appeal.
Yes.
ಅಲ್ಲ ಎಂಟೈರ್ ಫೈಲ್ ಪ್ರೊಡ್ಯೂಸ್
My lord,
ಮಾಡೋದಕ್ಕೆ
in this matter, my lord.
No, Sanket, ಇಲ್ಲಿ problem ಎಲ್ಲ ಆಗ್ತದೆ
First,
ಗೊತ್ತಾ? There are
ಇನ್ನೊಂದು
inconsistent judgments coming out.
ಇದ್ರದ್ದು ಏನಾಗಿದೆ?
Deposit ಆಗಿದೆ.
ಅವ್ರು ಬಂದಿದಾರ ಅಲ್ಲಿ.
See, on the same Mazda, there has to be some yards. See, I find that in this current Mazda, they have to answer two aspects. One, difference in date. Second thing is identification of the Panchas.
Yes.
Okay. Now, let us examine this Mazar with the Mazar in cases where the acquisition has been struck down only on the ground of Mazar, and also in the case where acquisition has been upheld on the ground of possession being taken
And
in accordance with law.
whether the mother is the same one.
Huh.
Till
So-
2023, my lord, I'm sorry to interrupt. Till 2023, my lord, we have followed the same thing. From 1976 till 2023, we have followed the same
So,
math.
ಅದು ನೋಡ್ಕೊಂಡು we'll have to give our judgment.
Supreme Court says, once the third party interests are created, it is deemed that the possession has vested with the authority, and you cannot ask the court to look into after 30 years that are on a technicality of a mother. You cannot approach the court saying that the mother
Produce
possession
that
has not
judgment
been
also.
taken.
You produce that judgment also.
Yes, that's them.
And also, see, he is relying upon certain other irregularities vis-a-vis the society.
There's a different issue.
Okay.
Yes.
See, well, if you say a scheme has not lapsed, then where is the question of giving it to society? It should have been part of BSK 6 stage.
Lord, it is a
That
part
is
of
because, my
BSK
lord,
fifth
that is-
state.
that is because, my
Alternate.
lord, the transaction document between the owner and the society has been produced to the BDA much earlier. And on the power of attorney which he has executed, I have challenged the acquisition also earlier. So it is
mean,
not that BDA was not aware about the transaction happened.
You had purchased the property?
Yes, my lords.
Yes.
Petitioner has no locus standi at all, my lords. Petitioner has sold the property to the respondent number 5.
Where is the sale deed?
And the bulk allotment.
Where is the sale?
Where the
My
sale?
lord,
Sale
as-
date is not yet happened. By
Yes.
that time, this notification was issued.
Registration
Therefore, I have
act.
continued by virtue of the power of attorney executed by him, that he has suppressed in the writ petition. He has not even shown that. When I filed the impleading application also, he has not traversed that. He has not even disputed on record.
Well, no, it
About
is not.
the execution of the agreement, power of attorney and the amount received by him through checks. It is not by cash.
My lord, in this context, I would like to borrow the observation made by Justice Krishna here in Mahinder Singh Gill. Orders are not like old wine, becoming better as they grow older. So they cannot substitute a document which is the defective one. That's all.
No, the issue is, did some right accrue in your favor? Did some right accrue in your favor?
When his right is divested, coupled with his undertaking to transfer it to me by receiving the amount, market value of the property as on that day.
No, similar submission was made in Vayali
He has
Kamal.
lost
Supreme
the-
Court says,
he has
if they
lost
have an
the
agreement,
ground.
let them go by civil court.
It is not that, I'm simply taking away the land as such. I have disclosed everywhere, this is the transaction happened. By that time, notification has come. Then I approached the authority as well as the government, seeking for bulk allotment. That has been considered by the government. Government has asked the BDA to consider it. So BDA has to take further steps. It is not yet taken. That is where in the bulk allotment order, which is gazetted, in detail it was considered.
Okay,
And I
when,
have
now when do you
already-
want it to produce all the relevant things? When can you produce?
My lords,
When do you want it?
document my lords are by 14th, my lords. 14th, my lords has, insofar as Mahazars are concerned, my lords, I will produce on 14, my lords.
ಎಲ್ಲ ಹೇಳ್ರಿ ಒಂದ್ಸಲ ಮುಗ್ಸೋಣ. ಪದೇ ಪದೇ. ಆಯ್ತು, I'll call it on 19th itself, because 3 days holidays are there. 19th ಸಂಕೇತ.
Great. Stay may kindly be continued. my
Heard in
lord.
part, for further hearing, call on 19th.
Interim order may kindly be continued.
Order if any is extended till next day.
Great.
Number 27. Shiv Prakash, Murgesh Vicharat.
This will be called on 27th, Lord, because this is a MAR peripheral ring road 2 matter, where Lord, similar issue has been dealt by your lordship, saying whether I should take only the aligned road or whether a land which is to be left out. That 7 guntas, they say, after farming a road, 7 exact road, 7 guntas will be left out. No, that is what is their place. Lordship may have it on 27th.
My grievance is now, if it is useful for the public purpose, let them take it. Now, as it is, road is formed, road margin is earmarked and everything is over. To my, the 7 guntas, this is the only access for my land to enter. If at all, if genuinely, if they require the 7 guntas for the formation of road or any other thing, let them take it. Now, it is not required. That's what the sketch is also prepared, surveyor also appointed, everybody.
I'm being told that it will not be an access control road. So, my lord, the access from the road is available to everybody. My lord, Lordship may have it on 27th on that day.
To my land,
Just access control road. See, what happened? The road is formed.
Yes,
Okay. Now, his land is adjacent to the said road.
yes,
Because after all, a portion of his land is
correct.
acquired for acquisition. Now, what do you do? For that road itself, you require 10 more feet, he has no objection. Because at the end of the day,
Yes,
his land will be adjacent to the road itself.
yes.
Okay. His worry is, now what you do? You acquire more land than required for the road.
Correct.
Okay. Then ಪಕ್ಕದಲ್ಲಿ ಆತನ ಜಮೀನ್ ಇರ್ತದ, ಉದ್ದಕ್ಕೆ ಇರ್ತದ. ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ ಅಕ್ವೈರ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಅದನ್ನ ನೀವು ಪ್ರೈವೇಟ್ ಪಾರ್ಟಿ ಕೊಟ್ಬಿಡ್ತೀರಾ ನೀವು?
ಇಲ್ಲ, ಅಲ್ಲಿ ನಾವು
Listen.
ಎಸ್ ಬಸ್ ಟರ್ಮಿನಲ್ ಮಾಡಬೇಕು ಅದೆಲ್ಲ. ಅದೇ
Whatever, where his access is blocked completely.
completely. It will not be blocked. What
No,
is it?
point is, you cannot say that now I want that road and I want that land and all that stuff. What is your current plan?
Yes, Lordship may have it on 27th, my lord, the entire plan will be
Yes,
brought
sir.
before your lordships.
PDA is directed to. ಅಲ್ಲ, ಈ ರೀತಿ ಮಾಡ್ಕೊಳ್ಳಿ. The case of the petitioner is that his land was sought to be acquired for formation of peripheral ring road. And on a portion of the land acquired, the road is already formed. Full stop. It is submitted that PDA has acquired excess land than what is required for formation of road. And he is interested in getting back only
7 guntas.
excess land and not the land utilized for the road. Full stop. Next para, for the aforementioned reasons, BDA is directed to file an affidavit stating whether it has formulated any plans for utilization of the said excess land along with the sketch prepared, relevant sketch prepared by next date of hearing.
Please.
Full stop. Call on
27.
27.
Please.
See, you have to clarify that.
Yes, we are filing it. In MAR, we are filing everything.
You don't require it, you
Not
give it up.
Not we require.
Adre, if you require, you should already have a plan for that.
Bus
Okay. See, declaration agvadra plan irbeku. Without a plan, you can't have a declaration, I say.
Out.
Correct. So what is the plan? See,
I understand.
by the time you come out with final declaration, there has to be a plan.
Yes.
Correct.
At least one 80%, 90% plan aru nam kade irutte.
80%, 90% ಅಂತ
Modification provision ಇದೆ ಅದಕ್ಕಾಗಿ
ಇದಕ್ಕೋಸ್ಕರ ಸೀಮಿತವಾಗಿದೆ. Nobody prevents you from modifying it tomorrow.
Yes.
But see, without any plan, if you say that I acquire this much, it is harassment.
Fairly, I am submitting. If it is genuinely required, let them take. Now it is not required. Even the BDA surveyor has conducted a survey and has marked the line and also sketch.
Those surveyors reports do not get approved by any competent authority.
Doesn't
They go to
matter.
their hand first and never be in the file.
When you acquire 10 acres, there has to be a declaration regarding the 10 acres.
Yes.
Now, you know, ಮಾಡ್ತೀವಪ್ಪ.
Correct.
ನಾಳೆ ನೀವು ಮಾಡಿಫೈ ಮಾಡ್ಕೊಳ್ಳಿ. ಬಟ್ ಈಗ ಸದ್ಯಕ್ಕೆ ನಾನು ಲೇಔಟ್ ಮಾಡ್ತೀನಿ, ಇಲ್ಲೊಂದು ರೋಡ್ ಮಾಡ್ತೀನಿ, ಏನೋ ಒಂದು ಇರ್ಬೇಕಲ್ವಾ? ಅದು ರೋಡ್ಗೆ ಆಕ್ಸೆಸರೀಸ್ ಕ್ರಿಯೇಟ್ ಮಾಡ್ತೀನಿ, ಇರ್ಬೇಕಲ್ವಾ?
ಅಲ್ಲ, ಈ ಪೆಟ್ರೋಲ್ ಬಂಕ್, ಅಲೈಟ್ ಸರ್ವಿಸಸ್ ಎಲ್ಲ ಮಾಡ್ಬೇಕು.
ಅಲೈಟ್ ಸರ್ವಿಸಸ್ ಅಂತಾನೆ ಇರ್ಬೇಕಲ್ಲಪ್ಪ.
ನೋಟಿಫಿಕೇಶನ್ ಅಲ್ಲಿ ಹಂಗೆ ಇದೆ. ಬಸ್ ಟರ್ಮಿನಲ್ಸ್, ಡಿಪೋಸ್ ಎಲ್ಲಾನು ಆಮೇಲೆ ಅಲೈಟ್ ಸರ್ವಿಸಸ್ ಎಲ್ಲ.
ಬಟ್ ವೆನ್ ಯು ಕಮ್ ವಿತ್ ದಿಸ್ ಡಿಕ್ಲರೇಷನ್, ಇಟ್ ಕಮ್ಸ್ ಓವರ್ ಹಿಯರ್ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ನಿಮ್ಗೆ ಇರ್ಬೇಕಲ್ಲ.
ಎಸ್.
ಅದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಸೆಟ್ ಅಸೈಡ್ ಆಗುತ್ತೆ. ಅದಿದ್ರೆ on one condition we will allow it. With the rider that he has got land subsequent to the lands acquired, adjoining to the lands acquired, he has remaining land and access to his land will have to be provided from the road.
Yes. Yes.
That observation will be made and writ petition will be disposed.
ಇಲ್ಲ, ಇವ್ರಿಗೆ ಆತರ ಆಗ್ತಾ ಇಲ್ಲ. ನಾವು ಅಕ್ವೈರ್ ಮಾಡ್ಕೊಂಡಿರೋ ಲ್ಯಾಂಡ್ ಅಲ್ಲಿ ನೀವು ಇಷ್ಟನ್ನೇ ಯೂಸ್ ಮಾಡ್ಕೊಂಡಿರೋ, ಮಿಕ್ಕಿದನ್ ಬಿಟ್ಟಿದ್ದೀರಾ, ಕೊಡಿ ಅದನ್ನ ವಾಪಸ್ಸು ಅಂತ. ಇವ್ರದ್ದು ಕೇಸ್ 20 ಗುಂಟೆಯಲ್ಲಿ ನೀವು 13 ಗುಂಟೆ ಅಷ್ಟೇ ಉಪಯೋಗಿಸ್ಕೊಂಡಿದ್ದೀರಾ, ಇನ್ನು 7 ಗುಂಟೆ ಉಪಯೋಗಿಸ್ಕೊಂಡಿಲ್ಲ, ಅದನ್ನ ವಾಪಸ್ ಕೊಡಿ ಅಂತ. That is what he is asking in the writ petition. That's all.
Okay. ಬಟ್ ಇವ್ರದ್ದು ಏನಾಗುತ್ತೆ, ಇಫ್ ಐ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಹಿಮ್ ಕರೆಕ್ಟ್ಲಿ, ಇವಾಗ ಒಂದು 10 ಎಕರೆ ಜಮೀನು ಇರುತ್ತೆ, 2 ಎಕರೆ ಅಕ್ವೈರ್ ಮಾಡ್ಕೊಂಡಿರ್ತೀರಾ, 1 ಎಕರೆ ಯುಟಿಲೈಸ್ ಮಾಡ್ಕೊಂಡಿರ್ತೀರಾ. ಇವಾಗ ಹೇಳ್ತಾ ಇರೋದು 1 ಎಕರೆ ಯೂಸ್ ಮಾಡಿದಿರಾ, ಇನ್ನೊಂದು ಎಕರೆ ಕೊಡಿ ಅಂತ ಅನ್ಬಿಟ್ಟು. 1 ಎಕರೆ ರೋಡ್ ಯೂಸ್ ಮಾಡ್ಕೊಂಡಿದೀರಾ, ನೀವ್ ಹೇಳೋದು ಇಲ್ಲ ಆ 1 ಎಕರೆನು ಬೇಕು, ಬಿಕಾಸ್ ಅದನ್ನ ಬೇರೆ ಡೆವಲಪ್ಮೆಂಟ್ ಯೂಸ್ ಮಾಡ್ಕೊಂತೀವಿ ಅಂತ ಅನ್ಬಿಟ್ಟು. ಅವಾಗ ವಿಲ್ ಮಾಡಿಫೈ, ಈ ವಿಲ್ ಸೇ ದಟ್ ಅದ್ರ ಪಕ್ಕ ನಮ್ದು ಇನ್ನ 8 ಎಕರೆ ಇದೆ, ಅದಕ್ಕೆ ಆಕ್ಸೆಸ್ ಬೇಕು
ಅಂದ್ಕೊಡ್ತೀವಿ.
ನೀವು ಪ್ರೈವೇಟ್ ಪಾರ್ಟಿ ಕೊಟ್ಬಿಟ್ರೆ ಆ 1 ಎಕರೆ ಬ್ಲಾಕ್ ರಸ್ತಾ ಬದಿನಲ್ಲೇ ಇದ್ರೆ ಏನ್ ತೊಂದರೆ ಆಗಲ್ಲ. ಅದನ್ನ ಪ್ರೈವೇಟ್ ಪಾರ್ಟಿ ಕೊಟ್ರೆ ನಾನೆಲ್ಲ ಹೋಗ್ಲಿ.
ಇಲ್ಲ, ಪ್ರೈವೇಟ್ ಪಾರ್ಟಿ ಕೊಡಲ್ಲ. ಅಂದ್ರೆ ನಾವು ಮಾಡ್ಕೊಟ್ರು 40, 60, 50, 80 ಸೈಟೇ ಮಾಡ್ಕೊಡ್ಬೇಕಾದ್ರೆ ಹಂಗೆ ಬಲ್ಕ್ ಅಲಾಟ್ಮೆಂಟ್ ಅಂತೂ ಕ್ಯಾನ್ಸಲ್ ಆಗೋಗಿದೆ.
ಅಲ್ಲ
50, 80 ಸೈಟ್ ಮಾಡ್ಕೊಟ್ರೆ ರೋಡ್ ಮಾಡ್ಕೊಡ್ತೀನಿ. ಇವ್ರಿಗೆ ರೋಡ್ ಇದ್ದೇ ಇರುತ್ತೆ. Obviously,
with that observation we'll dispose.
Yes, yes.
You just get it.
Please.
Yes, call on please.
Please, madam.
28 Kishan GS.
Lord, some inconvenience, my lord, and mistakenly I have left this filed in Tumkur, my lord, mail it day after tomorrow, my lord.
The request of petitioner call on day after tomorrow date.
29.
Next week, my lord, day after tomorrow, required to file objection.
ಇದು 28 ಒಂದು ಕೆಲಸ ಮಾಡಿ, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಡೇಟ್ ಕೊಡಿ.
28. 28.
20 ತಾರೀಕು.
Case number 29.
Please.
It's a Santosh Ajay Kumar.
My lord, I am appearing on behalf of the petitioner, my lord.
Yes, ready? Both
Petition
sides?
seeking for a writ of mandamus, my lords. Annexure N and Annexure Q are the representations by the petitioner to the BDA for considering his case for grant of alternative site. My lords, the petitioner was, the mother of the petitioner was allotted a site in the year 2000. My lords, in fourth stage BTM layout. Subsequently, my lords, the landlords had filed a writ petition. Your lordship may kindly take annexure M at page 39. The writ petition came to be allowed by this honorable court, and the 19-1 notification was quashed, saying that, my lord, it is lapsed. 19-1 notification. Subsequently, my lord, the mother of the petitioner also has gifted this property to the petitioner herein. My lord, he makes a representation to the BDA annexure N and annexure Q, 2021 and 2022 respectively. It is not yet considered by the BDA for alternative site, my lord.
So we'll have to pass orders on this. We'll have to pass orders on this representation, minutes. Plus the order which has been relied upon with annexure M, minutes. Try to get information whether we have preferred appeal. As I was not able to get any instructions as to whether appeal has been preferred. We'll have to pass orders on his representation based on this.
Correct. Appeal we'll dispose it out.
Please.
The time frame may kindly be fixed, my lords.
Yes. Yes, the petitioner is that his mother was allotted ಎಷ್ಟು site?
My lord, site bearing number 1350/B.
40 site measuring
4060, measuring 4060, my lord.
Was allotted a site measuring 14 to 16 BTM fourth stage. Second block, Bangalore. Full stop. It is further submitted that subsequent to allotment, the erstwhile landowner of the property from whom the said land was acquired for formation of the layout by the BDA challenged the acquisition by way of WP number 64621-64625 of 2016, and the acquisition has been set aside. Full stop. For that reason, the petitioner has submitted a representation to the BDA to allot him an alternative site. Full stop. As the said request has not been considered, the present writ petition is filed. Full stop. Similar value ಅಂತ ಹೇಳ್ಬೋದಾ ಕಾರ್ತಿಕೇಯನ್?
Sorry?
That you will be allotting him a site of similar value ಅಂತ ಹೇಳ್ಬೋದಾ? BTM ಅಲ್ಲಿ ಎಲ್ಲಿ ಕೊಡ್ತೀರಾ? ಎಲ್ಲಿರುತ್ತಲ್ಲ ಜಾಗ?
Similar value.
BTM ಅಲ್ಲಿ ಎಲ್ಲೂ ಇಲ್ಲ, my lord. I have verified it.
Make that statement. I will not be able to make such a statement. I don't have. I was trying very hard to ensure whether the writ appeal is filed. I had to bring to my lord's notice.
4060.
It's in accordance with the provisions, we'll have to pass.
25,000 ಚದರಡಿ ಇದೆ ರೀ BTM ಲೇಔಟ್ ಅಲ್ಲಿ, ಅದನ್ನ ಆಲ್ಟರ್ನೇಟಿವ್ ಸೈಟ್ ಇವ್ರು ಎಲ್ಲಿ ಕೊಡ್ತಾರೆ? 4060 ಡೈಮೆನ್ಷನ್ ಆರ್ಡರ್ ಮಾಡವ?
Yes, my lord. 2000 is the allotment date of year of allotment.
Very reasonable. Probably in my entire roster, I am not finding an advocate for the petitioner being so reasonable. Present writ petition is filed. Full stop. Next part. The counsel for the BDA fairly submits that the petitioner was indeed allotted a site measuring 14 to 60 feet as claimed by him. Full stop. He further submits that the BDA shall consider his representation in the manner known to law. Manner known to law. And allot him an alternative site. Full stop. His submission is placed on record. Full stop. Hence the following order. Full stop. Respondent number?
Representations are made to represent respondent number 1.
Respondent number 2. 1 and 2 respondents. Respondents shall consider the case of the petitioner in the manner known to law and allot him slash his mother. Allot him ಅಂತಾನೆ ಇರ್ಲಿ. Allot him. Slash his mother ಅಂತಾನೆ ಹೇಳ್ಬೇಡ ಅಲ್ವಾ?
Because the original allotee was the mother, my lord.
Slash his mother, an alternative site within a period of 3 months from the date of receipt of certified copy of this order. Alternative site of similar dimension.
Please.
Of similar dimension, anywhere in Bangalore. Anywhere in Bangalore. Within
Please.
a period of, yes.
Great.
30, Prakash T. Abbar. Number 30.
My lords, appearing for respond number 2 and 4, my lords. Kindly taken up this matter on 26th, my lords, due to some personal
Madam,
inconvenience.
at your request, it was adjourned to today.
Last occasion, we have filed in our objections, my lord. We have
It's all
requested
right.
court to file.
Elections ಇದೆ ಅದ್ರಲ್ಲಿ ಏನಿಲ್ಲ ಇದು ಗವರ್ಮೆಂಟ್ ಕಳಿಸ್ಬೇಕು ರೋಡು.
See, I asked the advocates, take a date of your choice on that day, no further.
That day, we
action.
won't request any.
Not like that. See, senior counsel has been waiting for this case from the morning. You think he has no other work, is it?
Apologies.
No, because of your incompetence, everyone is put into problem. Let me see what the matter is all about.
My
Yes,
lord,
sir.
my lords, kindly pass over, my lords. Please.
What do we do, sir?
Yeah, lordship stands, my lord. Whatever your lordship feel, my lord, I'll be.
If they want a date, they will not do today. They will only drag.
ಆಯ್ತು ನಾವ್ ಹೇಳ್ದಾಗ ಬರ್ತೀನಿ.
No further adjournment, madam.
No.
You take a date of your choice, but please go on with the matter on that day. When do you want?
26th, my lords.
At the request of counsel for respondent number
2 and 4.
2 and 4, finally call on
26th.
26th.
26 is no sitting day.
No, no sitting. Oh,
No, I won't.
that
sit,
day,
my lord.
they want. Yes,
26th. That day, we won't request any other.
26th is a holiday, madam.
27th, my lords.
27th.
Great.
31, Amar Gowda.
Correspondent number 2 and 3 in this case, your lordship.
My lord, this is a matter wherein, my lord, the respondent KDB, my lord, issued a preliminary notification, my lord. We filed our objections.
Ready, Nanappa?
Yes, your lord.
Good.
My lord. The preliminary notification was dated 12/8/2020, my lord. We have filed our objections, my lord. My lord, the land in question, my lord. Is survey number 298/3, my lord. After considering our objections, my lord, the land action officer has dropped it from acquisition, my lord. My lord, that you find at, my lord, Annexure F, my lord, ink page 23, my lord. My lord, my land is at serial number 129, my lord. My lord, at ink page 62, my lord.
Okay.
They say that it is recommended for dropping, my lord. Thereafter, in final notification, my land is found. They say house is there, it's a developed land and everything is done, my lord. Around 137 properties are dropped from acquisition, my lord. Recommended, my lord. But in the final notification, my
28/4, 28/3,
yes, ma'am.
not binding on 28/4. Only thing is they have to assign reasons.
And no reasons at court.
I have instructed your lordship, the land may be excluded from the acquisition.
File your objections.
I'll file objections.
You oral statement ಮಾಡಕ್ ಹೋಗ್ಬೇಡಿ. They will haul you up, okay? Get instructions and say that we'll drop acquisition ಅಂತ ಹೇಳಿ. He will also be happy, everybody will be happy and we can pass the orders.
29.
Orally, if you make these types of submissions, tomorrow your officers will put you in dock. You have to be careful.
Yes.
ಹೊಸದಾಗಿ ಬಂದಿದ್ದೀರಾ ಪ್ಯಾನಲ್ಗೆ?
2 years ಆಯ್ತು.
ಇನ್ನ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಆಲ್ದು ಬಹುಶಃ.
I'll file.
Stage level, my land.
No, I'll tell you, you have to be careful about your own officers first.
I have made 2 representation for supervisory remarks. Again, I'll make one step.
ಗೊತ್ತಾಯ್ತಾ? You have to be very, very careful.
29th May.
You will have it on 29th.
Yes, ma'am. Interim order maybe.
The request of respondent number 2 and 3,
Yes.
Respondent number 2 and 3, call on 29th. ನಾವು ರೆಕಾರ್ಡ್ ಮಾಡ್ತೀವ್ರಿ ನಿಮ್ದು ಸಬ್ಮಿಷನ್ ನಾವು ರೆಕಾರ್ಡ್ ಮಾಡಿ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತೀವಿ.
ಅಲ್ಲ 2 ಸಲ ನಾನು ಮೇಲ್ ಕಳ್ಸಿದ್ದೀನಿ ಸ್ವಾಮಿ ಪ್ಯಾರವೈಸ್ ಕೊಡಿ ಅಂತ ಇನ್ನೂ ಕೊಟ್ಟಿಲ್ಲ.
Whatever it is, file an affidavit. File an affidavit saying that, then it will be dropped. Otherwise contest. You will argue on merits, you argue on merits. Don't make that kind of submissions. Be careful. Yeah.
Interim order maybe.
Interim order, if any, is extended till next date of hearing.
32. SB Totat. SB Prakash.
I appear for respondents 1 and 2.
Now they have served me the copy of.
My lord,
statement of
my
objections.
statement of objections is ready, my lord. I will file today in the registry.
The request of parties,
14.
call on
14.
14.
ಮಾಡ್ತೀರಾ 14th?
ಹೌದು, ಹೌದು.
14th date ಕೊಡಿ.
14-8. 33 Mastaq Ahmad.
My lord, I appear for the contesting respondents, my lord. I have filed a review, my lord, against the order to which, by which, my lord, the petitioner is seeking relief before honorable court. We have not received any notice from, my lord, in the previous petition as well as to the government, my lord, on verification I submit. Therefore, my lord, we have filed review petition, my lord, before the Honorable Judge. It is moved, my lord, is likely to come up shortly. May I request it for 2 weeks' time, my lord.
This is to be posted along with that review petition, at least.
ಈಗ ಅದ್ರ ನೋಟಿಸ್ ಆಗ್ಲಿ ಫಸ್ಟ್ ರಿವ್ಯೂ ನೀವು ಇದನ್ನ ಅದಕ್ಕೆ ಟ್ಯಾಗ್ ಆನ್ ಮಾಡಿದ್ರೆ ನಿಮ್ಗೆ ಪ್ರಾಬ್ಲಮ್ ಆಗತ್ತಾ?
ಆಗ್ಲಿ ಸರ್.
The request of respondent, call on date ತಗೊಳ್ಳಿ.
Much of it.
Date
Did
ತಗೊಳ್ಳಿ.
it?
2 weeks ಬಿಟ್ಟು ಡೇಟ್ ಕೊಡಿ. 30 ಹಾಕೋಣ? 30ನೇ ತಾರೀಕು.
Much.
34 Ajan. 35. Kumbar.
This is with regard to the valuation that they have to pay.
35. Monica Patil.
Last take is
KDB.
time.
Sought for, my lord, compensation in the mango trees regarding acquisition.
That in the joint meeting that they have already admitted and
That
wanted to
comes.
file.
None appears for respondent number 2 and 3. Pradeep, ನೀವೆಲ್ಲ ಏನಪ್ಪ ಇದ್ರಲ್ಲೇ?
That Monica Patil.
My name may be deleted.
Registry is directed to delete the name of HL Pradeep Kumar as advocate appearing for respondent number 2 and 3.
Last occasion that the matter was urgent for filing objections.
Good. None appears for respondent number 2 and 3. Call on 21st.
Please.
21st.
36 Chandrasekhar R.
Petitioner, this matter.
Suraj Patil.
For respondent number 2 and 3, my lords, we are yet to receive wakalat and instructions from the authorities, my lords. So any date after 1st of September, my lords.
That's too long.
Not September, my lord, I have sought only for mandamus, my lord. I have not challenged the acquisition. All that, my lord, as per the scheme, my lord, I am entitled for 40% of the developed land. But I am seeking for mandamus, my lord, for allotment of 40% development.
Yes, 21st.
My lords, at least 27th,
But
my lords.
interim order may
How do
kindly be extended.
Get these instructions over telephone itself. What is there? See, your policy says either monetary compensation
Scheme itself.
or land compensation, right?
Please, my lords.
You have to ask them whether you have the policy. Then second question, was the policy in force when his lands were acquired? See, earlier land acquisition, those policies were not there.
Very notification reflects, my lords.
ಇಂಥದ್ರಲ್ಲೆಲ್ಲ ಟೈಮ್ ಕೇಳ್ತಾ ಹೋದ್ರೆ ಇಟ್ಸ್ ಯುವರ್ ಇನ್ಎಫಿಷಿಯನ್ಸಿ. You should know it. On 21st I will call.
Interim order may kindly be extended.
And yes, at the request of respondent number 2 and 3, finally call on 21st.
At least 23rd, my lords.
What's your problem? Why 23rd?
No, my lord, senior counsel will be out of station, my lords. He'll be returning on 21st, my lords. So
23rd.
gratefully.
Interim order could be extended.
Interim order if any is, idya?
Yes.
Extended till next date of hearing. Yes.
Much of this.
37 Bhaskar Gowda. K Manu.
Petitioner, my lord. Lords, appear for respondent 2 and 3. Restricting my prayer to prayer B, my lord, seeking
Lords.
mandamus, my lord.
I'll file my statement of objections.
Lord, this is with respect to acquisition in the.
Wants to file his objections.
Yes, ma'am.
You file it in the office. At the request of,
In their RTA reply only, they have stated that they have no funds to release.
Respondent 2 and 3, call on 14th. I'll call it on day after tomorrow.
14,
Please, my lord.
38, Srinivas V.
My lord, I appear for petitioner in this case. My lord, ಇದರಲ್ಲಿ AGA ಬರಲ್ಲ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ ಏನಾದ್ರು ಮೂಡ ಬರುತ್ತೆ. ಮೂಡದಲ್ಲಿ we have served the Muda commissioner, my lord. In fact, either it should be any of the panel advocates. My lord. Morning, Sharat Gowda was directed to take notice. Same matters.
Same matters, huh? Okay.
Same matters. But
GB
ಅದು
Sharat-
ನಾಚನಹಳ್ಳಿ ಲೇಔಟ್, ಇದು ದೇವನೂರ್ ಲೇಔಟ್, ಅಷ್ಟೇ ಡಿಫರೆನ್ಸ್.
GB
You involved
Sharat Gowda
as
is
well.
directed to GB Sharat Gowda, Allah.
Yes, my lord.
GB Sharat Gowda is directed to accept notice for respondent number.
And those matters are posted
Respondents.
on 19th.
Call on 19th.
39, Suresh.
Writ of mandamus, my lord, there was a dispensi in the sketch.
Ready?
Writ of mandamus.
But I will consider this in accordance with law, my lord, within a stipulated period fixed by this court, my lord.
Yeah, what is the
Annexure F is the representation given by them. They say that the sketch is required to be rectified. Lords, it requires survey, my lords, inspection and survey, and thereafterwards we'll pass an order.
The revenue department itself, the revenue authority itself have said that I am in 71/5, my lord. Whereas in the BDA sketch, they have still maintained it as 71/4. That is the difficulty. And the adjoining landowners are filing, I'm filing the criminal complaints before the land grabbing court, my lord. That's the reason I'm before your lordship. The revenue authority itself have said that I'm in 71/5.
71/4 has been acquired, huh?
Yes, 71/4 is acquired, my lord.
71/5 is not acquired, huh?
No, it's not acquired.
71/4P was acquired.
71/4B, that extent was 3 acres 12 guntas. Out of that, 1 acre 12 guntas was acquired. And in the final notification, it was shown as 1 acre 12 guntas. And the award has been passed to one person called But my lord. Subsequently, the remaining land was left over. I am purchased that property and that is where I am in possession. And
But
RTC.
the case of the petitioner is that he is the owner of survey number 71/5 of Talgatpura village.
That is after poding. After poding, he claims that 71/5.
71/5 of Talgatpura village, huh? Talgatpura village. He is the owner of lands in survey number. Lands in survey number 71/5 of Talgatpura village. And the said lands was not acquired, and the said lands
Was given up.
has not been acquired by BDA, huh? Full stop. However, the sketch released by BDA in regarding the acquisition of lands in the said area, his land is also shown as
That is the area, that is the.
being acquired. Full stop. Hence, he has made a representation to the BDA dated 8/4/2024, requesting to correct the map in tune with the final notification regarding the lands acquired in Talgatpura village.
71/4P.
Full stop. As the same has not been considered, the present petition is filed. Full stop. Next, the learned counsel for BDA upon instructions submits that after commencement of acquisition proceedings, it appears some of the landowners have got their lands ported, because of which there has been an element of confusion. Full stop. He, however, submits that the map
FN sketch.
By the BD, the sketch.
FN sketch. We will conduct a survey pursuant to the FN sketch and we'll pass orders.
Yes. He further submits that the sketch issued pursuant to the final notification will be verified with respect to the lands acquired in the final notification once again. And if it is found erroneous, the same will be corrected.
Rectified.
Pass orders.
And pass appropriate orders.
In accordance with.
In accordance with law. Full stop. Hence his submission is placed on record. Hence the following order. Next, respondents are, respondent, respondent.
BDA, my lord.
BDA.
Respondents are directed to
3.
consider the representation of respondent number 3 now. Respondent number 3 is directed to consider the representation of the petitioner in accordance with law and pass appropriate orders within a period of 3 months from the date of receipt of certified copy of this order. Yes, the remaining matters are 2:30.
Adjournments?
Serial number 44, my lords.
Ah.
I've informed the other side.
Oh.
A week's accommodation, my lords.
40?
Vasant.
Uprit.
Uprit.
The request of respondent call date to
21st or 22nd. 22nd.
22nd.
Serial number 19 in the second list. Serial number 19 in the second list.
Second list, sir.
Lordship, I have it on 23rd.
Other side inform ಮಾಡಿದ್ದೀರಾ?
Ramu case.
ತಾವು ಯಾರಿಗೆ ಸರ್?
Respondents.
Respondent. 19 ತಾನೆ 19.
23rd ಬೇಕು.
ಅಲ್ಲ 19.
19, serial number 19.
ಹೇಳಿದಿರಾ ಅದರ್ ಸೈಡ್ಗೆ?
ಹೇಳ್ತೀನಿ ನಾನು. And may not reach also.
The request of respondent call on
23rd. 23rd.
23rd.
Please.
Yes. ಮಧ್ಯಾಹ್ನ ತಗೊಂತೀನಿ ಸರ್ ತಮ್ಮ. Ready.
Serial number 8. Your lordships kindly, my lord. Serial number 18 in the second list, my lord, B group. My lord, respondent number 3 has died, my lord. In June 2024, my lord, on that count only, my lord, I took time. And July 2024, my lord, I have filed 3 applications. Those applications are not put up and it is posted today, my lord, in preliminary hearing, B group. Maybe, as IS may be ordered to be listed.
Yes, serial number 18. Office is directed to put up the interlocutory applications said to be filed by
Petitioner.
that have been filed by the petitioner. We'll call next week.
Interim order to continue.
Interim order, if any, is extended till next date of hearing.
Serial number
17, my lord. Serial number 17, when last time they were suggested some, produce some documents, that evidence as well as documents in the lower court.
On behalf of
Anyway, I have not received, I have asked my counterpart at the Mangalore. Anyway, some time may be granted.
The request of petitioner call on date could be 2 weeks, but
Please.
My lord.
28.
Serial number 10, my lord. Respondent number 1, 2 weeks time days.
I'm for the petitioner.
Senior not well, ಹುಷಾರಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ.
the request for serial number 10, second list,
Second list.
all these matters second list.
Interim order may extend.
The request of respondent number 1, call after 2 weeks, interim order if any is extended till next date of hearing.
Acha.
Second list 20 serial, the next Monday. Next Monday, 10 days.
The request of petitioner call.
I am
after
the
2 weeks.
respondent.
You are respondent number 1, na?
Yes, my lord.
The request of respondent number 1, call after 2 weeks.
Pass over matters, pass over. 19, list 1.
Senior counsel is engaged in another court hall, my lord.
ಇವತ್ತು ಪಾಸ್ ಓವರ್ ಡೌಟ್ ಇವತ್ತು ರೀಚ್ ಆಗೋದು ಮತ್ತೆ ಪಾಸ್ ಓವರ್ ಬೇಕೋ ಅಥವಾ
Pass over, pass over.
ಪಾಸ್ ಓವರ್ ಆಯ್ತು ಪಾಸ್ ಓವರ್.
ಸುಭಾಷ್ ಶಾಸ್ತ್ರಿ.
ಬೆಳಗ್ಗೆ ಬಂದಿಲ್ಲ ಅಲ್ಲ?
ಬೆಳಗ್ಗೆನೂ ಬರ್ಲಿಲ್ಲ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿದ್ದೀರೇನ್ರಿ?
ಬಂದಿರಿ ಸರ್.
ನನ್ನ ಬೇಸದ ಪಟಿಷನ್ ಕಾಲ್ ಆನ್ ಒಂದು ಡೇಟ್ ಕೊಡಿ, ಯಾವ್ದು ಬಂದಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ.
Monday, 19th, 19/8. 24, pass over matter.
Yes.
Please.
My lord, sir. Housing board issues, the notifications under challenge for acquiring the subject property bearing survey number 231/1, measuring 2 acre 1 gunta of Rajapura village, Jigini Hubli, Hanikal Taluk. And my lord, sir, this preliminary notification issued on 2/12/2010. Final notification on 26/12/2012.
26?
12/2012. Well, sir, these notifications issued in the name of a dead person, one Jayama.
Notified ಖಾತೆದಾರ್ ಯಾರು ಸರ್? ಡೆಡ್ ಪರ್ಸನ್?
My lord, sir.
Father and mother, petitioner's father and mother.
No, notified ಖಾತೆದಾರ್ was dead person only, yeah?
Yes.
ಏನ್ ಮಾಡಕ್ಕ?
Jayama. And she died on 28/4/2008 itself.
Sir, that is not a, that will not help you, sir. RTC ನಲ್ಲಿ ಯಾರ ಹೆಸರು ಇರುತ್ತೋ ಅವ್ರ ಹೆಸರು ಇವರು ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡ್ತಾರೆ ಅಷ್ಟ.
Please, my lord, it is a fact that through a registered partition deed, the petitioner had acquired the subject property.
You should have.
That is a public notice as according to proviso to section 3 of
It has been
Transfer
held in
Property Act.
umpteen number of judicial decisions. The acquiring authority cannot make a roving inquiry as to who is the owner of the property concerned. They will issue notices in the name of the notified khatidar, that's all.
Lord, moreover, my lord, the petitioners appeared for the inquiry and they participated in the inquiry, my lord, then that question, my lord.
Yes.
Participated in the
Yes.
inquiry.
It is a fact, my lords, this petitioner filed objections, he participated in 5A inquiry. Even after that 5A inquiry, this final notification issued.
Hmm.
In that also, that notification issued in the name of dead person.
Doesn't matter.
And now, this CH had the actual notice. With
Doesn't
regard to
matter,
outlet.
sir. That is no ground, sir. That is no ground. That cannot be a ground for you.
No.
You say how acquisition is bad in law. If supposing your land was converted for non-agricultural purposes.
Yes.
Okay, number one. Was it converted for
Yes,
non-agricultural
it was
purposes?
converted for non-agricultural.
When was it
residential purpose.
converted?
Yes, my lord, the application was made on 20th of November 2010,
Ah,
prior to the preliminary notification itself.
hmm.
But that order was issued on 1/1/2011.
After final.
Not
after preliminary
what I am making.
Hmm.
And this date of order that dates back to the date of application, that is what under the, that is my contention.
Hmm.
And the scheme is not sanctioned as according to section 24(2).
Hmm.
And there is a delay.
ಎಷ್ಟು ಎಕರೆ ಇದು?
2 ಎಕರೆ 1 ಗುಂಟೆ ಇದೆ.
Hmm.
There is a delay of for final notification, my lords, 1 year delay
Hmm.
from the date of preliminary and final.
Hmm.
And there is also delay of
ಇವಾಗ ಯಾರ ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇದೆ ಲ್ಯಾಂಡ್?
still we are in possession and there is an interim order to maintain status quo regarding possession, my lords.
ಏನ್ರಿ? ಯಾರ್
Before passing award itself.
Lord, the preliminary notification was issued, my lord, on 2/12/2010.
Hmm.
Lord, the so-called, my lord, the conversion order is, my lord, subsequent to the preliminary
It's
notification.
all right, they had made an application before that itself. Hmm.
Lord, that, my lord, even, my lord, assuming that, my lord, they made application, my lord, even if it is converted land, there is no bar to, my lord, state to acquire, my lord, the converted land, my lord, exercising power of eminent domain. That can be, my lord, that, my lord, the conversion, my lord, is only taken into consideration when, my lord, issue, my lord, dispersing the compensation. That, my lord, aspect, my lord, will be looked into. Lord, 6/1, my lord, is within time, my lord, we have passed award within time. Thereafter, my lord, the petition came to be filed, my lord. Lord, we have advised them to, my lord, take 50/50 land sharing, my lord.
I think that's a fantastic concept. 50/50 ಕೊಡ್ತಾರಂತಲ್ಲ. Put it to your client, you will get a developed land 50/50.
You can opt for any, my lord, sites, even, my lord.
Actually, 1,35,00,000 per acre is awarded, my lords. 15 ಅಲ್ಲಿ award ಆಗಿರುವಂತ ಅಮೌಂಟ್ ಅನ್ನು ಆಗಲೇ ಕಲೆಕ್ಟ್ ಮಾಡಿ ನಾವು ಇನ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ಇವತ್ತಿಗೆ ಅದು crores together ಆಗಿರೋ. That we have not. Now that see in the year 2015, this award is passed. Per acre 1,35,00,000 is the award.
Received the compensation.
No, he did not.
ಹೋಗ್ಬಿಟ್ಟು at least invest ಮಾಡಿದ್ರೆ that would have been fetched more than this.
He did not,
ಈಗ
my lord.
now that 50/50, my lords, at least that is where that I requested the learned friend. ನಮ್ ಕನ್ವರ್ಷನ್ ಆಗಿದೆ at least. provide us,
Government policy,
some
my lord, we
remote
cannot
one.
even.
Government policy, he cannot change it.
It's not private negotiation.
Not possible, and 50/50 is very reasonable. You have to be reasonable, counsel. You have to be reasonable. 50/50 is a very reasonable proposition.
Comparing to that, the compensation, my lords,
Compared to
very,
compensation
very less.
also it is reasonable. The reason being, the land, ನೀವು ಅದನ್ನ ತಗೊಂಡಿದ್ರು ಎಲ್ಲ ಹಾಕ್ತಿದ್ರಿ, ಲ್ಯಾಂಡ್ ಮೇಲೆ ಹಾಕ್ತಿದ್ರಿ ತಾನೆ?
ಇಲ್ಲಿ ಎಲ್ಲಾದ್ರೂ ಇನ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ಆಗ್ತಿತ್ತು.
Here also, the same rate will have increased. Put it to your client and get back. I think that makes a lot of sense. If you want, I will reserve that liberty and I will dispose of the right position.
Even the award is passed after crossing the limitation under the law, my lords.
No.
And section 11A, even New York,
Sir,
that
you
goes.
have two options. One, he can argue on merits. One, he can take that 50/50 compensation. What do you want?
So for us, taking that 50 ratio, my lords, that may not work out for us now. That compensation amount is.
Okay, go on with the matter, sir. Then. Yes,
Where that I'm.
go on with the matter.
Please.
Go on with the matter. Yes.
It is a converted land, at least they let them provide a convenient place,
Sir,
at least
this is-
50% ಆದ್ರೂ
Sir,
ಕೂಡ.
this is what the best they can offer. This is what the best they can offer. We cannot force them. The only question that we can look into now is, see, if you take that 50%, I can direct within 3 months, do the needful.
At least ಕನ್ವೀನಿಯಂಟ್ ಟು ಮೈ ಕ್ಲೈಂಟ್ ಎಲ್ಲಿ ಅಂದ್ರೆ ಯಾಕೆಂದ್ರೆ ಈ ಪ್ರಾಪರ್ಟಿಲಿ ಕೊಟ್ಟ STPP is formed just behind this property, my lords. Therefore, at least convenient to the petitioner, let them provide even 50%.
Convenient to petitioner ಅಂದ್ರೆ
He notified the,
ನೀವು ಅಲ್ಲಿ ನಿಂತ್ಕೊಂಡು ನಂಗೆ ಇದು ಕೊಡು ಇದು ಕೊಡು ಅಂತೀರ.
ಈ ನೋಟಿಫಿಕೇಶನ್ ಇಲ್ಲ ಈ ನೋಟಿಫಿಕೇಶನ್ ಆಗಿರುವಂತ ಪ್ರಾಪರ್ಟಿಯಲ್ಲೇ ಈ ನೋಟಿಫಿಕೇಶನ್ ಆಗಿರುವಂತ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ಎಲ್ಲಾದ್ರೂ ಒಂದು ಪ್ರೊವೈಡ್ ಮಾಡಿ.
Your land ಅಲ್ಲೇ ಕೊಡ್ರಿ 50%.
ಕೊಡ್ತೀವಿ sir.
Developed area.
Lord, they are asking for Lord some other good Lord sites. Lord, that we cannot say Lord that they have to go and work on.
50% in their
ಕೊಡ್ಬೋದು
land
sir.
only you give.
ಅವ್ರದಲ್ಲಿ ಕೊಡಕ್ಕೆ we don't have any objection. Lord.
We have no objection. ನಿಮ್ದ್ರಲ್ಲೇ ಡೆವಲಪ್ ಸೈಟ್ ಸಿಗುತ್ತಲ್ಲ 50%.
ನಮ್ಮದ್ರಲ್ಲೇ ಅಂತಂದ್ರೆ ನಮ್ಮ ಪ್ರಾಪರ್ಟಿ ಮೇಲ್ಗಡೆನೆ ಒಂದು STPP ದೊಡ್ಡದಾಗಿ ಮಾಡಿದ್ದಾರೆ. That I mean not worth my lords at least wherever same note. ನಮ್ಮ ಒಂದು ಪ್ರಾಪರ್ಟಿ ಮೇಲೇನೆ ಒಂದು STPP ಬರ್ತಿದೆ ದೊಡ್ಡದು ಮಾಡ್ತಿದ್ದಾರೆ as according to their plan. And if that comes, my lords, see our property may not fetch the proper value ಅಂತ. ಹಾಗಾಗಿ convenient to the petitioner in the area where this the property is notified under.
Let this case, my lord, disposed of, my lord, reserving liberty to take 50%. Let them go on, my lord, approach there in board, my lord, they can always, my lord.
See, ಅದು unless they consent, no, we cannot pass such a direction. Because law does not say so. If you want to adjourn it, think over and come back. ಇಲ್ಲದ್ರೆ you will have to take your chance arguing on merits. See, land ಅಂದ್ರೆ ಏನಾಗುತ್ತೆ ಈಕ್ವಲ್ ಡೆವಲಪ್ಮೆಂಟ್ ಆಗುತ್ತೆ. ಇವಾಗ ಇಲ್ಲ ಕಾಂಪನ್ಸೇಷನ್ ಅಂದ್ರೆ see you will get 2010 compensation along with interest thereon. It's of no use whatsoever. 50% land ಅಂದ್ರೆ 3 months allowed. ಕಾನೂನು ಏನಿದೆ ಅದ್ರ ಪ್ರಕಾರ ಮಾಡ್ತೀವಿ ಸರ್, ನೀವು ತೋರಿಸಿ ಬೇರೆ ಕಾನೂನು ಇದೆ ಅಂತ ವಿಲ್ ಗ್ರಾಂಟ್ ಯು ಬೆನಿಫಿಟ್, ಅದರಲ್ಲಿ ಏನು ತೊಂದರೆ ಇಲ್ಲ. ಶೋ ಮಿ ದ ಲಾ.
And so far as that very same village, my lords, see earlier to this notification, there were see other notifications under which all that converted properties are released.
Sir, if you want to argue, you can argue, sir. After hearing, I don't know what decision I'm going to make. In accordance with law, I'm going to pass my orders, considering both your arguments.
I'll discuss with my client and then, so far as 50%.
See, at the end of the day, it's your land. Justice should happen to you. You got it? No, Dre, similarly placed persons.
Not in this, my lord, in this notification, my lord, we, my lord, proposed for acquisition of 61 acres. Lord, we acquired 59 acres, only we left out 2 acres, my lord.
When in this notification also, they released a 2 acre 28 gunta. That is there, my lords. Discrimination is there.
It has been substantially otherwise implemented.
In the interest of some mut, my lords, this additional notification is
50% development
only
land,
for
my
the
lord,
smaller
it's a good
extent.
offer, you can not have for that, and it's a good offer, my lord, you can, my lord.
50% is a very good offer, sir.
That is where that time, say, I'll convince my client at least wherever convenient to him in the very same notification, my lords, not asking.
See, that may not be possible. There is no law for us to issue a direction to them unless they agree for it. ಸರ್, ನಮ್ಮ ಡೈರೆಕ್ಷನ್ಸ್ ಕಾನೂನಾತ್ಮಕವಾಗಿರ್ಬೇಕಲ್ವಾ? ಈಗ 50% ನಿಮ್ಗೆ ಎಸ್ ಅಂತ ಯಾಕೆ ಹೇಳ್ತೀವಿ ಹೇಳಿ? ಅವ್ರ ನೋಟಿಫಿಕೇಶನ್ ಇದೆಯಪ್ಪ. ಅವ್ರ ನೋಟಿಫಿಕೇಶನ್ ಇಲ್ದಲ್ಲ ಇದ್ರೆ ನಾವು 50% ಕೊಡಿ ಅಂತ ಹೇಳಕ್ ಆಗ್ತಿತ್ತಾ? ಅಲ್ಲ, ಆಗ್ತಿತ್ತಾ ಹೇಳಿ? ಆಗ್ತಿರ್ಲಿಲ್ಲ. ಇವ್ರಿಲ್ಲ 80% ಇದೆ ನಮ್ಮ ನೋಟಿಫಿಕೇಶನ್ ಅಂದ್ರೆ 80% ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ. ನಿಮಗೆ ಚಾಯ್ಸ್ ಇದೆ ಅಂತ ನೋಟಿಫಿಕೇಶನ್ ಇದ್ರೆ ಅದ್ರ ಪ್ರಕಾರ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ. ಬಟ್ ಆತರ ಇಲ್ವೇ ಅಲ್ವಾ? This is what you need to look at.
I'll discuss with my client and
When do you
make my
want that?
submission.
When do you want that?
Next week. Next week.
Next week.
19 ಹಾಕ್ಬೋದಾ?
ಆಗ್ಬೋದು. ಆಗ್ಬೋದು.
ಅಷ್ಟೊಳಗಡೆ ಒಂದು ಇತ್ಯರ್ಥಕ್ಕೆ ಬಂದ್ಬಿಡಿ.
That is also we discussed and see
Lord, I have
brother that ಅವ್ರ ಅಫಿಷಿಯಲ್ ನ ಕೂಡ ಕರೆದ್ರು. ಎಲ್ಲಿದೆ, ಏನ್ ಅವೈಲಬಿಲಿಟಿ ಇದೆ ಅಂತ. They have not brought, I think, that sanctioned plan and
ಈಗ if it can be resolved, Lord can indicate where you are going to allot.
That's why, Lord,
that also we will see ಏನಾಗುತ್ತೆ ಗೊತ್ತಾ?
ನಾನು ಎಷ್ಟೇ ಉತ್ತರನೇ ಕಳಿಸಿದ್ದೆ, ತಾವು ಹೋಗಿ ಮಾತಾಡಿ.
Listen, ಅವ್ರು ಹೋಗಿ ಮಾತಾಡಿದ್ರೆ ಇವಾಗ ನಾವು ಡಿಸ್ಪೋಸ್ ಆದ್ರೆ ಏನಾಗ್ತದೆ, ದೇ ವಿಲ್ ಬಿ ಅಟ್ ದೇರ್ ಮರ್ಸಿ. ಆಯ್ತು. ದ learned counsel for KADB submits, KHB submits that as per the policy of government, the state, petitioners are also entitled for petitioners are entitled also are entitled for 50% of the developed land, equivalent to 50% of the 50% of the developed land, in lieu of monetary compensation. Full stop. KHP is directed to verify and state where the land can be granted to the petitioner and to what extent by next date of hearing. Call up. 19th.
Please.
ನೀವು ಕೂತ್ಕೊಂಡು ನೋಡಿ ಅದು ಆಗುತ್ತಾ 19th ಇದೆಲ್ಲ 22nd ಕರಿತೀನಿ. 23rd ಕರೆದ್ಬೇಡ, ಯಾಕಂದ್ರೆ 2 ದಿವಸ ವರ್ಕಿಂಗ್ ಇರೋದು. Not well on it. ನೀವು ಅಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಏನೋ ಒಂಚೂರು ಇದನ್ನ
Now we already discussed, but the officials are not cooperating, my lords. That is where the
strength of this order. ಅದಕ್ಕೆ this observation I made.
please, that is where that I.
You can just pursue ನೋಡಪ್ಪ ಕೋರ್ಟ್ ಹಿಂಗ್ ಹೇಳಿದೆ ನೀವು ಎಲ್ಲ ಮಾಡ್ತೀರಾ, ನೀವು ಹೇಳ್ಬೇಕಂತ ಹೇಳಿದ್ರೆ ಅಲ್ಲೊಂದು ಇಂಡಿಕೇಶನ್ ತೋರ್ಸಿದ್ರೆ ಕೂತ್ಕೊಂಡು ಏನಾದ್ರೆ they can convince them or whatever. By next date of hearing ಒಂದು ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಬಿಡ್ಬೋದು.
Please.
And you can dispose of the writ petitions. Direction ಕೊಟ್ಟು ಮಾಡಿದ್ರೆ
ಸರಿ.
So 3 months allot ಮಾಡ್ರೆ ಅಂದ್ರೆ ಎಲ್ರಿಗೂ everyone will be happy. It's a win-win situation. See, ask your officers to be sympathetic to land losers. The end of the day ಅವ್ರದಲ್ಲೇನ್ರಿ ಜಮೀನು ದೊಡ್ಡವ್ರಿ ಅಂತ ಅವ್ರಿಗೂ. Be considerate, ask them to be considerate. Sir, beyond that, we can't do anything.
Please,
We have to go by law.
Yes, sir. My lords, ours will compel the officials at least to come forward for where the property is available and to.
See, under the circumstances, this is the best I can do for you.
Please, my lords.
Just see what you can get out of it. Otherwise, we can't help.
Please.
ಮುಗಿತಾ ಪಾಸ್ ಓವರ್? ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
41 LM ಚಿದಾನಂದಯ್ಯ.
In this matter, my lord, state government want to file objection. See, kindly have it on 19th, my lord.
ನಿಮ್ಗೋಸ್ಕರ ಇವಾಗ ಹಾಕೊಂಡಿದ್ರಿ, ಡೇಟ್ಸ್ ಕೊಟ್ಬಿಟ್ಟು ಹಾಕಿರೋದಲ್ವಾ?
ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ಈಗೂ ಬೇರೆ ಕೇಸು ಹಾಕಿದ್ದಾರೆ, ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಅಬ್ಜೆಕ್ಷನ್ ಆಗ.
ಆಯ್ತಪ್ಪ, ಇಟ್ಸ್ ಆಲ್ರೆಡಿ. ಏನಿದೆ ಹೇಳಿ, ಏನ್ ಹೇಳಿ ಇದು? ಏನಂದ್ರೆ 77 ಕೇಸು, ನಮ್ಗೊಂದು ಒಳ್ಳೆ ಡಿಸ್ಪೋಸಲ್ ಆಗ್ತದೆ ಅಂತ ನಮ್ಗೆ.
ಒಂದೇ ಕೇಸಲ್ಲಿ 75 ಇದೆ, ಇನ್ನೊಂದ್ರಲ್ಲಿ 75 ಜನ ಇದ್ದಾರೆ.
Yes.
The landowners of survey number 83, 86 formed a layout by taking the permission from Kodigahedi Gram Panchayat. Annexure A, page 35 is the approved layout. These landowners sold these lands and sites formed on different dates much before the preliminary notification. In the case, my
revenue site, sir. Revenue site or developed land?
Development. Now the sites are there.
Sorry, revenue site or converted land?
But this is the revenue sites.
Unconverted revenue.
Yes.
Junjama apply agata?
Junjama, now in fact, in this case, they themselves have already passed a resolution that they will give up these lands and they sent it to the state government. The state government, keeping it for more than 10 years, it says, on the statement of objection, they rejected the proposal of the BDA to delete these lands. Now there are.
BDA recommended deletion.
BDA recommended.
BDA can only recommend.
Of course, we know.
Rejection is 2017.
Did you recommend deletion?
It is, it is.
You recommended deletion.
But there was a resolution.
That is
There was a
rejected in
resolution. No, no, we filed-
2017. 2017 itself rejected.
Correct. New deletion recommend madadra.
No, we filed a memo before the court pursuant to the resolution passed with the BDA. In respect of certain revenue sites, my lords, we will recommend it to the government for taking appropriate action. Government has rejected it now.
Okay, government has.
Annexure M, page 67 is a resolution.
2017.
Okay, ಎಲ್ಲಾದ್ರಲ್ಲೂ BDA recommend madadra.
In all cases, they inspected and found, this is a full-fledged township has come, it's called Aniketana Nagara, the area.
Particular case ಅಲ್ಲಿ ಮಾಡಿಲ್ಲ. General ಆಗಿ it was recommended.
Niketa Nagara layout.
Of the revenue sites. Recommend, not for the particular layout.
ಆಯ್ತು ಇವಾಗ ಏನ್ ರಿಲೀಫ್ ಕೊಡು ಜುಂಜುಮ ಕೇಸ್
ಇವಾಗ division bench ಮೇಲೆ very same layout is concerned ಮೇಲೆ.
No, that will not apply.
Following the Junjama case, they have directed the revenue site holders to make the application and similar direction where they have to register.
For an alternative site.
Alternative site, there is a similar direction was issued. The order portion is annexure R2 to my statement of objection in first case.
ಫಸ್ಟ್ ಕೇಸ್ ಕೊಡ್ರಿ.
First case ಅಲ್ಲಿ R2 ಅಲ್ಲಿ
ಯಾವ ಕೇಸಲ್ಲಿ ಯಾವ ನಂಬರ್
judgment. ಎಲ್ಲ ಕೇಸ್
ಅಲ್ಲ ನೀವು ಫುಲ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ಅದನ್ನ ಐ ಪ್ರೊಡ್ಯೂಸ್
ನಂಬರ್ ಹೇಳಿ ಕೃಷ್ಣ.
1438.
ಕೃಷ್ಣ ಅವರ ನಮ್ಮ ಕೇಸ್
First case 14,585.
ಅಲ್ಲಲ್ಲ ಇದು ರಿಟ್ ಅಪೀಲ್ ನಂಬರ್ ಹೇಳಿ.
WA 1783 of 2014.
that is
connected matter.
may I submit?
Sure, sir. Sure, I'll hear you. 1783 of
1783 of 2014 and batch of connected matter.
ಈ ಲ್ಯಾಂಡ್ಸ್ ಇನ್ವಾಲ್ವ್ ಆಗಿದೆಯಾ?
Same
ಇಲ್ಲ
layout.
ಈ ಲ್ಯಾಂಡ್ ಇನ್ವಾಲ್ವ್
ಇಲ್ಲ ಇದು ಎಂಟೈರ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಎಂಟೈರ್ ನಡಪ್ರಭು.
Village ಸೇರಿಕೊಂಡು ಎಲ್ಲ all the entire notification is concerned ಮೇಲೆ this is given.
ಇದು ಬರ್ಕೊಳ್ಳಿ ಇದು 1783 of 2014 ಇದೊಂದು ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹೇಳ್ತಾರೆ. 1783 of 83 of ಇದು ಕೋರ್ಟ್ ಆಫೀಸರ್. ಪೂರ್ತಿ ಇಲ್ಲ ಅನ್ಸುತ್ತೆ. ಇದೆಯಾ ಪೂರ್ತಿ ಇದೆಯಾ?
The entire mallet is not produced. This land is not there. Secondly, mallet, the division bench has not dealt with what is the issue raised by us. No award is passed in last 14 years.
Okay.
That was not the issue raised in that writ petition.
I think we have to hear the state government, so we'll fix it.
As state government has to be heard for the reason. Meanwhile, they have to produce the record before your lordship's mallet. They produce one letter and then they try to justify based on the division bench judgment. In fact, the BDA has taken a decision made on 18/12/2010 that all these revenue sites, they are full-fledged layout, therefore they should not be acquired.
Now, these are individual site owners or?
They're all individual site owners. The landowners have also given a affidavit to the BDA stating that that they have already sold the land.
They have also resolved to take up to 275 rupees per square feet as betterment charges. In the same resolution, they have stated.
In fact, subsequently, they pass a resolution that they want to take 270. We said we have agreed to pay 270 per square feet for the development of the layout. Already the owner and
Recommendation is rejected by the government.
now they file objections stating that you surrender your existing houses, built houses, which they have built with their life and toil. And they want to ask us to apply for an alternate site which is going to be given somewhere else. That is, there is no consideration. When they have taken several writ petitions were filed before this court. They filed a memo before this court saying that they have already taken a decision to delete these lands from the acquisition proceedings. But suddenly, bolt from the blue, after 14 years, the government takes a decision. No, it is not permissible to delete these lands from the acquisition. Let the state government file objection and also let them produce the record before lordship. That will completely reveal what exactly happened from the date of preliminary notification till date.
Yes. The state is directed to file objections. ಏನ್ ಬೇಡ ಬಿಡಿ. The request of AGA call on ಯಾವತ್ತಪ್ಪ?
26th.
26th ರಜಾ ಇದೆ.
28th.
Interim order may be continued.
Objections if any by then. Interim order if any is.
Meanwhile, direct them to produce the records to the lordship.
Please continue till next date of hearing. Next para. The case of the petitioner is that They are all revenue site owners and they have constructed houses on the property concern. Property concern, full stop. It is further submitted that BDA also recommended for deletion of the said properties from acquisition.
The petition of property, it is general in general.
Entire, totally 14 acres.
Sir, it doesn't matter. What is whatever is applicable. Full stop. However, the state government has rejected the same.
Yeah, 2017 itself.
Full stop. For that reason, Learned DAG is directed to, for that reason, the state government is directed to file the affidavit of a responsible officer stating the reason for not accepting the recommendation of BDA BDA and also state whether similarly situated lands have been left out from acquisition or not. Call on. Yes, ಎರಡು ಬರ್ಬೇಕು. ಅದು ಬಂದಿದಲ್ಲ ಡೇಟು ಅದನ್ನ ಇಲ್ಲಿ ಕೆಳಗಡೆ ಹಾಕೊಳ್ಳಿ ಅಷ್ಟೇ ಮೇಲೆ
Interim order.
ಕಾಲ್ ಆನ್ ಅದು ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಇಫ್ ಎನಿ ನೆಕ್ಸ್ಟ್
28.
Sorry, 28.
28 ಕಾಲ್ ಆನ್ ಸ್ವಿಚ್
Please. 42, 43.
ನೋಡ್ರಿ ಇಡೀ ಬೆಂಗಳೂರಲ್ಲೇ ಯಾವ್ದಾದ್ರೂ ಲ್ಯಾಂಡ್ ಆನ್ ದ ಗ್ರೌಂಡ್ ಇಟ್ ಈಸ್ ಆಲ್ರೆಡಿ ಡೆವಲಪ್ಡ್ houses have constructed.
ಇದರಲ್ಲಿ full ಎಲ್ಲ
All temporary structure.
Denotify ಮಾಡಿದ್ರೆ you have to denotify these lands.
Yes. We have done number of cases.
ಅದಕ್ಕೆ ಹೇಳಿತ್ತು ಹಾಕ್ಲಿ ಅಂತ.
Exactly.
Division bench order, my lord, there is.
My learned friend Krishna is obsessed with the division bench order. It doesn't deal with that issue.
Sections are there, my lord.
No, comprehensively it is being dealt with, my lords.
No, it's not dead.
But in an identical situation, Supreme Court, the
It's not
division.
correct.
45, Sundaresh, HT Basuraj. 45, list 1, 45. HC Sundaresh, HT Basuraj.
Please. I am for Sundaresh Motso, he is not in station. Kindly consider the representation in accordance with that.
ಸಾಕು ಅಷ್ಟಾದ್ರೆ
sir. ಅಷ್ಟೇ ಇರುತ್ತೆ. So cancel the.
ಖುಷಿ ಅದು ಆ ಸಬ್ಮಿಷನ್.
To cancel the lease cum sale agreement by oversight by mistake, the BDA has executed the lease cum sale agreement in favor of Shiv Prakash. Earlier, the Devikarani was allotted and said it was executed in favor of Devikarani. By oversight, the same site was said it was executed in favor of the Shiv Prakash. Hence, we sought for it was reflected in the income certificate. That's why I sought for deletion of such a.
You sought for cancellation of what?
Cancellation of lease cum sale agreement.
Lease cum sale deed.
Executed in favor of?
On the Shiv Prakash.
MP Shiva Prakash.
Should you not make that person a party to the proceedings?
No, but he sought, he filed writ petition for seeking an alternative site. It has been allowed. By oversight, let's say it was executed in favor of Devikarani. By oversight, same site was lease cum sale agreement executed in favor of Shiv Prakash.
Who is Shekhar?
Shekhar is subsequent purchaser. He has purchased the property from the original at Devikarani.
How could you purchase without sale deed being executed?
No, after completion of lease cum sale agreement, I have purchased the site from the Devikarani. By oversight, the same site is executed.
Even otherwise, without taking permission of BDA, how could you have purchased?
Not BDA, see, already lease cum sale agreement has been, condition is over. Period of.
Sir, even otherwise, how could you purchase? Tell me, how could you purchase
But
when it was lease cum sale agreement?
See, sale allotment letter was issued in favor of Devikarani and also sale deed was executed in favor of Devikarani.
Where is the sale deed executed in favor of the?
I produce that.
After sale deed, yes, you can purchase. There is
Yes,
no-
After purchase.
Yes, no, after sale deed only.
Learned. Allotment letter was issued on 24/10/2007 in favor of Devikarani.
by the BDM.
Sale deed
Then
also
sale deed was executed on 28/11/2007.
in favor of Devikarani.
In favor of Devikarani.
Yes, my lord.
Thereafter, my lord, 22/2/2008, my lord, Devikarani executed a sale deed in favor of the present petitioner.
Petitioner.
Then, my lord, by oversight, my lord, 28/10/2009, my lord, BDA has executed a lease cum sale in favor of one MP Shiva Prakash.
BDA has committed mistake, my lord.
We will consider the representation in accordance with law.
What consider? You have to set aside the lease cum sale agreement.
Yes, madam, it has to be set aside.
We will consider.
Yes. Site number 33 bar B. 37th cross. 28th main. 9th block Jayanagar. Bengaluru 69. Was allotted in favor of one Srimati L. Devikarani by BDA. Full stop. Thereafter, SL deed also was executed in our favor on 28/11/2007. Correct,
Sale deed, absolute sale deed.
How the
This one, 28/11/2007.
2007. Full stop. Thereafter, the said Devikarani has sold the property in favor of 22nd 2008. Thereafter, the said Devikarani has sold the property in favor of the petitioner herein by a registered sale deed dated
22/2/2008.
22/2/2008. Full stop. To the horror of the petitioner, he later discovered that the petitioner has executed a lease cum, the petitioner, that the BDA has executed a lease cum sale agreement in respect of the very property in favor of one
MP Shiva Prakash. MP Shiva Prakash.
MP Shiva Prakash. MP Shiva Prakash. Full stop. Agreed by the same. He has made a representation to the BDA to take necessary action to cancel the said lease cum sale agreement in favor of MP Shiva Prakash. Full stop. As no action was taken by BDA, the present writ petition is filed. Full stop. Next para. The counsel for BDA upon instructions submits that BDA realizes this mistake, and in the meanwhile, the said MP Shiva Prakash filed a writ petition seeking an alternative site.
Well, alternate site he gave a representation for cancellation of
Shiva Prakash.
Shiva Prakash.
He filed writ petition for seeking alternative site. It's correct, my lord.
Please.
What did Shiva Prakash do?
Shiva Prakash.
Okay, you have taken steps, you have cancelled the lease cum sale agreement.
Please, man. Shiva Prakash.
And has taken steps to cancel the lease cum sale agreement executed in favor of MP Shiva Prakash by allotting him an alternative site, alternative site.
Yes.
And he further submits that the request of the petitioner shall be considered in accordance with law and appropriate action will be taken within a period of 3 months. 3 months.
Yes.
Full stop. His submission is placed on record. Full stop. Next para. Hence the following order. Madabod tane?
Madabod.
Respondents are directed to consider the request of the petitioner.
Representation dated
Representation of the petitioner in accordance with law and take suitable action regarding cancellation of and take suitable action to redress this grievance within a period of 3 months from the date of
For cancellation of lease come agreement.
Annexure H, Annexure H, and we'll consider the representations.
Sir, I would have passed that order if you had made Shiv Prakash a party to the proceedings. He becomes a just and necessary party to the proceedings under the given circumstances of the case.
Already he was allotted another site now.
So what?
That the mistakes committed with the
Have they
BDA.
said that?
No, man.
Have they said that it has been allotted? Have they said that it has been allotted? Then see, ನೀವು ಕೇಸ್ ಹಾಕ್ತೀರಾ ಕೇಸರಿ ನೀವು ಅಂದ್ರೆ whoever has filed it. ಕೇಸರಿ ಆಗಕ್ಕಲ್ಲ ನಾವೇನ್ ಮಾಡ್ಬೇಕು?
ಅಲ್ಲ he is not. Sundaresh.
ಆಮೇಲೆ ಕೋರ್ಟ್ಗೆ ಆರ್ಡರ್ ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ಹೇಳೋದು.
See, he is not well man. That's what I was instructed.
ಅದಲ್ರಿ.
I do agree.
ಈಗ ನಿಮ್ಮ ಸೈಡ್ ನ ಬೇರೆಯವ್ರಿಗೆ ಅಲಾಟ್ ಆಗುತ್ತೆ. Actually, we are deciding the right of that particular gentleman. Now, will he not become a just and necessary party? In fact, the writ is liable to be thrown out for not making, but Allah cancel martini. Make him party to the proceedings.
What does the lordship has that?
From the date of receipt of certified copy of this order.
Sorry, my lord. Much.
The previous sentence ಏನು ಅಂತ ಹೇಳಿ directed to consider his grievance ಅಲ್ವಾ redress his grievance ಬಂತ. Right. 46 Suraj Sampath.
My lords, the matter pertains to HSR complex, my lords. My lords,
although this pertains to the same complex, my lords, I am not similarly situated to the other tenants who have approached this court, my lords, and some matters have been disposed, my lords. How I may be able to kindly be permitted to show, my lords? My lords were to come to page 56, my lords, which is Annexure J, which is my license agreement. This is executed by the BDA subsequent to the concession agreement. The concession agreement is 22nd of March 2018, my lords. I am given a license by the BDA for the very same complex in November, this is November 24.
Page number?
1 second, my lords. Page number 40, my lords, Annexure D. 5th July 2018, which is admittedly subsequent to the concession agreement. My lords will find the concession agreement at page number 78. In fact, my lords, from what I understand, this is the only petition, my lords, where the concession agreement itself has been produced as an annexure and where I am relying on reliefs under this concession agreement. Everybody else who has approached this honorable court has sought for not to demolish the project or not to, and just to quash the eviction notices. I, on the other hand, have sought for relief under the resolution as well as this concession agreement. This is at page 78, 22nd March 2018, my lords. So I have 2 units. One is, both are on the ground floor, my lords. In fact, one of my units is the biggest units in this complex. I'm running a restaurant in that, my lords. It's in the center of the property. It's 5,560 square feet, my lords. And another one is a 470 square foot shop. Admittedly, both of these shops are paying market rent, my lords. These are all picked up by the petitioners in a public auction. Every 2 years, there is an
duration of license.
Initially in 2004, I've picked it up, my lords. They have been extended in 2017 and 18, my lords.
Now
those agreements are produced.
Now this is 2018.
Yes, my lords.
How many years?
5 years, my lords.
It's expired, no?
It's expired, undoubtedly it's expired, my lords. But I have sought for reliefs not to stop the project. I think if the court were pleased to see my reliefs that I've sought for, my lords. First two prayers are for washing of the eviction notices, my lords.
Why?
Under the concession agreement, there is a duty on the BDA to ensure that I move to the makeshift market, my lords. Their duty is not to evict me or to give vacant position to the concessioner. It is to move me to a makeshift market. Nowhere in the eviction notice do they say, please leave. I'm giving you this alternative space as a makeshift market. I'll take my lords through the agreement itself.
Okay, next.
Where 3-4 places it is there. my
Okay,
lords.
next.
Can I point out the clauses where it?
Next, I will take it as you say. Is a
Please, my
cause.
lords.
Next.
Then also what I've sought for is to reallot in the final, after the project is developed, to reallot in the new building that comes up in that place. All of this is in terms of both the minutes of the meeting, the resolution passed by the BDA in its own meeting, and in terms
What
of
about the makeshift market?
Then as per the resolution, the concessioner has to rehabilitate into some other place. First thing is also have to view from this property. After he leaves, then we have to rehabilitate him once he leaves the property. If he sits on the property and.
Yes, we'll direct them to do so. We'll direct them to do so.
Allah, their notice itself doesn't talk about rehabilitation.
We will say so.
The agreement clearly specifies it is not just the concessioner's duty. It is BDA's duty to make sure I move to my lords, I am somebody who has been there at the property for 20 years. I'm paying market rent. It's not that I've got a nominal rate of rent that I'm paying and I'm taking advantage.
We'll ask them to do so. Anyway, license agreement has expired. Bunny.
Allah, but also, my lords. Lords,
may I submit, my
I
lords?
also have some citations, my lords, before my friend
For
would
what?
finish. On the point, my lords, whether an agreement whether it's expired, whether it's deemed to be expired as on today because the written agreement has expired, my lords. Whether there can be an oral agreement. It is undoubtedly a situation where they're issuing challans to me. I am paying those challans.
You become a tenant holding.
My lords.
Allah, even if it's deemed as month to month, my lords. One, I'm not going on the aspect of whether I should be evicted by following due course of law, all of that, my lords. I'm on the point that I am wanting to continue in your project, in your new project. In the meanwhile, according to your own agreement, where it's set out in at least about 15.
Giving that relief, no?
Advanda Swami, other bit to whether on the point of.
The point of what? You have to vacate the property.
My lord. I am ready to vacate, my lords, provided they give me a makeshift place is one of my contentions.
Yes, Bunny Purple.
Petitioner
May I
has
pass
filed
on the
earlier
citation?
petition.
The petitioner is a licensee in a BDA complex situated at
HSR
complex.
HSR layout. Full stop. The license agreement was executed on 5/7/2008. The license agreement was last renewed on was last renewed on 5/7/2018. Full stop. It was to remain in force for a period of 5 years. Full stop. Even thereafter, petitioner has continued to run his run his business from the premises. Full stop. In the meanwhile, even a few days prior to execution of the said license agreement, BDA had entered into an agreement with a developer to build to demolish the existing structure and build a new commercial complex on the premises. Full stop. It had as part of the said agreement, BDA has a scheme to rehabilitate the existing license holders. Correct and rare?
Yes, my lords.
Huh?
Yes, my lord.
License holders. And also to reallot,
My lords, as per the resolution dated.
I reallot shops under certain circumstances. Huh? Full stop. Next para. The grievance of the petitioner is he has been sought to be evicted from the property without following the due process of law, and also and the BDA is also contemplating not to provide him any makeshift arrangement to run his business or to reallot the land. Full stop. For the said reason, he has prayed for setting aside the notice issued by BDA and also for a direction to provide him with makeshift arrangement to run his business and also to reallot a shop in the very same property if he is made to vacate the same. Full stop. Next para. The learned counsel for BDA upon instruction submits that the license of the petitioner has been expired and he has no right to continue in the property concerned. Full stop. However, he submits the representation of the BDA will be considered, representation of the petitioner will be considered in accordance with law. And upon him vacating the property, if the regulations stipulates, then in that event, he will be provided with a makeshift arrangement to run his business. And if the regulations once again permit for him to be re-allotted the land consent, he will be re-allotted shop consent, land shop consent, he will be allotted a shop as per the policy. As per the policy. Full stop. His submission is placed on record. Next part. The writ petition is disposed of in terms of the submissions made by the learned counsel for BDA.
And the judgment may be quoted, my lords. It is.
I'm not similarly situated to that situation at all, my lords.
Ray, this is as good as that.
Much of them.
What relief were granted him? I only told you if your policy permits,
much of them.
give him a makeshift arrangement and also.
Annexure Q have produced the policy, my lords. What he's saying policy is there at Annexure.
It's all right. I directed them. No?
419. In terms of other purpose, in terms of the concession agreement and in terms of the policy.
Yes, next.
If I may seek that indulgence.
Our policy in the
there is an agreement which they're bound by. Despite that, the issue
goes without saying, counsel. It goes without saying.
Despite that, despite that, they issue this notice to me. They are very well aware of their own policy, their own agreement.
All right, now he has given an undertaking, I recorded it.
I have 3.5 crores of investment in this property, my lords. I have 125 people working under me. This is a restaurant that is running, my lords. Without, despite their own agreement saying it, they still don't take steps in terms of that, my lord. Adhike, that's why I'm saying if some protection.
Policy in the Helidi Bappa. Yes.
47. Rajeshwar PN B Vachan.
Matter could be taken up next week, man.
Next week,
Next week.
How?
Next week, anytime.
The request of petitioner call on date.
Date, sir.
19th.
19.
Please, ma'am.
28th.
20th August. 20th.
20th, sir. 20th.
Illa, 48th.
47 ಮಾತ್ರ.
47.
48. My lords had directed them to produce information.
Producing the information, my lords, along with memo. Because my lords, Saturday was not non-working day, my lords. I am producing along with the memo. my lords, BDA has, as on date, my lords, BDA has not utilized the property, my lord. Surrounding the property, my lords, BDA has already formed a layout. As the first map, my lords, is pertains to survey number 8/2. There are two buildings existing in the my lords. Survey number 8/2.
But ಏನು ಮಾಡಿಲ್ಲ ಇಲ್ಲ.
My lord, BDA, because my lord, there were two litigations, my lord, litigations were pending, my lord, hence BDA couldn't do it. The surrounding, my lords, insofar as 9/1 is constructed by BDA, and my lords, survey number 6 is also utilized by the BDA. My lords,
ಯಾರು ಡಿನೋಟಿಫೈ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ
no, my lord, 8/16 is also utilized by BDA, my lords, and formed a layout. And 8/13 also formed, my lords. Surrounding lands are already, my lords, are all, my lords, utilized by the BDA, except this, because, my lord, there is a litigation. And in respect of, my lords, 9/2 is also same, my lord. BDA has passed the award, possession has been taken. Because of the litigation, my lords, BDA couldn't form the layout, my lords, in 9/2. It is also vacant, my lords. 9/2 is also vacant.
15/3 is concerned, but status quo. 15/3 is concerned.
But I will go through this one also. Just now they have handed over.
When do you want?
On the very same day, my lords.
20th, my lords. Basically, I am relying on two aspects, my lords. One, taking of merger, which is covered by Justice Anand Bharati's judgment. Two, in respect of two survey numbers, there is no award.
Only 15/3, my lords, because of the status quo order, we couldn't go ahead with the.
Now case.
15/3.
Produce that also, my lord. The case number.
That case is already disposed of.
No, at that time.
2008.
Then 2008 disposed of. I filed this petition in 2016. And that's in respect of an altogether different parcel of land.
This dispute ಇರೋದು ಅದು 9/2 ಆಮೇಲೆ
8/2, 9/2 and 15/3.
ಇದೆಲ್ಲ ಮುಗ್ದಿತ್ತಲ್ಲೇನ್ರಿ ಕೇಳಿ ಎಲ್ಲಾನು.
ಎಲ್ಲ ಕೇಳಿ ಮುಗಿದಿತ್ತು. ನಾವು ರಿಟರ್ನ್ ಸಿನಾಪ್ಸಿಸ್ ಹಾಕಿದೀವಿ.
Respondent has to argue on the merit. I'll argue the matter on merits. Not on this.
You have to show possession, sir.
Yes, my lord, sir.
It was on this issue, possession basically.
Yes, my lord, sir. I'll produce, I am ready to argue on possession also.
Go on with possession. ಇದ್ರಲ್ಲಿ ಏನಿಲ್ಲ ಇದು. ಇವಾಗ ಏನ್ ನೋಡೋದು ನೀವು?
ಏನಿಲ್ಲ.
ಇವಾಗ ನಾವು ನೋಡ್ಲಿಲ್ವಾ? ನೀವು ನೋಡಕ್ ಏನಾಗಿತ್ತು?
ಏನಿಲ್ಲ ಆದ್ರೆ.
Go on with the matter.
My lord.
See, the ground is ಇದು preliminary notification ಯಾವಾಗ ಹೇಳಿ?
Preliminary notification 8/4/2003, my lords.
Final notification.
Final is 9/9/2003.
9903. 16/2 ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ.
16/2 ಆಗಿಲ್ಲ.
In respect of 9/2 ಆಗಿದೆ sir.
9/2 ಆಗಿದೆ, 8/2 and 15/3 ಆಗಿಲ್ಲ.
9/2 ಕೊಟ್ಟಿಲ್ಲ.
ಆಗಿದೆ. In another matter, my lords.
ಎಲ್ಲಿದೆ 16 notification?
Not produced.
ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಿ ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವು.
My lords, in so far as 9/2 it is happened, my lords.
ತೋರಿಸಿ ಅದು.
Yes, my lords, sir.
ಇದು ಕೊಡಿ. ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಆಕ್ಟ್ ಕೊಡಿ. ತೋರಿಸಿ ಮಾಜರ್ ತೋರಿಸಿ.
My lord, Mazar is at my lord's page number 16 of my statement of objection, my lords, annexure R2.
ತೋರಿಸಿ. ನೀವು ಯಾವ್ದ್ರಲ್ಲಿ ಶ್ರೀನಿವಾಸ್?
8/2 and 15/3.
8/2 and 15/3.
I am in 9/2 and 15/3.
ಯಾರು?
I am in 9/2.
ನೀವು?
Only 8/2, my lords.
ನೀವು 8/2. ಓಕೆ, ಮೂರು ಒಟ್ಟಿಗೆ ಏರ್ ಮಾಡ್ತಾ ಇದೀವಿ.
Connected matters.
ಕೊಡಿ. ರಿಟ್ ಪಿಟಿಷನ್ ಕೊಡ್ರಿ.
My lords, I am arguing in 33208 of 2016, my lords. Page number 16 of my statement of objection.
This 33208 pertains to what?
Pertains to 8/2.
33208 pertains to 8/2.
Yes, my lords.
Huh.
Award has been passed in respect of.
The whole issue was only with regard to possession.
Yes, my
ನೀವು possession ತಗೊಂಡಿದ್ರೆ
possession, my lords. Yes, my lord.
ನಿಮಗೆ ಕೇಸ್ ಉಂಟು. possession ತಗೊಂಡಿಲ್ಲ ಅಂದ್ರೆ
Yes, my lord.
ಹೊಡೆದಾಕ್ತಿವಿ ಅಷ್ಟೇ. It's as simple as that.
Page number 16 of my statement of objection.
1 second, wait. ಇದು ಫಾರ್ ವಾಟ್ ಸ್ಟೇಜ್ ಇದು? ಯಾವ ಲೇಔಟ್ ಇದು?
Extension of Sir M. Vishweshwaraya.
Further extension.
Further extension of.
ಸ್ಕೀಮ್ ಏನ್ ಲ್ಯಾಪ್ಸ್ ಆಗಿಲ್ಲ?
ಇಲ್ಲ. Scheme has been upheld, my lords, and substantially implemented.
ಸ್ಕೀಮ್ ಅಪ್ಹೆಲ್ಡ್.
Yes, my lords.
ಓನ್ಲಿ ಥಿಂಗ್ ಇಸ್ ಪೊಸೆಷನ್ ಅಂತ ಅಷ್ಟೇ.
Possession.
ತೋರಿಸಿ.
My lords, page number 16 of my statement of objection, annexure R2.
ಮಾಜರ್ ತೋರಿಸ್ರಿ.
Annexure R2, my lords, page 16.
Annexure
Of the
R2,
statement
page
of
number
objection.
16. In my statement of objection, my lord.
ಎಲ್ರಿ?
Filed on 19 November 2020 itself, I have statement.
Objections ಎಲ್ರಿ? Mazar ತೋರ್ಸಿ.
My lords, page number 16 of
ಏನಿದೆ?
annexure R2, my lords, is the Mazar under section 16.
ಯಾರಪ್ಪ ಸೈನ್ ಮಾಡಿದಾರ ಪಂಚ?
My lords, in the right side, my lords, the Mazar darar ಸಹಿ ಮತ್ತು ವಿಳಾಸ ಅಂತ ಇದೆ ಸುಮ್ಮನೆ.
ಯಾರಿದಾರ?
ಅಲ್ಲಿ 3 ಜನ ಸಿಗ್ನೇಚರ್.
ಎಲ್ಲಿದಾರ? ಇಬ್ರು ಏನೋ ಗೀಚಿದಾರ ಅಷ್ಟ. ಇದನ್ ಮಾಜರ್ ಅಂತ ಕರಿತೀರ ನೀವು? ಆಮೇಲೆ ಸುತ್ತಮುತ್ತ 16-2 ಮಾಡಿರ್ಬೇಕಾದ್ರೆ ಇದನ್ ಮಾಡಕ್ ಏನಾಗಿತ್ತು?
My lords,
ಸುತ್ತಮುತ್ತ ಎಲ್ಲ 16-2 ಮಾಡಿದಾಗ ಇದನ್ ಮಾಡಕ್ ಏನಾಗಿತ್ತು? ಮಾಜರ್ ಬರೆಯೋ ಜಾಗದಲ್ಲಿ ತೆಂಗಿನ ಮರಗಳು, ಮಾವಿನ ಮರ, ಹಲಸಿನ ಮರ, ಸೀಗೆ ಮರ, ಹೊಂಗೆ ಮರ, ಹೊನ್ನೆ ಮರ,
ಆಕ್ಲಿ ಮರ, ಬೇವಿನ ಮರ.
ಅಟ್ಲೀಸ್ಟ್ ಪಂಚ್ಗಳದ್ದು ಏನೋ ಒಂದು 5 ಜನದ್ದು ಗೀಜಿರೋದು ಇರ್ತಿದ್ರಿ, ಇಲ್ಲ ಅದು ಇಲ್ವಲ್ರಿ.
this is how they have taken
ಆಮೇಲೆ
possession of the
ಮಾಲೀಕರು
property.
ಹಾಜರಿದ್ದರು ಹಾಜರಿರಲಿಲ್ಲ. ಅದು
ಅದ್ ಬೇರೆ ವಿಚಾರ. See, that we are not insisting upon. Usually they do all types of naughty.
notice
ಯಾರು
has been
ನಾಟಕ
issued to
ಮಾಡ್ತಾರೆ
them.
ಇವ್ರು. ಯಾರು ಮಾಲೀಕರು ಅದನ್ನ ಕೌಂಟ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
Notice under
ಹೋಗಿದ್ರು
section
ಅನ್ನೋದಕ್ಕೆ
12
ಬೇಕಲ್ಲ.
has been issued to the petitioners also. Notice under section 12(2), my lords, in that also, my lords, the date of the Mazar is also shown. On what date we are coming to take
Okay, this
possession.
is Mazar according to you, right?
Yes, my lords.
Anything else?
My lords, my lords, there is some judgment, my lords, with regard to the drawing of Mazar and all. Pass on.
Sir, we have seen that, sir. Yeah, accepted Justice Anand Reddy's judgment. We are going to go by that. And by no stretch of imagination can you consider this a proper Mazar.
My lords,
Be fair to the court.
the BDA has already substantially implemented the scheme. Award has
I'm
been
not on that.
tendered the amount to the, once the land, my lords, once it is tendered to the, my lords, to the petitioner, my lords, the scheme or the.
ಆಯ್ತು, ಪೊಸಿಷನ್ ತಗೊಳ್ಳದಲ್ಲೇ ಇದ್ರೂನು ಲ್ಯಾಂಡ್ ವೆಸ್ಟ್ ವಿತ್ ದ ಗವರ್ಮೆಂಟ್ ಅಂತ ತೋರಿಸಿ
My lords,
ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿ.
my lords,
ನಿಮ್ ಪರವಾಗಿ.
Indore
Dismiss
Development
ಮಾಡಿ.
Authority, my lords.
Huh?
Indore Development Authority
What
was.
is it, sir?
Third.
ಇದನ್ನ ತೆಗೀರಿ, ಕನ್ಫ್ಯೂಷನ್ ಆಗತ್ತೆ. ಆಯ್ತು, ಇಲ್ಲ ಇದೆ ಬಿಡಿ, ಸರಿಗಿದೆ. ಹಾ ಹೇಳಿ, ಪಾರ ನಂಬರ್.
My lords, I will just moment, my lords.
ಪೊಸಿಷನ್ ಬಗ್ಗೆ ಕಾನೂನು ತೋರಿಸಿ ಅಪ್ಪ.
Yes, my lords, I will. Para 133 of Indore Development Authority judgment.
Yes.
ಒಳ್ಳೆ ಕೆಲಸ ಮಾಡ್ತಿರೋ, ಸರಿಯಾಗಿ ಮಾಡಕ್ಕಾಗಲ್ಲ.
Para 366 7.7, my lords.
My lords, first I will.
133 ಓದಿ.
133, my lords.
Vesting takes place as soon as possession is taken after passing of the award. Vesting takes place with possession, Sachin.
Yes, my lords. My lords, sorry, my lords. Para number 244. (228), my lord, page number 275, mode of taking possession.
Para number?
Page number 275, para number 228. My lords, may I read, my lords? There are more, 5 modes of taking possession.
ಎಲ್ಲಿ ಪ್ಯಾರಾ ನಂಬರ್
228, page number 275, my lords. Top right corner, there is a page number.
There are 5 methods of making payments ಅದು.
My lords, I am sorry.
Lords, in Chickputaya's matter, my lords have considered Indore Development Authority, extracted the 11 portions also.
He wants to argue something, I'm giving him.
My lords, sorry, my lords, 286, page number 286, para number 244. Issue number 4, mode of taking possession under the Act
Yes, go ahead.
1894.
Hmm.
The section 16 of the Act provides that the possession of the land may be taken by the state government after passing of the award. Thereupon, the land was free from all encumbrances. The state government similar or provisions made in the case of urgency, section 17. The word possession has been used in the Act 1894. My lords, I'll
ಯಾಕೆ ನಿಮ್ ಅಗೇನ್ಸ್ಟ್ ಆಗಿ ಹೋಗುತ್ತೆ ಅಂತ ಸ್ಟಾಪ್ ಮಾಡ್ಬಿಟ್ರಾ?
My lords.
ಓದಿ ಪರವಾಗಿಲ್ಲ, ಇಟ್ಸ್ ಆಲ್ ರೈಟ್.
My lord. Whereas in section 24(2) of the Act,
it is submitted that drawing of Panchanama for taking over the possession is not enough when the actual physical possession
yes, my lord.
remained with the landowner, and section 24 clause 2 requires actual physical possession to be taken, not the possession in any other form.
Yes,
when the state has acquired the land and award has been passed, land vests in the state government free from all encumbrances. The act of vesting of the land in the state is with possession. Any person retaining the possession thereafter has to be treated as a trespasser and has no right to possess the land which vests in the state free from all encumbrances. The question which arises whether there is any difference between taking possession under 84 Act, 1894 Act and the expression physical possession so and so. What was contemplated under Act 1894 by taking the possession meant only physical possession of the land. Taking over the possession under Act of 2013 always amounted to taking over physical possession of the land. When the state government acquires land and draws up a memorandum of taking possession, that amounts to taking physical possession of the land. On the large chunk of property or otherwise which is acquired, the government is not supposed to put some other person or so and so.
But in Chikkaputaya matter, my lords have extracted 244, 256, 247.
Come to 259.
Yes, my lord. Now the court would examine the mode of taking possession under the 1894 Act as laid down by the court in Balwant Narayan Bagade. It was observed that the act of Tahsildar is going on the spot and inspecting the land was insufficient to constitute taking possession. Thereafter, it would not be open to the government or commission to withdraw from the acquisition under section 48(1) of the act. It was held thus. We agree that.
Come to 267.
My lords.
267. This court stated that the mode of taking possession is by drawing a Panchanama considering the mode of taking possession in any other law to a similar effect has been laid down in any layout residents association versus Bangalore Development Authority. Certain decisions were cited with respect to other statutes regarding coal fields and etc. and how the possession is taken and vesting is to what extent. Those have to be seen in the context of particulars act. Possession comprise of various rights, thus it has to be couched in the particular statute, for which we have plethora of decisions of the court. Hence, we need not fall back on the decision in other cases.
So all this proceed on the assumption that a Panchanama is to be drawn. But
Whether
the judgment,
Panchanama is drawn
how the
properly
judgment,
or not.
Panchanama, how the Panchanama is to be drawn, this decision does not address that question, man. That question is addressed by Justice Anand Bairad's decision. Ultimately, Panchas, who are the Panchas? That
They have
should be
to be
known.
identifiable. That's all. They have to be identifiable.
Once the my lord's award is tendered.
See, this goes in the Belige matter problem.
My lord, that's why my lords I am happy. Better, my lord. Once the land, my lords, award is passed, my lords, in one of the matters, my lords, in Banda Development Authority versus
regarding my lord, Banda Development Authority is concerned, my lord. Symbolic position itself enough for their control.
Where in Bekagilpi, see, method of taking possession. You go to the spot, you draw a Panchanama.
In this case, my lord, what happened, my lord? Other land is concerned, my lord, I have already implemented. This land is concerned, my lord, they are not taken position regarding the 16.2.
See, illenagate gotta defects enen barutte gotta. Ondu Panchanama sariyaಗಿ draw madilla.
Please.
You definitely cannot identify even the name of one punch also here.
Yes.
Even the name of one punch also cannot be identified, number one. Number two, Panchanama is very defective. You are not coming with 16.2. See, all the surrounding lands you come up with 16.2. This one land you don't come up with 16.2. Third one, to give them a long rope, I said, what is the current status of the property? Supposing you have gone ahead, you have formed the road, you have done all those things, it would be fine and better.
It is a vacant place.
Huh?
It is a vacant place.
It's a completely vacant space and their note sheet itself reveals no layout has been formed. No layout has been formed. And the third one is, yes, are they prevented from any litigation or something? 2008, the
Judge's order disposed of.
disposed of. There was no impediment. This writ petition is filed in the year 2016. 2016, and they have enjoyed the property.
To show that they are in possession and enjoy the property, my lords, except a mutation of 2002.
No, Srinivas, see, it's like this. The point is, have you taken possession of the property?
As per this, only this Mazar will.
ಅವ್ರು ಏನಾದ್ರು ಕಟ್ಕೊಂಡಿರ್ಲಿ ರೀ ಅಲ್ಲಿ ನೀವು ಪೊಸೆಷನ್ ಸರಿಯಾಗಿ ತಗೊಂಡಿದ್ರೆ ಮಾಜರ್ ಸರಿಯಾಗಿ ಡ್ರಾ ಮಾಡಿದ್ರೆ ಇದೇನ್ ತೋರಿಸ್ತದೆ. ಆಮೇಲೆ ನೀವ್ ಯಾವ್ದೇ ಮಾಜರ್ ಅಲ್ಲಿ ನೀವು ಈ ತೆಂಗಿನ ಮರ ಅದೆಲ್ಲ ಬರೀತೀರೇನ್ರಿ? ಮಾಲ್ಕೀಸ್ ಮಾಜರ್ ಅಲ್ಲಿ ಬರೀತೀರಾ? ಮಾಲ್ಕೀಸ್ ಮಾಜರ್ ಅಲ್ಲಿ ಎಂಟರ್ ಮಾಡ್ತೀರಾ? You don't. ನಾನ್ ನೋಡಿರೋಂಗಂತೂ
There will be a separate question, my lords, if my lords posted it on 14.
No, sir, today I am deciding it. Sufficient. ಇಬ್ರು ಹೇಳ್ತಾ ಇದಾರೆ, ಇಬ್ರು ಕೋರ್ಟ್ಗೆ ನನಗೆ ಇದು ಫಾರ್ವರ್ಡ್ ಮಾಡಿ ಸಾಕಾಗಿದೆ.
My lords, tomorrow, my lords, I will address my arguments on possession, my lords. With respect to possession, only in this judgments, my lords, compilation. I will not go by beyond that.
I have read it such a.
Yes, my lords.
I'll pass my orders.
Tomorrow, my lords, at 2:30, I will address my argument. I will not seek any adjournment on tomorrow, my lords. It's my
2:30 tomorrow.
As my lord said, we are endlessly taking the matter.
No, my lord.
Testing my lord's patience.
Sorry, my lord. Humbly praying for tomorrow, my lord. I'm not.
ಇದ್ರಲ್ಲಿ ಬೇರೆ ಏನಿಲ್ಲಪ್ಪ ಇದ್ರಲ್ಲಿ.
Yes, my lord, I do understand. My lord's
Sir,
question is
Rajeshwar,
very simple and I will address
find
my
out the
arguments
relevant
on-
provision of law and judgments and apprise me.
Yes, my lords.
ಅಲ್ಲ ಇದರಲ್ಲಿ ತಮ್ಮ ಚಿಕ್ಕಪುಟ್ಟಯ್ಯ ಜಜ್ಮೆಂಟ್ ಫಾಲೋಯಿಂಗ್ ಜಸ್ಟಿಸ್ ಆನಂದ್ ಬೈರಡಿಸ್ ಜಜ್ಮೆಂಟ್
ಅಷ್ಟೇ.
ಅಷ್ಟೇ, ಇನ್ನೇನು ಇಲ್ಲ ಇದರಲ್ಲಿ, ಬೇರೆ ಏನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಇಲ್ಲ.
Possession not taken, what is the effect of it?
Land doesn't vest. If the land doesn't vest, there is no acquisition.
But scheme is substantially implemented.
That's true.
My lords, award.
Acquisition should be complete for divesting me of my property, my lords. The acquisition is not complete.
My lords, once the award is passed, possession is taken, my lord. My lords, so far as 9/2 is concerned, my lords, our 16.2 notification is there, my lords. I will produce tomorrow itself, my lord. And in with respect to 8/2, my lord, they have not, even till today, my lords, they have not produced their titles over the property.
That is different altogether. This is not a title inquiry.
No, my lords, even if they have no title over the property, my lord, he has no locus to file a petition.
My lords, he is taking this ground for the first time.
No, my lord, in the earlier round, my lords, when the Vachan sir matter also.
That is a different, that is a different survey number.
Question, my lord, he has not produced the documents, my lord. I have tried from the day one, I am arguing this matter, my lord. Even till date, he has not produced the sale deeds or any document to show that he is the owner of the property.
That's petitioner name in this case is Mudlappa. His name is shown in the notification. What my learned friend is submitting, my lords?
My lords,
I'm a notified khatedar.
why I am asking this, my lords, earlier round of litigation, some other person has claiming the property and has filed a writ petition and he has lost the writ petition, my lords. My lords, may kindly turn the page 18 of my statement of objection, my lord. I have done that, my lord.
Plus total
other
extent of
person has
land is
filed.
4 acres, 2 guntas. This petitioner is claiming hardly about 24 guntas. There are different parcels of land in the same survey number. There are different owners. My name is shown in the notification.
for tomorrow, my lord, I will.
Third in part. Call on tomorrow date for 2:30.
Plus let the other survey numbers also, my lord, let them be thorough.
ಅದು ನೋಡ್ಕೊಂಡ್
ನಾಳೆ ಅದನ್ನ
I,
ನೋಡ್ಕೊಂಡ್
Allah, I go with 8/2 and 15/3, my lords,
no award.
Allah, award is not passed because of the litigations.
What litigation?
My lords,
No litigation in respect
with
of this
regard to
parcel of
8/2,
land.
my lords, I adopt the arguments of my learned.
ಏನೇನು ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ ನಾಳೆ 2:30.
49. The same Babu. Annapurna Bardoli. Number 49, list 1. Annapurna Bardoli. Number 49.
Lord, the land bearing survey number. Lord, survey number 159. Lord, totally measure 15 acres. Lord, in the year 1965, the petitioner's father.
You are ready?
My lords, on the, if I may recollect, my lords, last occasion, my lords have pointed out that one judgment to be relied upon of Honorable Supreme Court, RTC shows the name of the khatedar. We have issued the preliminary notification based on the name which was reflecting in that.
No, I just asked you, are you ready?
Please, my
No, I'm sorry, we have not gone into the merits of the case at all.
Let him decide, let him argue first,
Please.
yes.
Lord, kindly see, Lord, this is survey number 159. Lord, now last to kindly take, Lord, the final notification which I have produced at in page 21, 20, and at page number 27, serial number 175. Lord, then it shows survey number 159. There, my lord, the names. Last kindly see.
Page number?
Page number 27. 27 ನಲ್ಲಿ serial number 175 ನಲ್ಲಿ survey number 159. Lord, ಇಲ್ಲಿ ಶಿವಲಿಂಗೇಗೌಡ, ಅಣ್ಣಯ್ಯ, ಬಿನ್ ನಿಂಗೇಗೌಡ, ಶಿವಣ್ಣ, ಕೃಷ್ಣಪ್ಪ, ಸಿದ್ದಲಿಂಗೇಗೌಡ, ಶಿವರಾಮೇಗೌಡ, and bin Lingegowda. All these persons, my lord, they are the owners in respect of part of survey number, that is 7 acres and 38 guntas. So far as the 8 acres is concerned, Lord, this land was purchased by my lord, one Anke Gowda, that is the grandfather of the petitioners. Lord, in the year, by sale deed dated 20th March 1965, I produced the sale deed also. That is 8 acres.
What about RTC?
Yes. Lashma, can you take note ink page? Lord, annexure A. Lord, this is a notification, preliminary notification was on 18th March 2006. Final notification in December 2006. December date, 5th December 2006. Now I have produced the RTC even much earlier to it. Lashma, kindly take annexure A. Ink page, my lord, 13. There, Lashma, kindly see, this is from 2002. These are the names of the persons who have purchased this property, 8 acres. Lashma, kindly see, my lord, survey number 159. This is 8 acres. Lashma, kindly got it, my lord, 8 acres. This has been mutated. This no longer shows 15 acres. This is in respect of 8 acres, which was purchased by a grandfather of the petitioner.
And as on that date, the names of these persons will not appear in the RTC column. Lashmi kindly see, if you Lashmi kindly take the, even thereafter, my lord, several mutations have been taken place after the death of the principal owner, his sons, grandsons, till to, as on date, my lord, there are more than 20 persons, my lord, who are the Khatadars. And at no point of time, the RTC shows that this land has been acquired or whatever it is. Even today, Lord, the land has been shown in the names of these persons, and even the mutation shows that the
So you are claiming under Ankegoda.
Annegoda.
Anneno, Ankeno.
Ankegoda. I have produced the sale deed also. Lord, may I request your lordship to in
Yes, Ankegodange notice ಹೋಗಿಲ್ವಾ?
ಅಂಕೇಗೌಡರು ಯಾರಿಗೂ ಹೋಗಿ ಬಂದಿಲ್ಲ ನಮಗೆ. And these persons, they are the tenants in respect of the remaining 7 acres, 38 guntas. I'll prove that, my lord, because they have produced the award. The award is only in respect of 7 acres, 38 guntas. That award has been produced by my learned friend. It is at, Lashmi kindly see, my lord, the award. Award is at annexure R6. That is dated 14/3/2019. Writ petition was filed in the year 2016. 2013. And Lashmi kindly see that award, my lord. This is in respect of only 7 acres and 38 guntas, not in respect of 8 acres. My specific case is, without showing the names of the Khatadars, Lord, this preliminary and final notifications have been issued. I came to know about this notification only in the year 2013, when, my lord, the JCB, which entered my land, tried to pull out the trees. Then immediately I filed a writ petition before the Honorable Court and obtained an interim order. Even today, the land is under our possession, and it is being cultivated by the petitioners by raising mango crops, coconut, and other agricultural operations are going on, and several houses have been constructed there, and they are residing long back. My response submission is, this notification, this acquisition, without issuing notice under section 28(4), my lord, is totally illegal. Therefore, my lord, this notification, so far as this land is concerned, that is 8 acres in survey number 159, has to be quashed. So depending upon them, they want to acquire, let them issue fresh notification, whatever the. I am ready to prove.
If notice is not issued, it has to go on.
It has to go. It has to go. Lashmi kindly see. Last time my learned friend.
Notice issued to the wrong person.
I'm not Lashmi kindly see. The notice regarding notice, no
judgment. Judgment, sir.
Lord, my learned friend has given a bunch of the judgments. There, my lord, that judgment 2020 online 217. And my lord, the latest judgment I have produced. The latest judgment, my lord, which was pronounced by the Supreme Court on 17th June.
Judgment, sir.
Lord Lashmi kindly see, that is the judgment. Yes, good. May kindly take my lord. Para 30 mil. Right to notice. The right to.
Which judgment?
Page 19. Ink page 19.
Paragraph 30. The following are the 7 principles There, my lord, the first 30.1, the right to notice, a prior notice informing the bearer of the right that the state intends to deprive them of the right to property in a right in itself is a linear extension of the right to know embedded in the Article 19(1)(a). The Constitution does not contemplate acquisition by ambush. The notice to acquire must be clear, cogent, meaningful. Some of the statutes reflect this right. Therefore, my response submission is right to notice is a fundamental right. As Milord, and Lakshmi kindly see Milord. Then Milord, in the Section 4 of the Land Acquisition Act, Section 131 of the Requisition and Acquisition Name Property Act, Section so and the so and so Act are examples of such statutory incorporation of the right to notice before initiation of the land acquisition proceedings. In a large number of decisions, our constitutional courts have independently recognized the right to notice before any process of acquisition is commenced. Milord, this is the judgment rendered on Milord 17th June 2024 by the Honorable Supreme Court. Sorry, 16/5/2024. I stand corrected. 16/5/2024. Therefore, my responsible submission is without notice, without Milord issuing a notice, Milord, this land is now they want to take possession of my land without acquiring, without notifying my land. My land has not been acquired in accordance with Section 28 of the KIDBI. I can prove, Milord, to show that the award has been passed in respect of, and the award produced by my land friend only shows to the extent of 7 acres and 38 guntas, which does not belong to me, which is the part of the portion of the survey number.
What is your extent of right over the land?
Milord, 8 acres.
Milord,
Milord?
where have you said so?
Yes, Lakshmi, writ petition. Lakshmi, can you take the writ petition? In the first paragraph itself, Lord has stated. Lord, page 5. The petitions are the owners of agricultural land bearing survey number 152.
Show the RTC once again, sir.
Lord, RTC is at page 13.
13,
13. Writ petition only that.
ಸರ್ ಇದು 1-3 ಹಾಕಿರೋದು ನೀವು ಇದು ಟೋಟಲ್ ಎಕ್ಸ್ಟೆಂಟ್ 8 ಎಕರೆ ತೋರಿಸ್ತಾ ಇದೆ 159/2.
8 ಎಕರೆ ಹೌದು. He purchased 8 acres.
ಸಿ ಇದರಲ್ಲಿ ಕೆ ರಾಮಪ್ಪ ಅಂಕೇಗೌಡ,
ಅವರೆಲ್ಲ ಅಲ್ಲಿ ಪಕ್ಕದಲ್ಲಿ
ವಾಸು, ಕೃಷ್ಣಪ್ಪ, ಮರಿಗೌಡ, ಸಿದ್ದರಾಮು, ಅಣ್ಣಯ್ಯ.
ಹೌದು, they are all legal representatives of ಅಂಕೇಗೌಡ. And Lakshmi, can you see the right hand column ನಲ್ಲಿ?
ಸರ್ ಅಂಕೇಗೌಡ ಉರ್ಫ್ ಪುಟ್ಟೇಗೌಡ ಬಿನ್ ಅಂಕೇಗೌಡ. See, it shows only 1 acre 24 guntas.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಪಕ್ಕದಲ್ಲಿ ಅದು ಮ್ಯೂಟೇಶನ್ ಆಗಿ ಇಂತಿಂತವ್ರಿಗೆ ಇಷ್ಟು ಎಕರೆ ಬಂದಿದೆ, ಟೋಟಲ್ ಇಷ್ಟು ಬಂದಿದೆ. ಆ 8 ಎಕರೆನಲ್ಲಿ ಇಂತಿಂತವ್ರಿಗೆ ಇಷ್ಟು ಬಂದಿದೆ. And they are the persons who are in possession. ಸ್ವಂತ. This is 2002. That is even much before the acquisition. Later on, further it has been mutated. So these
ಸರ್ ನೋಡಿ, ಅಣ್ಣಯ್ಯಂಗೆ 20 ಗುಂಟೆ ಬರುತ್ತಾ?
ಅವರು ವಿಭಾಗ ಮಾಡ್ಕೊಂಡಿರೋದು ಸ್ವಾಮಿ.
ಸರ್ ಲಿಸನ್, 8 ಎಕರೆನಲ್ಲಿ ಅಣ್ಣಯ್ಯಂಗೆ 20 ಗುಂಟೆ ಬರುತ್ತೆ. ಅಣ್ಣಯ್ಯಂಗೆ ನೋಡಿ ಸರ್ ದಯವಿಟ್ಟು.
ಹೌದು, ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ಅಣ್ಣಯ್ಯಂಗೆ 20 ಗುಂಟೆ ಬರುತ್ತೆ. Annaya's name is found in 4 notification.
That is where I wanted to. Now Lakshmi kindly pay I have produced the land tribunal's order ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅಲ್ಲೂ ಆ ಟೆನೆಂಟ್ಸ್ ಹೆಸರು ಆ ತರನೇ ಇದೆ. 1 or 2 names. Not I have produced the order of the land tribunal to show that the 7 acres 38 guntas was the subject matter of land tribunal for number 7.
This is 159 part 2, sir. 159 is acquired. Where is 159's?
My lords will get it as statement of
I'll-
objection
I'll-
what we have
I'll
filed.
complete it, Mary. I'll answer your lordship.
The-
Let my land friend, thereafter let her answer.
RTC has been
No.
produced, my lords.
I have produced the RTC as on the year 2002. Itself clearly shows that the land has been mutated. And my lord, the survey number 159 does not exist as on that day. It has been bifurcated. Survey number 159 illa iga existence. Survey number 159 bar adu mutation prakara bandide adu numbers. Further numbers kuda bandide adu. ನಾನು ಹೇಳೋದೇನೆಂದ್ರೆ 2006 was the preliminary notification. At least as on that day, ಈ ನೇಮ್ಸ್ ಆದ್ರೂ ತೋರಿಸಬಹುದಾಗಿತ್ತಲ್ಲ. ನಾವು ಇವಾಗ ತಾವೊಂದು ಮಾತು ಹೇಳಿದೆ. May I request the Lordship to kindly take my memo along with documents filed on 21/7/2020.
Sir, it's all right, sir. See, survey number 159 is sought to be acquired. The undivided survey number 159 is sought to be acquired. Okay. Now, you are claiming right under Ankegowda.
Yes.
Not under anybody else.
No.
Okay.
I put the cell deed. Cell deed.
It's all right. You are claiming right under Ankegowda.
Yes.
Now, if Ankegowda is not notified, you have got a case.
Ankegowda has not been notified.
You have got a case. Only to the extent of land held by Ankegowda.
8 acres. He has purchased the 8 acres. Not 15 acres.
Sir, listen, survey number 159, sir.
Yes.
Okay. Now, what do you say is you come to your RTC at ink page number 13 vis-a-vis the notification at ink page number 27.
Yes, yes, yes.
Ink page number 27 notice, sir. Shivlingegowda. Shivlingegowda does not find a place over here.
Yelli.
159/2 nalli. See, and once again, see, you are now concerned about lands in 159/2 no horto. You are not concerned about lands in other survey numbers.
First of all, Ashma, kindly see this, my lord. It consists of 15 acres.
Sir, listen.
One nimisha.
Sir, let me make myself clear to you.
Yes.
We are talking about survey number 159.
Yes.
As per the notification, the entire survey number 159 measuring 16 acres, 15 guntas was sought to be acquired.
If that is the case, all the names who owns survey number 15 has to be shown in the RTC.
Has to be shown in the
notification.
Has to be shown in the notification. Okay. Now, with regard to the 16 acres, 15 guntas of land, whomsoever name that is shown in the notification, they will not get a right to challenge by way of writ petition. That notice has not been issued to them.
They are the legal representatives of they are not the vendors, Allah. They are the legal representatives of Ankegowda. They are not third parties.
Sir, listen.
Yes.
The names which finds a mention in page number 27. Notification.
Yes.
They will not get a right to challenge the acquisition. ಒಪ್ಕೊಂತೀರಾ?
ಇಲ್ಲ ಮತ್ತೆ ಇನ್ಯಾರು ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕು? ಈಗ ನಮ್ದು ಸರ್ವೆ ನಂಬರ್ 159 ನಲ್ಲಿ 8 ಎಕರೆ ನಮ್ದು ಜಮೀನು. ಅದು ನಮ್ಮ ಗ್ರ್ಯಾಂಡ್ ಫಾದರ್ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದಾರೆ. ವಿ ಆರ್ ದಿ ಲೀಗಲ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ಸ್. ಇಫ್ ಲೀಗಲ್
ನಿಮ್ಗೆ ಅರ್ಥ ಆಗ್ತಿಲ್ಲ ನಾನು ಹೇಳ್ತಿರೋದು.
ಅಲ್ಲ, ನೀವು
ದಯವಿಟ್ಟು ಒಂದ್ ನಿಮಿಷ 27ನೇ ಪೇಜ್ ನಂಬರ್ ನೋಡಿ.
ಹೌದು ಸರ್. That is the notification your lordships are referring to.
Yes.
If you are, may I request your lordship if you are referring to this document, then you will also refer to the land tribunal's order.
Sir,
All
it is
these
not
names-
required, sir. Please look at page number 27.
Yes, my lord, I'm saying.
16 acres, 15 guntas of land
Howdu,
in survey number 159,
howdu.
owned by Shivlinga Goda.
Own alla adu, that is the whole difficulty. He does not own. This Shivlinga Goda is a tenant in respect of 7 acres, 38 guntas. It is available from the award.
ಸ್ವಲ್ಪ ಪೂರ್ತಿ ಹೇಳೋದು ಕೇಳಿಸ್ಕೊಳ್ಳಿ.
Hmm.
Which according to KADB is owned by Shivlinga Goda, according to KADB. You may not be the owner. Okay, according to KADB, it is owned by Shivlinga Goda, Annaya, Shivanna, Krishnappa, Sidlinga Goda, Shivarame Goda, Binlinga Goda. Okay. Now, if these persons own any of the lands, or if anybody is claiming a right over these lands under these persons, they cannot file a writ petition. Persons other than those persons, these persons alone can file a writ petition.
That is the petitioners. Correct.
Okay?
Yes.
To that extent, you are in agreement.
Yes, yes.
Now, come here. Shivlinga Goda. Column number 9 ಅಲ್ಲಿ ಶಿವಲಿಂಗ ಗೌಡನ ಹೆಸರು ಬರಲ್ಲ. You now come to page number 13. Okay?
Yes.
ಅಣ್ಣಯ್ಯನ ಹೆಸರು ಬರುತ್ತೆ 20 ಗುಂಟೆ.
ಅದು ಅಣ್ಣಯ್ಯ ಆ ಅಣ್ಣಯ್ಯ ಅಲ್ಲ.
ಅದು ಇನ್ಯಾವ ಅಣ್ಣಯ್ಯ?
ಆ ಅಣ್ಣಯ್ಯ ಬಂದು
ಅಣ್ಣಯ್ಯ ಬಿನ್ನಿಂಗೇಗೌಡನೇ.
ಅವನ್ ಅದೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. That is the reason Lordship kindly take the land tribunal's order. In order to distinguish, he is the entirely different person. I have produced the order of the land tribunal to show that he is a tenant who had filed an application before the land tribunal in respect of the other 7 acres, 38 guntas. And the award is passed.
Sir, you all claim right under whom, sir? Ankegoda and anybody else?
We claim, my lord, only from Ankegoda.
Ankegoda is shown to be owner of only 1 acre 24 guntas, sir, not 8 acres.
In fact, that's what I am trying to say. The Ankegoda purchased this property on 20th March 1965. That is 8 acres from out of 15 acres, 38 guntas. In fact, my lord, the total extent is 16 acres and 15 guntas. There, my lord, 17 guntas Karab ಅದು ತೆಗೆದಿದ್ದಾರೆ. ಹೋದ್ರೆ 15 ಎಕರೆ 38 ಗುಂಟೆ. 15 ಎಕರೆ 38 ಗುಂಟೆನಲ್ಲಿ ನಮ್ದು 8 ಎಕರೆ ಹೋದರೆ 7 ಎಕರೆ 38 ಗುಂಟೆ. ಆ 7 ಎಕರೆ 38 ಗುಂಟೆ was a land subjected to for number 7 before the land tribunal. ಅಲ್ಲಿ ಟೆನೆಂಟ್ಸ್ ಇದ್ದವ್ರ ಹೆಸರು ಇಲ್ಲಿ ಹಾಕ್ಬಿಟ್ಟು ನಮ್ಮ ಹೆಸರು ಯಾರ್ದು ಹಾಕಿದ್ರೆ they try to say that the land is sought to be acquired. This is our case, Miller. I can prove with the documents to show that this land acquisition is only in respect of that 7 acres 38 guntas and not in respect of 8 acres. And even the award that has been passed is only in respect of 7 acres 38 guntas and not in respect of 8 acres.
Okay. ಅದನ್ನ ಹೇಳಲಿಲ್ಲ ನೀವು.
The award is at.
Yes, madam.
Oh, my lords, may kindly see, my lords, my statement of objections which was filed on 1/4/2013. It was 26/2013. My lords, it's dated 26/2013.
26/2013. Huh.
My lords, I have produced the RTC of 2005/2006. This is an acquisition of 2006. My lords, may kindly see the names of the entire 15 acres, 16 acres, 15 guntas, my lords. Shivalinga Gowda, Annaya, Shivanna, Krishnappa, Siddhalinga Gowda, Shivarame Gowda. Then, my lords, I have issued notices to all the people whose names are reflected my lords may kindly R2 are the notices that we have sent.
Lord, your lordships are referring to, my lord. Which
R1, sir,
page 23, na?
page number 8, R document. No. See, where is the server number over here?
My lord, it's mentioned on the corner, it's 159, my lords.
Where is it mentioned? Where is it mentioned?
That's got
6th, server number 159, yes.
159. What my lords, my learned friend was showing is 159 bar 2 knee. This is whole 159, my lords. And it was, the preliminary notification was issued on 24/4/2006. And this is a RTC of 25/11/2005. So we have gone by this RTC and we have issued notice to all the people whose names were reflecting in the RTC, my lords. That is R2 are the notices that we have issued. Thereafter, my lords, may kindly turn to the petition. And my lords, the dates are important. 2006, a final notification was issued. 5th December 2006, the final notification has been issued. In the final notification, my lords, may kindly see that my learned friend have produced it. At page number.
No, listen.
Please, my lord.
Where is the preliminary notification?
My lord, 3 years. There is, my lord,
One second, wait.
My
What
lord,
is,
see the prayer what has been sought. In 2013, he filed a petition for a relief by issue a writ of mandamus any other order. The case may be direct the respondent number 1 and 2 not to proceed with the formation of industrial layout without acquiring the agricultural land bearing 159 bar 2, measuring 8 acres, so and so. My lord, this acquisition was to an extent.
Okay, where is the final notification?
My lord, that is at in the petition, page number 21. Final notification is not challenged, my lords. In 2000.
I'm sorry, it has been challenged. Subsequently, an amendment application has been filed.
Amendment is 2024.
Maybe.
In 2024, he has sought for.
That is only a formal amendment.
That was clearly made that he will not claim the benefit of limitation, my lords.
No.
That is at 25/4/2024, there is an order to that effect, my lords.
I'm sorry, my land friend is saying so many things.
My lord, the honorable court wanted to dismiss the petition. That is when, my lord.
I'm sorry, these are the my lord, uncalled for statements. It should not be said like that.
My lord,
There is no evidence to show that the court said that. I can, otherwise I can also say so many things. In fact, court wanted to allow the writ petition on that ground. I did not say that before you all. I did not want to say all those things. I know, I am practicing, this is for the 49th year I am practicing before this honorable court. She should know what should be told before the court and what should not be.
If my learned friend allows me to argue, I'll.
So finally, how much is sought to be acquired?
My lords, entire 16 layouts have been formed, my lords. Industrial layouts have been 5 beneficiaries have been allotted for the entire extent, my lords. This acquisition was 500 and odd acres of land, my lords. It's forthcoming from the final notification itself. 544.16 acres of land, my lords. And my learned friend cannot claim
this is
that
like
he was not aware of this acquisition, my lords.
Yes.
Layouts have been formed.
Now, what you have acquired is survey number
159.
159.
Please, my
When
lords.
you acquired this, was survey number 159 bar E was there?
My lords, we have gone by the RTC, which was available at the relevant point of time, my lords. The RTC clearly reflects, and the RTC, what my lords.
No, I am asking you.
Please, my lords.
When survey number 159 was acquired, was there survey number 159 bar E in existence?
My lords, that we are not aware, my lords, that my learned friends have said the report has happened, but it's not forthcoming. And my lords, 544, and matter is pending before LAC, where they are also party and appearing before the land. Reference code, my lords.
Government.
Page number 27. That's it, very clear that 159 total document is 95 is that. Whatever my lordship articles is what that my lordship KIDP suffered that land. 27 very clear, and also my lordship, this name is not shown in the subsequent RTC.
And my lords, these P2 and P3 are already, has been.
When was the preliminary notification issued?
My lord, preliminary notification was issued on
18th March.
24/4/2006.
84?
24/4/2006, my lords.
24/4/2006. Yes, learned AGA is directed to produce the RTC for the year 2004-5. In respect of survey number
159.
159 of Kurgalli village, Ilwala Hobli, Mysore Taluk by next date of hearing. Full stop. He is also directed to verify and state whether there was survey number 159/E. Tane? 2E. 2? Neena. Nee ante yadru idu.
It's 2 it is mentioned in the.
ಅಲ್ಲ RTC ನಲ್ಲಿ ಇದೆ ಅದು
2
ಅಂದ್ರೆ
Nee ಅಂದ್ರೆ ಎಂತದಪ್ಪ ಅದು?
he said 2 ನೀ ಅಂತಿದೆ annexure
ಆಯ್ತು, ಸರ್ವೆ ನಂಬರ್ ಏನು 159 2 ಅದು ನೀ ಕನ್ನಡದಲ್ಲಿ ನೋಡಿರಿ. ಅದು ಕನ್ನಡದಲ್ಲಿ ಇದೆ, ಕನ್ನಡದಲ್ಲಿ ಇರಲಿ ಅದು. ಇನ್ ಎಕ್ಸಿಸ್ಟೆನ್ಸ್ at the set time, at the set time, and if yes, the RTC for the said survey number also. Call on. ಯಾವತ್ತಪ್ಪ?
29.
ಅಷ್ಟು ದೂರ ಇಲ್ಲ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ತರಿಸ್ಕೊಳ್ಳಿ.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಲಾರ್ಡ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಐ ವಿಲ್ ಬಿ ಓನ್ಲಿ ಆನ್ 21 and 22 ಮಾತ್ರ ಇರ್ತೀನಿ.
ಯಾವಾಗ ಕೇಳಿ, ಯಾವಾಗ ಇರ್ತೀರ ನೀವು?
ಲಾರ್ಡ್ ಆಫ್ಟರ್ 28th ಎನಿ ಡೇಟ್.
ಆಯ್ತು, 29. ಆಯ್ತು, ಕಾಲ್ ಆನ್ 29th.
Lord, Lakshmi kindly see, my lord, I have produced, Lord, along with the documents, the family tree of the entire family.
Release or let the government come.
I have produced the family tree also. I can establish and show, my lord, that none of the.
Sir, ಮಿಕ್ಕಿದ 7 ಎಕರೆ ಖರಾಬ್ ಲ್ಯಾಂಡ್ ಸರ್, ಅದು ಗವರ್ಮೆಂಟ್ ಖರಾಬ್.
ಇಲ್ಲ, ಖರಾಬ್ ಅಲ್ಲ ಅದು. In fact, that is the Hiduvali land. Land tribunal has granted occupancy rights. That was the subject matter of the honorable court, and 3 times it has gone. And now my lord is pending before the land tribunal even today.
Let the government come back.
And in fact, I have produced the order of the land tribunal, which clearly depicts the names of the persons shown in the final notification in the land order of the land tribunal.
Yes, sir.
50 HN Basuraju.
Madam, in the meanwhile, do you have this 50/50 scheme? I think they will be happy with it. 50/50.
That's already entire land has been given to beneficiary. Layouts have been formed. Industrial area has been done.
Okay.
50 Murgeshwi Charity. HN Basuraj.
Date में senior hand up.
At the request of respondent, call on date today. 2 weeks without it.
22nd. 51 Ashok Narayana Nayak.
I appear for the petition.
Lord, I appear for the respondent.
Ready both sides?
Lord, this is for my lord. Pursuant to the acquisition, my lord, the matter was referred to the civil court, and civil court passed the award, my lord, increasing 2 lakhs per acre.
But in the award, my lord, as per the 23(1)(a) benefit, from the 12% interest from the date of notification till till the passing of the award or taking of possession. My lord, in the decree, it has left out that, my lord, taking of possession. So based on that, that is calculation has to be done. For that, my lord, when they have filed an execution petition, we came to know that, my lord, there is a error in the award. Then we have filed a writ petition before this court, my lord, they stay the execution petition.
ಎಲ್ಲಿದೆ ಇದು ಡಿಗ್ರಿ ಎಲ್ಲಿದೆ?
Decree first ಇದೆ page number, may kindly annexure A, page number 23. Page number 23, my lord. That is the claimants are also entitled for additional amount equivalent to 12% annum on the enhanced market value from the date of oral notification till the date of general award as provided under section 23(1)(a). 23(1)(a) says till the general award or taking of possession, whichever earlier.
Did you got the ಇದು ಡಿಗ್ರಿ ಕರೆಕ್ಟ್ ಮಾಡಿಸ್ಕೊಂಡ್ರಾ?
ಇಲ್ಲ ಅದಕ್ಕೇನೆ we have filed an application and we have filed an writ petition before this court, my lord. This court directed to consider our application for correction. Now that came to be dismissed by the reference court. It is a statutory provision, my lord. It is only a court error.
Then you have to challenge it.
Yes, that's the reason we have challenged it, my lord, in the writ petition. That is the only ground.
No, that order of dismissal you need to challenge.
Dismissal alla ಅವರು rejection, rejected our IA.
No, where is it?
That is, my lord, page 38. We have not challenged any enhancement, but only correction of the decree so far as the.
ಮಾಡ್ಬೇಕಾಗತ್ತೆ sir.
ಅಲ್ಲ, previously what had happened, you know, the very award was challenged in an MFA. MFA was dismissed. Subsequently, my lord, when the execution was filed, they come up with an application, my lord, under section.
ನಾಡದ್ ನೋಡೋಣ.
Monday, my lord.
ಆಯ್ತು, ಮಂಡೇ ಡೇಟ್ ಕೊಡಿ.
19/8.
ಅದು ಮ್ಯಾಟರ್ಸ್ ಅರ್ಜೆಂಟ್. ಯಾವ ಡೇಟ್ ಬೇಕು ತಗೊಳ್ಳಿ ಸರ್.
ಟೂ ನಲ್ಲಿ 4:27 ಆಯ್ತು.
Take a date of your choice.
Only one request. If Krishna Malad allows me to look into that, I can cut down my argument.
ತೋರಿಸಿ ಅದು ಏನ್ ಬೇಕು ಅವ್ರ
ಅಷ್ಟೇ.
ಕೂತ್ಕೊಂಡು ತೋರಿಸಿ.
ಎಲ್ಲ ಎಗನೆಸ್ಟ್ ಇದ್ರೆ ನಾನು ಆರ್ಗ್ಯುಮೆಂಟೇ
ಅವ್ರ
ಮಾಡೋದು.
ಜೊತೆ ಕೂತ್ಕೊಂಡು ಇಲ್ಲ ತೋರಿಸಿ ಅಪ್ಪ.
5 ನಿಮಿಷ ಅಷ್ಟೇ.
He's a nice person.
I know that.
Sir, date ಯಾವಾಗ? Date.
Next Monday.
Sir, ಎಲ್ಲ take a date of your choice. Court officer will grant. Yes.
One by one ಕಾಲ್ ಮಾಡ್ತೀನಿ, 2 ನಿಮಿಷ.
What of sir?